Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not
You will
proven.
bring the jury.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy, do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy
They
there.
got the wrong guy, and the dog was biting him.
He roughened him up quite a bit. There's a lawsuit.
9 out of 10 judges prefer watching the Recovery Addict live stream in their courtroom.
The fireworks are not done.
Now we're getting commentary on the case. Dati mihi Anglican por his verbis Latino.
That's literally not true.
I didn't ask you to interrupt me.
Is that correct?
Oh, for Trump's sake.
Good morning. Welcome to the Court of Public Opinion. I am the Recovery Addict. Happy Monday to you. Hopefully your weekend was just epic. It was just wonderful. Everything good happened this weekend. If not, hopefully next weekend is that one for you. But in the meantime, Monday is calling, and we've got some stuff to do, and that stuff means we are following the Kouri Richins case. It's day 6 in the trial, and we'll bring you gavel-to-gavel coverage, audio and video, of everything the judge allows. With the, we had the slight exception on Friday with the judge ordering us to not show somebody that they allowed us to show briefly. And then he revoked that, so we had to scramble to get that taken down. If that did mess up your rewatch, I do apologize. I had to privatize the video immediately and download it, clip the video up, re-upload it. So it's out there. If you missed Friday, it's out there with the exception of that little piece the judge says can't watch the undercover agent as he testifies for obvious reasons. Or as we like to say, the formerly undercover agent as he testifies for obvious reasons. I did it fast. I'm so pleased. I have a PC. I run mostly Macs, and I have one PC that I got specifically for this purpose, because there's sometimes I have to edit a huge video file. I mean, we're talking like 60 gigabytes of video, or 72 in this case, gigabytes of video, and it just crunches it like it's breakfast. It is amazing. So that was good. Saved me hours and hours. Good morning, by the way. Good morning. We have a few things to get out of the way before we go to court. The feed is not up yet, but it will be up probably in about 10 minutes or so. And then once it does, we'll bring you everything that happens. And I'm trying to remember where we left off with all the drama of how Friday ended. I think there's a decision the judge wants this morning. Is that correct? Am I remembering that? Or is that what happened on Friday? Anyway, we'll get it sorted out. Evangeline Light. So close to 3 years of my life in this wonderful community. RA and mods are the best. Evangeline Light, thank you. And you are 34 months. That makes you an OG. Thank you very much. I get choked up, Evangeline Light. Thank you for that support. It means so much to us and our family and everybody. It's time to crack into the Deer Park water. Not a sponsor yet. Deer Park, please respond to my messages. I can't guarantee you will make any more money from me because I already buy all my water from Deer Park, but somebody else might. You never know. One fish, two fish, red fish, blue fish. Shout out to happy birthday, Dr. Seuss. One of my favorite authors still. You know what? Dr. Seuss, I might have told this story before we do the birthdays. I'm going to share just a little personal story because I can. Dr. Seuss is the reason I got an A in my senior year communications class, senior level communications class. And I feel bad about this. Not so bad that, I'm going to retake college or anything, but I wrote a paper. We were supposed to write a senior paper, and my teacher loved it. She absolutely loved it. It gave me an A. I'm like, wow, that's cool. Not sure I got an A. She's a pretty strict grader. Got an A, and I'm like, awesome. I went back to work at the college, and I ran to my teacher again, and she's like, I just have to tell you, I loved your paper so much. I'm like, I'm trying to remember what I wrote it about. And she's like, I've always liked Dr. Seuss and the way you compared the stories and you broke it down on the communication level and what was happening. I'm like, I didn't write about Dr. Seuss. That wasn't my paper. I wrote about like some song. I don't know who got a terrible grade in that class, but I am so sorry that the teacher thought you were me, and that I was you. I got the A. She graded on the curve. I'm sorry. I like somebody out there. I don't know who it is, but I'd already walked on the stage. I'd graduated. I had my diploma before I knew this had happened. I don't know how I could go back and turn back time. I'm pretty sure the other person graduated. It wasn't like a pass-fail type thing. But my communication teacher miscommunicated when it came to whose paper was whose, and I got the A. So thank you, Dr. Seuss, for that. I wish I could read the paper. It sounded amazing. Anyway, now where were we? I apologize. A little side note. I would have passed. I would have graduated anyway. Okay, my grades, I was probably like a 3.9, 3.95. Somewhere. I was like maybe 3.85 was my GPA. So I would have graduated anyway, but I feel bad that I graduated with somebody else's paper. All right. Posty 7, member for 38 months. OG, thank you very much. Appreciate your support, and you do have that red courthouse. Looks great. Also, Kelly Easton, or Kelly Easton, Tennessee. A member for 31 months. OG, love our community. Posty says, I got my diplomatic plates on my hoopty. You got those federal plates that say you can't ticket this vehicle. That's what being a federal employee gives you. Tammy Lee, member for 18 months. My first watch was Daryl Brooks closing. Tammy Lee, you are an OG. Let's see, anybody else? Regina Adams, member for 31 months. And what a great 31 months it has been. Regina, it would not be the same without you here. Thank you so much, OG. Let's see, anybody else? Jason, welcome. Mistrial about the jail call. Oh, right. Thank you, Jason. Yes, thank you for reminding me. That's what we're waiting for this morning. We're waiting for the judge to put on the record the communication, the little call, I guess the sidebar that we had where Miss Nestor asked for a mistrial because she elicited testimony from the witness that violated the you can't create your own mistrial. But Jason, thank you very much for that reminder. That will be spicy to start off the morning, or at least interesting to start off the morning, if not spicy. Camila Juliana, member for 17 months. My first gavel to gavel was Banfield, but I was here before there before. Makes you an OG. Let's see, anybody else? Birthday, get your name on the list. Yes, we're about to sing because we're about to go to court. Let's see where. Oh, I'm so far behind. I've got to talk faster. Chris Wallace, member for 32 months. OG, not oh no. OG, mistaken identity. Yes, I'm sorry. And you guys are all telling me mistrial. I'm just now catching up to it. Lena H, member for 29 months. Another OG. Wow, time sure does fly. Love my true crime channel. Makes work go by so much easier. I'm glad I can help. Let's see. Lindsay Bay, member for 24 months. Lindsay Bay, you just hit that big 24-month, 2-year mark. Says RA mods have managed to create a safe village to watch true crime. Really saved me. Thanks. I love it. I love that you're here for it. And it wouldn't be the same.
You look good.
Without you here. Emily Aaron's member for 23 months, almost 2 years. Yes, you get that new color courthouse that Lindsay Bay is showing off right here next month, Emily. And I can't wait for it, but you're already an OG. Thank you. We were at the jail call mistrial stuff. Yes, I'm excited about it. Thank you, Tony, for that reminder as well. CCG Shots, welcome to the gallery. New blue color courthouse. Looks great on you, by the way. Welcome. You're one of us now. You can never leave. Anybody else? Buffer chat on screen forever. And my mods were trying to tell me. They were trying to tell me. Let's do a quick recap really quickly because I'd like you guys to see that your messages did in fact make it. Let's start with Rocky Boo. Welcome to the gallery. Thank you very much, Rocky Boo, an OG. First thing this morning, Evangeline Light, member for 34 months. Thank you. Cindy, enjoy the moment. Came to the super chat. Shout out, happy birthday, Dr. Seuss. And then we got on a tangent because squirrel. Posty 7, member for 38 months. Thank you with the diplomatic plates on your hoopty. Kelly East, Tennessee, member for 31 months. Another OG. Tammy Lee's OG. First watch was Daryl Brooks. That was mine as well. Regina Adams, member for 31 months. What a great month it's been. OG. All these statuses are OG. Camilla Juliana, member for 17 months, but she's been here longer. OG status there as well. Chris Wallace, member for 32 months. OG. Speaking of OGs, Lena H., member for 29 months. Time does fly. Lindsay Bay, member for 24 months, showing off that fancy pink courthouse. Look, I think it's pink. I can't tell. Honestly, I can't tell. OG. Emily Aarons, member for 23 months, almost the 24. There, she's an OG. CCG Shots, we just said welcome very much. You got that second color, that light blue courthouse. In no time, it'll be changing colors for you, and you're always welcome here. Cody Height, member for 8 months. Can I use this to make RA even more behind? Why? Yes, you can, Cody. Yes, you can. All right. With that, now I have to dig up, because the mods have sent me birthday list somewhere, and I missed it. I guess they're still adding stuff to it. Red, please add Josh. Please add Cleverly Twisted. And there we go. Boom. Do we need a Josh added to this, or Red or Josh? I think it's Red or Josh. We're good. Josh has the birthdays for us. Before we do birthdays, though, Shelly Small giving out the birthday presents with 5 gifted memberships. Thank you. Now let's sing happy birthday before we go to court, because they're about to put up the live feed. So this is how the birthday celebration works. We sing happy birthday every morning. Anyone who start this. Hang on. Pause. Have to start Top Mark Media on air. If somebody can tell me if Top Mark is working properly, that would be great. And a thumbs up when the audio occurs. I'm hearing the judge talk. We need to sing very quickly. Everyone, wherever we are, stand up, take a breath, shoulder. Okay, they're teasing me. Everyone, wherever you are, stand up, take a breath, shoulders back, project your voice to the back of the room, blend your voice with a neighbor, and warm up with me, if you will. La 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 la. There we go. We're going to sing happy birthday to Cleverly Twisted, Little Barb, Sue McGill, Shelby Jean, Susan, and Theodore Giesel. There we go. Happy birthday to you. Happy birthday to you. Happy birthday, Cleverly Twisted, Little Barb, Sue McGill, Shelby Jean, Susan, and Theodore Giesel. Happy birthday to you. Woo! To everyone who's celebrating their birthday today, happy birthday. I realize there are a million places you could have been and a million people could have celebrated with, but you chose to be here with us. The privilege, the pleasure, the honor, the joy is ours, and hopefully we can turn that joy back to you. Make your day a little more special, or begin by helping yourself to free pancakes at Denny's, IHOP, Village Inn, Waffle House, McDonald's, Tammy Dunlap's House, Andy's Grill, Bob Evans, and Cracker Barrel. Woo! There we go. Oh my goodness. All right, we are set. We have a live feed going over on Top Mark Media if you want to see it clean with closed captioning. There's just about a 10-second or 15-second delay over there. Actually, I think it's about 30 to get the closed captioning in. But that has a clean feed, so it looks just like our feed here, but it looks more like, I don't know, say this. Which, if that's what you want, you can watch over there. We'd love it for you to do that. We have a couple mods over there you can chat with, and some others watchers as well. We provide that for some of our media partners who use that in their own broadcast or wrap-ups later on. So just a clean feed for our partners there. That does not mean this is a dirty stream. Right, Sloth Life. This is a very important distinction. Dr. Seuss, also known as Theodore Giesel, appreciates the birthday song. I appreciate the A. And my teacher, Colleen Packer, sorry, I just shout you out. Colleen Packer, loved your class. It was great. I loved the grade you gave me even more. I do feel a little bit bad. But it was one of those, we know in court, if you don't object in a timely manner, it's in the past. You just can't do anything. I think we've got a drum solo to finish this. Hang on. Ready to go? Beautiful. There we go. Now we're back to court.
2, check.
Oh, we're here. Check. Loud and clear. 9 by 9.
Check 1, 2, check.
That one's good as well. Yep.
Yeah.
Yep. 1, 2, 1, 2.
Check.
Test. It's working.
Happy birthday.
We tested
Check
this
1, 2.
Check. Hello. Can you hear me? Is this one on 2? Yeah. So far, everything's working. All right. Good morning, RA. How are you feeling about this so far? Probably my favorite court case of the year so far. Might be my favorite court case of the year. We got the snaps. We're testing all the mics in all the courtroom.
Squirrel finds a nut.
Somebody want to go back and count how many mics they have running? So far, we've had. I think the last snap was the judge's. Just reaching over the bar and snapping behind the mic instead of going up and sitting in his seat. That's always sketchy in case he walks out and he's like, "What are you doing in my chair?" But sounds like about 5 mics. 1, 2, 4 or 5 mics. Doing a great job on this courtroom. So, all right. Thank you for the thumbs up on top, Mark. We'll keep that running over there. And fingers crossed, no undercover officers testifying today. Prosecution better get on the ball. I believe they do. They on 2 fronts. We need to start getting some evidence from better witnesses than, I don't know, we liked Carmen, but we need a more trustworthy, reliable witness than Carmen and who was her dealer? Who was the dealer? I have to look at his name. Robbie. We need better stuff. And I know there is better stuff. We should start getting to it. So that needs to happen. Also, prosecution, be more snappy on the objections. Don't make the judge make the objections for you. First of all, it looks bad. It looks like the judge has a dog in the fight, and he doesn't. Don't put him in that position. And also, man, stand up for your witnesses a little bit. Just, yeah. All right.
Hush.
I'm seeking stronger stuff.
I'm trying to have court. Don't raise your voice.
Should be 6 mics, 1 on each table, 1 witness. Okay, we've got, yes, Cody Height. 1. They've got these, this is just like a little lectern podium mic type thing. They have 1 of these for each table. So Pros has 1 and defense has 1. They also have 1 for the judge. So that's 3. Then prosecution and defense each have a wireless that they're wearing. So that's 5. And then I think we have some additional ones because we know that we can hear the clerk when she reads. So she's mic'd. We know that we can hear the jury when they talk. So, you know, we've got a couple more, and they might be like ambient room mics that are doing that. But I think the clerk's on her own microphone. So. And those nice boom mics, those little gooseneck mics, they're only like $600 a piece. They're a little spendy. I'm excited. I get to use mine this month. I purchased it for a gig I'm doing just before my birthday, actually. And I've always run a wireless mic in that situation. I'm familiar with the gig and what they want me to do. I've done it several times. And I've not been happy with the mic. I mean, everyone else is like, it sounds great, but I know it could sound better. And so I'm bringing in another mic, and we're gonna do something really cool. I'll show you sometime. Angela's on the phone. Just 1 second.
To accept, press 1.
Angela, you know you're taking a risk. You're calling right before the court's supposed to start. What's on your mind?
This is witness Mike.
Oh, I know. And I know. I am watching you live. And guess what? I am all caught up. Thank you.
Yes. Wonderful. It's a good trial. It's a really good trial.
Yes, Louis. I do, Louis Cox. I do sleep. Don't worry.
I'll tell you when
yep.
you can.
It's going to be good today.
I have so many thoughts. Yeah. I have so many thoughts, and it's gonna take a while because it has. I have a theory where both Carmen and Robbie are right, and I'm not saying they didn't lie or did lie, depends on what you see. I'm just saying that there is some part that, like, there is a way where both are right, especially with that part that we get to see. Well, I didn't say it, but thank you to Gomez who did repeat what was said of that undercover agent, that how many oxys did contain the fentanyl in 2022. And there is a DEA report from 2022 that 6 out of 10 oxycodone tubs that were tested did contain fentanyl.
Found the street ones. We're talking oxy that's purchased on the street, right?
Yes.
The real ones were pure. The OxyContin you get from the pharmacy was, OxyContin, but or oxycodone, I forget.
Yes. And sure, we are to believe that, those pills were found in a baggie, not in a pill bottle. So are we to believe that, I'm not saying Robbie is lying, I'm just how believable so is it that he just got from the people that had the prescription?
Right.
That sounds a little sus.
Yeah.
If you know.
In the drug world where drugs are commonly cut and mixed and blended to turn extra profits, and corners are cut, and it's the market, right? It's what it is. Oh, we're getting a little bit of a hot mic. He seems to trust his source as like, no, my source would only give me the good stuff. That's what I asked for. I'm sure it was the good stuff. Yeah, right. It's like, you might think it was. You might have asked for the stuff that you got before, and it was the good stuff from the pharmacy, from somebody's prescription. Their plug was given the prescription. We might have to cut this short. We've got a hot mic that I want to hear because it's getting heated.
Okay, I'm not saying he's lying. I am just saying that I think that he's telling the truth because he believed that he got oxy, but he never tested it, and to see if it was laced with fentanyl or was pure fentanyl, because there is DEA reports that says 6 out of 10 oxys were laced and contained fentanyl.
And I believe we got basically that sort of testimony from the witness who shall not be seen, the one we had to cut. That was the gist of that testimony as well. So. All right, yes. Angela, I've got to hear these hot mics. I want to hear what's going on in court. Thank you for the call. I'm glad you're caught up. We'll talk again soon. See ya. Bye.
Yes, bye-bye.
All right, let's, I think it's just people in court. I'm not hearing, it wasn't court proceedings. Let's put it that way. All right, we just have, this court's supposed to start at 10:30 Eastern Time, 8:30 Mountain Time, which is where this court is operating out of, in the Park City region, Summit County, Utah, which is beautiful. Absolutely beautiful this time of year. Normally mountains covered in snow. I don't think there is snow right now, or at least not nearly as much as there normally is. Utah is actually quite concerned about that, worried that they're looking at a major drought this upcoming summer because the snowpack is just not what it should be. So hopefully they get some snow here before we're right towards the end of the winter, and they need a little bit more snow. So Selena is there today. That's awesome. Selena's been an amazing court watcher for us. John only goes on Fridays. I'm not sure if we have a Friday this week. I'm going to see if the court's going to be held on Friday or not. I don't know for sure right now. I've heard that it wasn't. If you're experiencing buffering, refresh. If the audio cuts out for some reason, refresh, and it should pop right back. I had the feeling that Robbie thinks he's smarter than anyone in the room. I don't believe Robbie one bit. He seemed very shady and coached by the defense and how the defense was being sweet to him as opposed to how they were to Carmen. I talk about Bruno, member for 9 months, says, hey, welcome. We talk about Bruno here. I think Robbie was a full-time drug dealer. Yes. I'm not sure if he still is or not, but it did seem a little sus in some of his testimony. All right, let's see. No way to know if Robbie was lying or not since we don't have his source. Yeah, I think Robbie knows exactly who his source was or who his sources were at that time. He might not be able to remember, I got that bag from this person, but he knew who he was buying from. And he's protecting them. I don't recall. I can't remember. He's buying from a lot of people. I don't know. Yeah, I think you do. Okay, let's get our counter ready. We are counting objections. And let's see. There we go. It looks a little bit off. Lined up right there. How's that? Is that straight enough for everybody? There we go. 84 objections so far. It's been a little bit spicy the last couple days. It sort of ramped up the objection counter. I think we're back to the police testimony. So as far as the people we're going to hear in court today, I think we're going to start getting into the technical side of things with the phone extractions. I can't wait. You guys can't see it, but I added another monitor to my setup today. It's right behind this, and it's turned sideways, so I can see it, but you can't see it. It's between this monitor and that monitor over there. But it lets me see what's happening on my recorder, on my HyperDeck, as far as the different bytes and how much space is used. So far, I'm using 0.7 terabytes, and I have 4 terabytes in there ready to go. So we've got plenty of space to record everything, which is important because that's how our pool feed's working for us this time. Let's see. Katrina Buddy says, Recovery Addict, do you think that the defense, when they first talked to Robbie, may give him the idea he could be held liable in a civil suit if he didn't recant? I don't think the defense did that, because every time the defense talks to Carmen or Robbie, their lawyer is there as well. So it's not just like we had a secret meeting with the defense. Prosecution would be there. Their lawyer would be there. It's possible that he had, a pretty frank discussion with his own lawyer saying, look, here's the lay of the land. Here's the situation you're in. If this is the case, this is a possibility. If that's the case, that's a possibility. So I'm sure he did that. Printer cam. I have to order a new nozzle. I broke the nozzle. I don't know what I did. I think I was manually controlling the print head, just playing with it, and I drove it into it chipped the nozzle. So now I need to replace the nozzle on my 3D printer. And my son is like waiting anxiously because he has like a bajillion things he wants to print. Jody has admitted to being an addict. Welcome. We call that admitting to being an addict. That's just clicking the subscribe button, Jody. Welcome. Good to have you here. You're one of us now. You can never leave. In a couple minutes, I think it's 5-minute delay before you get to chat. And then you'll be in here with the gang and you can talk and we can say hi and everything. Let's see. When does court start? Right now. The judge just walked in. So we're just waiting for the mics to go hot. He's going to get situated, make sure everybody's here, and then he's going to call for appearances, and we'll get the audio during that. And right now, here we go. Gigi Sharebear member for 29 months. Woohoo! Thank you very much, Gigi. OG. Here's Judge Smooth Voice. Yes, if you haven't heard this judge yet, prepare to swoon. He has the pipes. It's unbelievable. Yeah, being quiet so we can listen for it, but he's not talking. My husband just bought a 3D printer like yours. I love it. Supermom, we've had so much fun with them. And I've printed useful things. I printed a part that fixed our old door. We've got a doorknob that, our house was built in 1915. And the door, a big mortise-style lock that's odd-shaped and everything, had a part inside that was broken, and I was able to 3D print a fix for that. It's pretty fun. All right, here we go. I'm getting the inside scoop that we're about to begin here. So it's not just the judge's voice, it's his wonderful demeanor, gentle firmness, his courtesy, and his knowledge of the law. He's great. He was nominated by Governor Mike Leavitt, I believe, back in the day. I think Leavitt was governor in Utah before Governor Herbert, who was right before the guy, whoever they had.
231-500-139, State of Utah versus Kouri Richins. Counsel for the state and the defense are present. Ms. Richins is present as well. Mr. Burmester, anything on the record before we invite the jury in?
Your Honor, the state's first witness is Dr. Eric Christensen. I was notified by counsel this morning that they intend to move to exclude or suppress his testimony, and I will let them make whatever motion they want to make.
We got a fight first thing this morning.
Counsel, tell me more.
Judge, it is simply that we have not been able to consult with Dr. Christensen. We have reached out to him to...
Say that again from the...
I'm sorry. We have not been able to consult with Mr. Christensen or Dr. Christensen. We've reached out numerous times, got on the phone with him once. He was unavailable, asked if we could get some time with him. That was about, I don't know, 4 or 5 weeks ago. And haven't heard anything. Last week we informed the state that we haven't been able to get in touch with him, asked the state to have him reach out to us. He has not reached out to us, so just based on just the rule, and he should be available to cooperatively consult with us. He did not.
I appreciate that. He's here now.
I understand. I think it has to be
Mr. Burmester, if we flip the order of events, can we allow Dr. Christensen to consult with defense counsel since he's physically present, and then we can use the time for a different witness?
I have no objection to that. Indeed, I asked counsel at time 15 minutes ago if that was enough time. That was not. So,
who else do you have on deck?
I don't know people.
Your Honor, let me see. I don't know if we have anybody in until 9, but let me see.
Okay.
Your Honor, we have an objection to another witness that the state intends to call today.
Oh, wow. Okay, but let's stay focused on this one for the moment. Mr. Ramos, make a record for me. If I change the order of witnesses and just order Dr. Christensen to consult with you since he's physically present, anything further on that?
just assuming that we can take that break. I'm not sure who's next and whether it's my witness or not.
Understood. Okay.
Absent that, I will make do. Obviously, I didn't want to do that rushed before we got here. So if we can have an hour or whatever we need,
right,
that'd be great.
Let's figure out what the order of witnesses is going to be.
May I just have the benefit of the record for like 1 minute? So I spoke to Mr. Christensen, or Dr. Christensen this morning. He says that he received a call several months ago from Mr. Bertram saying, hey, we need to set up a time. He never heard from them again. He received a call warning that he would be getting an email maybe a month ago or so. No, a subpoena. He subsequently received it by email. And then he received a call with no message this over the weekend, and that's where we are.
We are where we are. We'll work it out. Mr. Bullardroth, talk to me about the other witnesses that are proposed for today.
Your Honor, I think that other witness is going to draw a motion.
Oh, who is it?
His name is Todd Davis. I guess I don't know.
Detective
Todd Davis. Your Honor, Mr. Davis was not on the state's witness list. They added him on Thursday, which I believe is in violation of Rule 16, and I would point the court to State v. Draper at 378 P. 3rd, 1261. In that case, the state had the manager of the store that was the victim of the theft on the witness list, and then later, during trial, added the assistant manager, and the Court of Appeals found it was an abuse of discretion for the trial court to allow that witness to testify without sufficient notice under Rule 16.
What was the amount of notice in that case?
I don't think it said exactly if it was but it was during trial. It said it was during trial that they announced that she was going to testify. Okay. And I don't recall if it was the same day, but I mean, the state's had months and months. We've had 8 amended witness lists, and I think to continue to add witnesses during trial is not sufficient under the rule.
Help me out, Mr. Bloodworth. What is is it Detective Davis?
It's Lieutenant Detective.
Okay.
Lieutenant Davis, right?
Sure.
He, Your Honor, the state is calling him to authenticate the May 4th, 2023 interview video of Robert Crozier. In rebuttal to Robert Crozier's testimony, all he's going to do is authenticate the video.
Is that
That's the first I've heard that that's all he's going to do, but
is that issue in dispute? I mean, you reserve your arguments about whether there are other bases to bar the admission of that video,
which I believe there are.
but authenticity probably isn't one of them. Do we really need to call a witness, or can we just stipulate that it's authentic and then the parties will reserve their arguments regarding admissibility?
I would agree it's authentic, but yes, we would have other objections.
So can we just have a clear stipulation on the record that the May 4, 2023 video recording of law enforcement's interview with Robert Crozier is authentic?
Yes.
Okay.
Your Honor, may I add to that the transcript of the video as well?
Is it a certified transcript?
It is certified.
I think that follows from the rule regarding certified transcripts. Ms. Lewis, do you agree?
I agree.
Okay. So it sounds like we don't need that guy.
Todd's out. Todd Davis is gone.
Correct, Your Honor. We may as well use this time to litigate, I guess, what other objections to admissibility the defense has on the video.
Forgive me, the state is offering the video under which rule or exception?
Your Honor, 801, it'll be D1A, and perhaps some of it will be D1B. The defense's cross-examination of Mr. Crozier elicited testimony that, and the state's direct examination elicited testimony from Mr. Crozier that was inconsistent with his testimony in the video. The defense's cross-examination elicited testimony that he was kind of out of it because of withdrawal and pressure to say certain things. And the video, rebuts that testimony. The video itself is, I think, 13 minutes long, and from the state's view, the entire 13 minutes, pieces of those 13 minutes are direct impeachment, but the entire 13 minutes goes to whether or not he was high and out of it, and whether or not he was pressured into saying certain things. Those pieces of evidence are throughout the entire 13 minutes.
The impeachment pieces, or more specifically, the D1A inconsistent pieces, correct, those would be, I think, fairly perceived off a cold transcript. The second piece, I'm not sure I or defense or you or the jury would be able to evaluate whether he was in a bad way from the transcript. Is the state seeking to admit both, or publish the video and admit the transcript? What's the scope here?
Your Honor, publish both. We have the transcript running real time beneath the video.
Okay.
So that the jury can watch, listen, and read all at once.
All right. Ms. Lewis, do you have the video with the transcript?
I don't have them together where it
okay,
shows it under. No, I have them separately.
Right. Sitting here today, are you prepared to make a record regarding this, or do you need a moment to go through the pieces of, or to make argument regarding certain pieces of the transcript versus other pieces?
I think I would need a moment. I would like to see the video with the transcript run under it, and then, yes, I would need a moment. I would need some time to look at that.
Okay. We'll need to play this out a little bit. The state makes a facially, if not valid, at least thought-provoking argument under D1A.
I'll read
801 D1A that the video and the transcript related to it are categorically not hearsay. But having not seen the whole 13-minute video or read the whole transcript, and without the defense having the same opportunity, I can't make a ruling sitting here at the moment. So
we need to take a break.
Can we provide the video with the running transcript to the defense?
We can, Your Honor. I believe we placed it in box yesterday, but we can, if they want to, perhaps we can go into a conference room here and we can just play it off of one of our machines.
Sure. I mean, I would also understand if the defense said, hey, we just need an evening with it to go through it, collect our thoughts, have you make a ruling. Ms. Lewis, what's your request?
Depends on what is happening here next. I may be able to watch it now. I don't know where we're headed.
Let's watch it now.
That's the thing, Your Honor. Those were our first two. That was our...
It's our day.
Batter in the box and our on-deck batter.
Okay.
So we are scrambling to get our in-the-hole batter here.
No, that's fine. These things happen. We're going to let Mr. Ramos continue to consult with Dr. Christensen. Ms. Lewis, Ms. Nestor, if you would have a conversation with the state about the video with the running transcript, let me know where we end up.
All right. Thank you.
Okay. Before
There's
we
Selena.
take a break for that, Mr. Bloodworth, anything else on the record?
No, Your Honor. Thank you.
Ms. Lewis?
No, Your Honor.
All right. Let me know when you're ready for me. Thank you.
I like
Court will be in recess.
Selena's always first to stand on the recess. There she is. Boom. So, quick recap. We're going to have a recess. This may be 15 minutes or so if they decide to watch the video right now. The judge has said he's inclined to let them have it for the evening, but we're quickly running out of witnesses to have this morning. So this morning starts a little bit spicy, right? We've got defense who's made 2 objections to 2 witnesses. The first is the expert the state has on deck. This is someone that's on their witness list. I don't remember his name off the top of my head, but they say we object because we have not been able to confer with him. We have the right to be able to talk to him and say, what are you going to say? What's your opinion? Why are you here? What are we going to hear from you on the stand? So we can prep our questions and our experts to counter that. That is one of the rules that Dr. Christensen, thank you for the name. So he is here now, and Mr. Ramos, okay, the guy who did a terrible job on his first cross-examination, just came way over the top, is going to be questioning him. So he's out there right now meeting with Dr. Christensen. At the same time, their next witness up was going to be Todd Davis, who is going to authenticate a video that is the video of Robbie initially when he made his initial statements to the police. Now, the couple of rules were cited here, specifically Utah State Court Rule 801, and it was D1A, 801 D1A that was cited. This article is exclusions from hearsay, right? A hearsay is any out-of-court statement. If it happened outside of the courtroom, it's hearsay and it can't come in unless it qualifies under one of the many exceptions. And this says, D1A says, a declarant witness's prior statement, it's something he said to the police before, the declarant testifies and is subject to cross-examination about a prior statement, and the statement, D1A, is inconsistent with the declarant's testimony, or the declarant denies having made the statement or has forgotten, and then it says, or is inconsistent with the declarant's testimony is offered to rebut or express or implied charge that the declarant recanted, fabricated it, or acted from a recent improper influence or motive so testifying. So it seems like it fits perfectly. This video fits perfectly, but the judge looking at it says it's a 13-minute video. And a lot of hearsay can happen in 13 minutes, and I don't know if all 13 minutes fits into that box. It might be that there are only certain parts that fit in. The state has divided up, it has to chop it up into pieces instead of just playing everything, including all the hearsay that comes from the officers and the hearsay that So they're going to find it out. Probably watch it right now. I'm thinking they're probably going to watch it right now. I don't know where we're going to go if we don't have that. Can I increase my mic volume? I can. I can also talk right into it, which helps. Thanks, Lisa. I will do that. Let's see. Check 1, 2. Check 1, 2. Check 1. How hot do you want it? I mean, you could do ASMR court today. All right. Is that better? Okay, just kidding. I'm just kidding. I'm not into that. The issue in the videos may be Robbie's state, and if he impeaches his in-court statements, right? I think it will. I think the state feels very confident about the evidence they're going to present with the video, if they're able to. as opposed to the evidence they presented with Robbie, which was terrible, and ended with the defense telling Robbie, listen, it ended with the defense telling Robbie, who was the state's witness, to look at the jury and tell them, look at them in the eye and tell them that he was telling the truth, and he did. That is a flipped witness. That is the state calling somebody who helped the defense. But this part could flip that back. All right. Let's see. Can you finish telling us what the judge was nominated for? He was in Utah. Judges are nominated or appointed to the bench, and then they run for retainment. So you don't vote a judge in initially. First, you have to, like the governor puts their name forward, and they're approved by the legislature. And so that's how he got his seat initially. And then I don't know if it's 4 or 6 years, he appears on the ballot. His name appears on the ballot under the question, should Judge Michael Krasnick be retained? Meaning, should we keep him on as a judge? And it's a yes/no question. And it's not a political office thing. It's not like should Democrat judge be retained or Republican judge be retained. It's not like that. They're not partisan seats, but they are up for a retainment vote. And the funny thing is they never campaign. You never see a signs like "Keep this judge, he's the best." They never do that. It's all they just sort of let it ride. Anyway, when he was first appointed, lots of good things were said about him. I think he was the counsel for the town of Alta, which is a ski resort town up there, in the mountains. I'm not sure if it's in Summit County or Wasatch County, but he's a good dude. All right, let's see. You had to call Robbie. It would look shady if they didn't. They did, but it was a bad one. So bad. I'd love to see Robbie impeached. It seems a little funny that the state couldn't really call the witness and impeach their own witness. That looks bad. But they called the witness, and then he testified for the defense differently than what he wanted, and now they're impeaching that testimony that the defense elicited, which they're still impeaching their own witness, which is still funny. Gailey May, member for 34 months, says, "Happy Monday. You can do this. I believe in you." Thank you, Gailey May. OG, 34 months. That's awesome. All right. I call my city victim advocate for advice on which judges to keep here in Utah County. She knows them well. Generally, the judges, and sadly, unfortunately, all politicians as well, typically they get retained unless they do something somebody doesn't like, or unless there's like a unicorn new contender on the scene who just blows up in the media and it's mostly name recognition, sadly. Otherwise, it's like, I don't know that guy. Sure, he must be doing a good job. He's in there already. Let's keep him. So, let's see. Although I think there's a judge in Utah right now. And I'm sorry, this gets a little close to politics, but I think the Utah legislature right now is passing a resolution condemning a judge for comments he made during an SA trial that were just terrible. They were terrible. People have been calling for him to resign and everything. And now the legislature, they can't really remove him, but they're basically writing his name on the chalkboard and putting 3 checks next to it. They don't like him much at all. That's going to happen probably before Friday. So the rare move for the legislature to weigh in on a judge like that. All right. Where did we find out Robbie's lawyer refused to go in the courtroom? That was from our court watchers themselves. They observed it when the camera and the mics were off. Robbie's lawyer refused to participate, was standing outside in the hall, wouldn't come in. And the judge basically said, well, you either come in here or I've got another room for you with a view through bars. Those are your choices. And she came in. But apparently not happy with what was going on in the court. I'm not sure the reason why. Let's see. What software do you use to create your own 3D print designs? My son uses Tinkercad, and he does most of the programming for me. It's a very simple CAD program that lets you export in a 3D format that you can print. Why wouldn't the lawyer go into the room? It was probably a protest because the state was forcing him to testify with the plea deal. Okay, because you can't plead the fifth when you have a plea deal, right? It takes that away. We saw that in the trial in Georgia, the Young Thug trial. The state offers a plea deal, which takes away the risk. I plead the fifth. If I testify anything, it can be held against me. Well, now it can't. Now you can't plead the fifth. Now you have to talk. And then when he did talk, it was a mess. So I don't know what the specific reason the lawyer objected to. I wish we got to hear that, but we did not. We're only 6 days into the trial. Hopefully the prosecution has more to offer. Denisha, I know they do. They've teased it in the open, which they didn't go into everything, but wait till we get to the Google searches. Wait till we get to the text messages. Wait till we get to the phone locations and the timestamps and who was lied to who and when and why. They have a lot more. Happy Monday, Aurelia Julia. Good to have you here. Probably because the defense was going to flip the witness and the lawyer wasn't happy about it. Squirrel question, 3D printer question. Does it take forever to create what you're trying to make on the computer? I have a circuit. The design part takes forever. D-Nice. Generally, the higher quality the graphics card, the easier. Well, you want a good CPU graphics. A good computer will process those things faster. I don't know how else to say that. Graphics card, the RAM, the memory, and the processor are the three big things. Usually the hard drive itself isn't the problem unless your disk is full. But if those are decent, it should be able to process everything pretty quickly. They still have to put the fentanyl in her hand, and so far they haven't. Gabby for Justice, I'm not sure if they will be able to, with the exception of this video that they're going to play. It's possible that this video says that he sold her fentanyl. There's a lot more coming in for sure. Wish I could get a cleaner shot of the tab on the judge's tea to work out what brand it is. He does seem to enjoy a little cup of tea in the morning in his Park City High School baseball team mug. Defense opening, I recall Miss Lewis stating they would have a witness that would testify that they did not sell fentanyl to Carmen and Kouri. Am I recalling that correctly? Yes. And I think that witness was Robbie. I think that's who she was talking about. Let's see. All right. Any more questions? What was the purpose of showing the state's behavior towards the one female witness? What was the purpose of showing? Are you talking about the defense playing video clips of the state interrogating Carmen? That part? I would say that just it's terrible optics for the state. The prosecutors, typically, we like to think that in the justice system, the pursuit is for justice, right? We're looking for the truth. We're investigating to find out what really happened. And in those video clips, it comes across as, this is the outcome we'd like. Now give us what we want so we can get there. It sounds very shady. It sounds like it was done backwards. It sounds like we were starting at the tail end instead of, where the evidence led. So I think she's talking about Anna with the warrant and the dog pull. That was additional. That was just that was a strong arm tactic saying you've got people in here testifying that you've basically said, if you don't do what we want you to do, we will make your life miserable. We'll take your dog. We'll put your dog to sleep. It was a vicious dog. We had to put him down. We're any issue, any traffic court issue. If you got an outstanding ticket for a parking something up in Park City one time, we're gonna drag you to jail for that. They were saying, we want this. I don't care if you don't, but we're gonna get it, and we're gonna get it one way or another. So the state looks bad. That one detective particularly. Didn't the state call Robbie to impeach him deliberately? Their witness order suggests so, and Robbie's affidavit was created by the defense and handed to the state. The state likes the affidavit. I think they admitted it. The state admitted it but didn't publish it, and if I remember correctly. And the defense went through it and published it, and then the state went through it and republished it. I think that's the order it went in. The affidavit says I sold him fentanyl. Or, well, the latest one says I didn't. But it says OxyContin when it should say oxycodone a bunch of times. We still have the walk the dog letter to come. Oh, that's going to be an amazing day, Jan. That's going to be absolutely wonderful. Jen says, random question, if our birthdays fall on a weekend, do we get a birthday song? Yes, we just sing to you either on Friday or Monday, whichever you'd prefer. Add to one or the other. They have to get it into her hands to get it from her to Eric. In my opinion, she's guilty, but according to the law, the prosecution isn't there. The entire walk the dog layer isn't coming in. That's my recollection as well, Little White, but I believe parts of it are. Robbie couldn't prove the pills were not laced with fentanyl. He didn't test it. As a matter of fact, one of his Insightful Gamer Guy, one of the things that Robbie said on the stand close to the end of his testimony was basically that at the time he acknowledged that there were Roxy 30s that had fent in them, and that he bought his Roxy 30s from a plug that the plug told him it was from a script. I mean, it came from somebody's prescription medicine and not from some street pill maker. But there's no way for him to know that, other than saying, "Oh, they looked like the other ones. They were the same color." I would have noticed a different color. I'm not sure you would have, honestly. Let's see. We still have Kouri's very problematic text messages and her Google searches. What about her friend? Why would all this... You guys have a million great questions here. I'm trying to read them all. What about her friend that went with her? Can they call Nick back up Carmen? Nick was the driver that got paid $300 on his drive, right? And there was the other friend who got high on her drive, who owned the car but let Carmen drive on the way back. I don't know. I guess they could potentially call them, but there's just a lot of shady people. I think it's better for the state to just rely on the evidence they do have. Those pictures from Carmen and her friend taking selfies in the car. With the right timeline, the bank statement with the check that was deposited or cashed at the bank with the date on that, I think it was the March 9th date with the March 6th check. Those things, they frame that a lot better. They put it together and make it make sense a lot better than calling somebody, another. Sadly, for lack of better words, a druggie off the street to try to remember what happened 4 years ago when they were actively using. That's tougher testimony to just convince the jury with. Let's see. Kim R says, I got my massage lady friend Jenna to sub. My goodness, Kim, thank you. That is awesome. I saw my massage lady over the weekend, and I was like, she was pushing her stroller with her kid in it. I'm like, how soon is too soon to get a massage? Because if you can't tell, my back is just like tweaked. I'm like in some kind of contorted position so it doesn't pinch a nerve. I need to go there. But I have another friend recommended another massage business that might be able to help me out. They're in my town, so. Why would all this stuff... Oh, let me back up. Laura says, if you don't believe the fentanyl is in Kouri's hands, I guess you believe Robbie and Carmen that they didn't sell it to her? Well, if you don't believe that Kouri was the source of the fentanyl, at this point, I would assume that you would have to believe that Eric was buying drugs himself. And I don't think we have any evidence yet to support that. I don't think that there's anything that's come in aside from Kouri's statements, okay, which weigh them for what they're worth, considering where they're coming from. I don't think you could get to the fact that, everything we know about Eric was that he was possibly a social drinker. That came from his family, but they say there was no drugs involved at all. He took testosterone shots. Let's see. That was a missed prosecutor opportunity, says Nicole at Goodman Law Firm. The letter was not threats. It was, you haven't reached out to us, and you better show up for the trial per the subpoena, or we have to arrest you and impound your dog. Yeah. State needs this video to impeach Robbie and nullify his immunity. I don't think they're going to get to nullify his immunity. I don't think that will happen. First of all, I don't think the state is chasing Robbie, as Robbie was a middleman. I'm sure he was the king of his castle, but it was a small castle. He's not a cartel kingpin. He's not the big dog in a circle. He bought from a couple of people and he sold to a couple of people, and he kept his circle small. So I don't think the state is going to do much. I don't think they do anything. I don't think they prosecute him. Josh Ritter from Courtroom Confidential said they don't need to put it in our hands. They can base this entire case on circumstantial evidence. We have seen murder trials before where we're missing that key moment, the knife in the hand, the gun in the hand. We're missing that. We don't have the evidence. We might be missing the weapon. Sometimes we're missing the body. We've seen convictions with a no body case. This, we have the body. So I imagine, just with the evidence that is provided, I was talking to Ian and Kurt the other day. I think this would definitely pass a judgment of acquittal right now on the elements that have been presented. Right, the state hasn't presented all their evidence, but on the stuff they have, I believe those elements would pass the judgment of acquittal motion because evidence sufficient for a jury to convict has been presented in the light most favorable to the state. So I would say it's possible to get there. It just might be a stretch. If they use this video to impeach Robbie, can they take back his immunity agreement? We talked about this a little bit. The immunity agreements, once they're in place, as long as the witness goes to court and answers the questions, it is really difficult to claw it back. First of all, you don't want to. It looks bad. It weakens the prosecutor's office and every future deal they might ever want to make. You don't want to be the one that's like, we can't trust you. You sign up to a deal and then you do everything you can to break it. You don't want that. You want to be able to say, if I say we're not going to prosecute you, if you testify, we're not going to prosecute. And you want that to stand. So I don't think they will. I don't think he did enough to breach his agreement, because the difficulty in proving perjury is, that's pretty high. I don't think they can do that. I don't think they will. That's so Jessica says, guys, I got married this weekend. Jessica, that's exciting. Congratulations. Wonderful. And enjoy the experience. Marriage is a great institution. I highly recommend it. Finding the right one is key. So it looks like you have. Katrina Buddy says, a lawyer said that he thinks there's grounds to revoke it here. It would be interesting. I'd be fascinated to follow that if they do revoke Robbie's agreement. And if they do, it would probably not be on his, I'd have to see the timing of the deal. Did his last affidavit come after his agreement? Because if they can prove that he lied in his last affidavit, that would be grounds, I think. But if he issued all the affidavits and then they made him the deal, I don't think they're going to go back and say, well, you had these two conflicting affidavits and then you testified according to one of them, which means you lied. That means you committed perjury. I don't think they're going to go there. Robbie did his time without a deal, but he's avoiding prosecution. He has a deal right now. Let's see. Telling the truth is required, right? But not remembering or recalling the truth a certain way. I don't know. It's a funny little gray area. Eric isn't a druggie. He had a bottle of pills from 2016 that wasn't empty. Yeah, the bottle of pills was said no refills before this date in 2016. I think the drugs expired in 2020, so they could have been expired drugs, but they were prescribed to him, at least if that's what was inside it. Lindsay Lou says, as a divorcee, I second RA. Finding the right one is key. Sherry says, RA, what brand of pickles do you like? I used to love the Walmart brand, which was Sam's Choice, spicy maple bourbon pickles, which are, it's like a sandwich pickle, but it's got a little spice to it, a little kick. They discontinued them. Now, I know they released a new
in front of the Walmart,
a new brand of pickle jar that's like half the size and the same price. So basically doubled the price. And some places you can find the spicy maple bourbon pickles, but they're not sold in my area. I haven't found them yet. I still have 2 jars left, thanks to some generous people who found them and shipped them to me. Let's see. Shelley Small says, I was my husband's 6th wife, and of course, the best one. All right. Kiki's Garden member for 32 months says, time flies when you're having fun. Send good vibes my way. I've got some interviews this week. Kiki's Garden, good luck. Knock him dead in the interview. I mean, not literally, but, more figuratively. Hope they go well for you. Let's see. There's zero evidence Eric was abusing any drug. The ME testified he had no history of illicit drug use or prescription drug misuse. Some of you guys are funny. We are waiting right now for those that jumped in and wonder why we're staring at the seal and why court has not begun. This morning started with a little bit of a bang. The prosecution was going to call their next witness, but the defense objected to their expert. The defense also objected to their backup witness, who was Todd Davis. Todd Davis was the detective who interviewed Robbie. They were only going to call Todd to authenticate the recording, the video and audio recording of Robbie's interview ends the transcript. The state and the defense, with the judge acting as mediator in between, stipulated to the truthfulness or the factual basis of those existing and being accurate. So now Todd doesn't need to be called to do that. So the second witness is out. The state is still talking to the first witness. Mr. Ramos is in another room conferring with him to try to figure out what they're going to talk about. They probably will still object when they come back after talking. We'll see how that works, because they don't want this guy to come in. But we're gonna hear how that goes. That might be our first witness. If the conversation with Mr. Ramos and Dr. Christensen goes longer, we might start with the video if the state and the defense can get on the same page as to whether or not it's admissible, or if all of it is an exception to hearsay under Rule 801 D1A of Utah, the exclusions to hearsay rule. So we're just holding in a holding pattern, waiting for that decision, as there are 2 conference rooms being used right now between the 2 parties, and hopefully we can get rolling here in just a minute. The jury is present and just waiting in the jury room, wondering what's going on. Of course, they're not supposed to speculate. So we'll answer whatever questions we can in the meantime. Let's see. Allison Lawler, hi from across the pond. Hello. It's been a hot minute since I've been in England, so hope you're doing okay. If you have a Kroger near you, they sell spicy maple bourbon pickles. Kroger and Smith's, the two, they're like synonymous with each other. I don't have any in my state that I'm aware of. If they do, they might be like 5 or 6 hours away. No Kroger's here. I'm on the East Coast. Ivan, I missed a call from you over the weekend, and I went to call you back, and someone else called me, and then I forgot about everything, so I apologize, my friend. Hope you're doing well. Going to be 40 degrees today, T-shirt weather. Why not go with a tank top? 40. Catch some rays at the same time. Let's see, but you still have to prove she did it without his knowledge for this trial. So far, I haven't seen the evidence that he didn't pop them himself. We're gonna get to that. We're gonna get to that, and I think some of Kouri's searches will get to that, and some of the walk the dog letter will get to that as well. I think there's plenty of evidence that will point the finger of blame at Kouri Richins here. Kouri admitted to police of giving Eric the drink. If Eric, in my opinion, says Crafty Chris, if Eric was a user of the THC or something would have shown up in his toxicology report. It didn't. Let's see. Told you they do, and I may or may not know someone that is about to supply you with one. Oh, that'd be awesome. Let's see. All this is reasonable doubt in my humble opinion so far, says the truth is out there. I will tell you the truth is out there. In my humble opinion, if I was on the jury right now and had to vote right now, it would be not guilty. The state has not proven this yet beyond a reasonable doubt. We have some suspicious circumstances, and that's basically it. I know that Kouri bought drugs. I believe that Kouri bought drugs from Carmen through Robbie. I think that happened, but I don't think the state's proven everything yet. That's why we have 4 more weeks to go. Is it possible the boyfriend will flip on her? Denisha, refresh my recollection. Are you talking about Kouri's boyfriend flipping to become a state's witness? I don't know where he's at. I mean, as far as on testimony, I doubt that Kouri. Well, we have seen a couple texts. I don't think he would flip unless he was like considered a co-conspirator by the state. There had to be some risk to him that if the truth comes out, you too can be prosecuted and held just as liable for everything. That would incite somebody to flip. But I don't think, barring that existing, I don't think he would. Ivan Victor's going to start smuggling pickles for me. Sweet. Get me the good ones. Just a little squeak coming through court. Like a door needs some WD-40. All right. I don't understand. Oh, sorry. I don't understand why the defense is going down the route of Mexico, given the walk the dog letter states this is how they plan to deceive the jury. Cruffy's legacy. The state didn't preface the walk the dog letter for us very well in the opening statement, so I don't know how they're going to work it in, but they have a lot of evidence that looks really bad for Kouri, and I think they do have a plan. One thing I do know is the prosecution, they're not brand new. They're not wet behind the ears, first time in court. All the bright lights are dazzling them. They don't know what to do. These are experienced prosecutors, and I think they have a pretty solid plan. This is not the greatest moment in their plan. This is the part that they have to trudge through, and they've got some witnesses that just don't look good and some stuff that doesn't look good for the state. But I believe they have a solid case, and we'll get to that. So I think that will change, and it's going to get spicy the closer we get. Did we hear how much time there was in between buying the pills? I think Carmen tried to make that timeline and told us that the early February was the first buy. The state tried really hard to correct her and say, are you sure it wasn't in late January? And she's stuck with the early February on her testimony. But basically a couple buys in February and one of the buys after Eric's death from Robbie. But let's see. Beautiful day in Scotland today, 9 degrees. I'm guessing that's Celsius. Sunny and feeling like spring. Hooray! That sounds beautiful. Go out and watch the haggis roam the hills. That would be fun. Kouri's defense opening. Kouri never changed her story once. This is true. This is something that the defense has raised a couple times, but meanwhile, her story keeps changing according to all the witnesses. In talking with the police, she's been remarkably consistent. We'll see if through all the evidence if that stays the case. The trial just started. Have faith, peeps. Have faith, says Loves Pink. I still haven't gotten there yet, though. The jury may not have either, so we'll see. I don't know anything other than what's been in the trial. That's a great way to look at it, Cricket S. So watching it as a jury might. And just keep the parts that were in the media that might not come into trial out of your mind. How are they going to get the walk the dog letter in without saying it was confiscated from a jail cell when the jury has always been told not to think that she was ever in custody? Oh, that's a great question. It's a great question. I don't know. I wonder that myself, maybe possibly in a rebuttal. All right. Thank you for those who clicked the subscribe button. We view all as friends. If you wait for just the 5 minutes, you'll be able to join us in chat. All we ask is that you're respectful in chat. Don't call people names. We don't want to fight here, but we'd love to hear your opinion and discuss it. We're not all on the same side here. I don't think that helps anybody to be in a little echo chamber and all chant the same words together. I like to learn from you, and hopefully occasionally you might learn a thing or two from me. So welcome. Please join us here. We're all friends at the end of the day, even if we disagree. Why would she buy after Eric's death? Well, what if she was the one using? Let's see. Roaming haggis in the spring is the best sight. Yes. They're beautiful, beautiful things. So cute and cuddly. The acoustics in the echo chamber is horrendous. It is. All right, we expect that hopefully within about 15 minutes, well, I think about 15 minutes, 20 minutes has passed. I could go back and check. But we expect to have at least one of the two witnesses or well, in this case, the video, ready to be presented to the jury. So we think that the jury will be out and be hearing testimony or viewing evidence here shortly. Either it'll be the Dr. Christensen or we'll be watching a 13-minute video from court. One thing the defense has pointed out before on these transcripts where we have a video of a jail conversation or in custody conversation, police interview, that sort of thing, the transcript has not always been perfect. And I'm talking very minor imperfections, but those are things that they're very good at noticing and they jump on, and it causes a problem because now you have to make a new video or correct the video or somehow acknowledge the error in the video to the jury. And in some cases, it might keep the evidence out altogether because it's not accurate. So that might be the case as well. Request for commands to work during this break. Are they not working? Let me check. I did, I know what I did. I broke everything is what I did. I reformatted a drive.
It's not your turn to talk. I'll tell you when you can talk.
Oh, no. Let's see. Go to network.
In front of the Walmart.
Holy cow. I've gone and broke it, and I don't know how. I can't fix it right now, so sounds are not working. Whatever I did this morning broke a lot of the commands. A couple work.
500139.
We're back. We're back.
Mr. Ramos, have you had an opportunity to consult with Dr. Christensen?
That's very helpful, Judge. We appreciate it. We're ready to go.
Okay.
All right.
Mr. Burmester, anything before we invite the jury in?
No, Your Honor.
Counsel, anything before we invite the jury in?
No, Your Honor.
All right, let's do it.
We're ready for the jury.
So, an hour late, 50 minutes late, the jury comes in to start the day. The judge will probably apologize and take blame himself, as judges do, telling the jury not to hold this against prosecution or defense. Mindy Lou, I don't know. You should be able to. I know I tried to send one on Ian's channel and it didn't appear, but I think I used a banned word.
Ladies and gentlemen, please have a seat as you come in.
Sorry, there's your message, Mindy Lou. Sorry.
Please have a seat. Good morning. Thank you for your patience. We'll now proceed with additional witnesses in the state's case in chief. Mr. Burmester, the state's next witness, please.
Dr. Eric Christensen.
Let's invite Dr. Christensen in. Doctor, if you would step in front of Brittany, we'll get you sworn in, please.
The judge will put the mistrial discussion on the record probably either at lunch or at the end of the day.
Do you solemnly swear the testimony you're about to give in the matter before the court to be the truth, the whole truth, and nothing but the truth, subject to the pains and penalties of perjury? Yes. Thank you. Have a seat.
Drag that chair wherever you need to.
Okay, thank you. Thank you.
Please proceed.
Thank you, Your Honor. Can you please state your full name and spell your last name for the record?
Sure. Eric Dean Christensen, last name Christensen.
Sir, are you employed?
I'm currently self-employed.
Okay. You were recently the chief medical examiner for the state of Utah?
Yes, I retired in 2024.
How long were you the chief medical examiner?
I began working as a chief medical examiner in July of 2016.
Did you then supervise Dr. Ulmer?
I did.
Are you familiar with the death investigation for Eric Richins?
I am.
And how are you familiar with it?
I'm familiar with it from discussions with Dr. Ulmer over the time she was evaluating the case, as well as my subsequent review of the medical examiner's file.
Did you have an occasion to talk to Kouri Richins?
I did.
Okay. Have you testified as an expert in forensic pathology before?
I have many times.
Okay. I would like to first talk to you about
It's coming from the witness.
Cause and manner of death and the statutory requirement for that process. When you have a death investigation, could you please explain how, I guess, what the manner of death choices are and what's the purpose of that, and just describe that for the jury, please.
So, two of the things that the medical examiner is tasked with doing under statute is determining the cause of death and the manner of death. The manner of death is a box that we check on a death certificate that is essentially a one-word synopsis of the circumstances surrounding that person's death. The options available to us, we can certify that a death is a natural death. It can be an accident, it can be a suicide, it can be a homicide, or it can be, in Utah, the death certificate reads, could not be determined, what most commonly is referred to as undetermined. And in those settings, undetermined essentially means we don't have enough information to decide which of those other four options best fits.
What's the purpose of that whole exercise?
Again, it's something that's on the death certificate, and so it's part of the vital statistics function that the medical examiner's office provides. All of the deaths that we investigate and deaths that we certify provide information then back to the state. Sometimes that's public safety, sometimes it's Department of Health. Other people will utilize that death certificate data to evaluate the ways that people are dying within the state and attempt to intervene to minimize those types of deaths.
In this particular case, were you stuck between the first four you mentioned, such that you ended up picking undetermined or cannot be determined?
Yes, again, and just to be clear, I didn't sign the death certificate, Dr. Ulmer did, but certainly was involved in discussions around that. And the determination, making a determination of undetermined means that we generally can't decide between two. In this case, I would say actually generally most cases where we certify a death as undetermined, it's because in overdose deaths that we certify as undetermined, it's because I don't know enough about the person's own intent. We see it frequently in the setting, for example, of people that may have depression or other mood disorders, and maybe even prior suicide attempts, as well as they may have substance use history that they use to self-medicate their depression and things. And so if someone overdoses on a drug that they're known to abuse, but they also have depression, if they don't leave a note or something else, then I don't really have a means of, telling just from looking at that, did they mean to do this or is it accidental, incident to their normal drug use? That's the most common scenario in which we certify a death as undetermined. In this case in specific, we did not really have any concerns about suicide in this case, but there had been concerns related to our office that perhaps someone had done something to provide this to him and that he didn't just take it himself, but we didn't know. We had no idea how he got the stuff into his system, and so with that, we were left with undetermined.
So the choice there would have been, as opposed to accident and suicide, it was accident and homicide.
Correct.
Okay. Could you describe for the jury the way in which the body processes substances? In particular, I'm looking at opiates and the different ways they can be ingested.
Okay, there's a lot in that question.
Yeah, sorry.
Opiates can be consumed in a lot of ways. Even things, for example, like pills that you might get from your doctor for hydrocodone or oxycodone, opioid-related medications, those can be just taken by mouth as they're usually prescribed, but it's not uncommon for us to see people take those pills, crush them up, dissolve them in liquid, draw them up into a syringe and inject them. It's also not uncommon for us to see those pills crushed and then heated, and people inhale the vapors from that, primarily as a means of getting the drug into their system more quickly. And there's lots of other reported ways that people use things, but those are probably the most three common ways that we see pills abused. People may directly inject just about any drug that's available in a liquid form. Fentanyl certainly is. Fentanyl is also available in patches and lozenges and other forms. And so it can get into the system in a lot of different ways. In terms of what your body does with it, fentanyl in specific is metabolized primarily by your liver. There's what they call a CYP enzyme that is primarily responsible for the metabolism of fentanyl in your liver. That metabolism is felt to be mostly determined by how much blood is flowing through your liver. So the more blood flow you have to the liver, the more rapidly it will be metabolized. There are other ways that sometimes people will metabolize it more slowly, but based on what specific genes they have for metabolism, or for that metabolizing enzyme. But mostly it's a function of how much blood is flowing through the liver. And it's then converted very quickly, has a very short half-life in the body, minutes, and is converted to a substance called norfentanyl, which then is eliminated in the urine. Don't know if that covered all
yeah, that's great, thank you. Once it gets into the blood, then what's the intoxicating effect? I mean, how does that function?
Sure. So fentanyl in the blood distributes throughout the body. It's absorbed either through the mucosa, the lining of the mouth, or directly into veins, whatever. It gets into the bloodstream. And then from there, it gets into the brain, it gets into other organs, where it exerts its primary effects on the brain and the central nervous system, where it causes respiratory depression and or cessation. Can also cause central nervous system depression, meaning it alters the way you think, can make you groggy or less than normally responsive and things, but its primary lethal effects are related to its effects on your breathing. And it is dose dependent, so a higher dose will do this more readily than a lower dose, but it will either slow or stop your breathing, and sometimes that has lethal consequences.
The lethal consequences then are from stopping breathing?
Yes.
Okay. And when you stop breathing, death ensues. Does that metabolizing process continue to happen, or does that stop as well?
Generally, it will stop. There are, once your circulation stops and blood is no longer flowing through the liver, you're not going to have that continued metabolism through the liver. But there are a number of changes, large number of changes that are described in the way fentanyl is present in the body after death, that are related to changes in the pH of the body as you start to decompose, and other things that will influence what those levels look like.
When a person, I'm going to give you a hypothetical. So we have a decedent, and in the blood you and the lab personnel determine that there is quetiapine below the threshold of their tools. There is fentanyl at 15 nanograms per milliliter. And then in the gastric fluid, there is quetiapine at about 16,000 nanograms per milliliter, and fentanyl at 20,000 nanograms per milliliter. My question then is, based on that hypothetical, is there sufficient information for you to determine whether those two drugs were taken simultaneously or sequentially, and if sequentially, which one came first?
I can't tell you that.
There's just not enough information?
No, you can't derive that information from those values.
Okay. I just wanted to follow up. You said there's drowsiness as a consequence of taking, I assume, opioids of any type. Fentanyl just happens to be stronger?
Yes, fentanyl on a weight-by-weight basis, 1 milligram of fentanyl compared to 1 milligram of oxycodone or of morphine is sort of the usual reference standard because it is the classic opiate medication. Fentanyl is just much, much more potent, 80 to 100 times more potent than morphine.
So you said there's depression of the respiratory system, drowsiness. How quickly might one start to metabolize, given the fact that they take some fentanyl and it causes their death? Would they be able to metabolize at least some of it?
You would expect so, yes.
Okay.
I mean, there are a number of overdose deaths reported in the literature where the death occurs so quickly, and these are primarily in the setting of intravenous drug use, that no metabolism is able to be recorded because they just die too quickly. But generally speaking, we see some level of metabolism.
Let me see, I wanted to... But someone takes an overdose, a fatal dose of fentanyl. It's not then instantaneous death.
It depends partly, I mean, generally speaking, no. It's a function of the dose and the route of administration. So it's going to get into the system more quickly as an IV, or smoking will generally get it there pretty quickly as well. But ingestion would delay that somewhat. But however it gets into the body is going to determine how quickly that happens.
In this case, we have the two things, I think. One is there's some fentanyl in the stomach, the 20,000 nanograms.
Yes.
And and also a measurement of, I know I'm saying it incorrectly, acetyl fentanyl.
Acetyl fentanyl, yes.
Does that, is that information help you determine how it was ingested in this case?
It's suggestive that it's an oral ingestion. The presence of a large amount of fentanyl in the stomach, sort of the rough equivalent of, several milligrams by volume is, suggests that it was taken by that route, but there's not any way to definitely know that. There is some literature that suggests that the stomach will concentrate it, regardless of where it's from, but it is suggestive of that. And the presence of acetyl fentanyl in the stomach is also consistent with, is more consistent with this being illicit fentanyl than otherwise. Acetyl fentanyl is a variant of fentanyl that is, in our office, certainly we've only seen it in the setting of illicitly manufactured fentanyl.
When a body comes in for autopsy, in this case, Mr. Richins' body comes in, is it routine to check for injection sites?
Yes.
And
in this case in particular, there was visible pulmonary edema described at the scene, foam coming out of the mouth, and that is most commonly in somebody who didn't drown or have a history of heart failure is concerning for an opiate overdose, and so we would, in that case, do a thorough check for those.
Oh, for
injection
sites, and none found.
Again, I did not do the exam. None are described, and none were discussed by Dr. Ulmer.
Okay.
And I didn't see any in the photographs.
When you, in cases where you've seen an overdose death, particularly an accidental overdose death where you suspected inhalation, what's the sort of evidence that you would expect to see?
I'm not sure what you mean, inhalation of the substance?
Of fentanyl or opiates.
Yeah, they all kind of look the same from that regard. You may see evidence that they've been smoking. Sometimes you'll see little burns on their fingers or other things from heating it up to smoke it, because they're not actually smoking it in the same way that you smoke a cigarette where you light it on fire and then you're inhaling the smoke. What actually is happening is that drug is being heated up and vaporized, and you're inhaling the vapors.
So, in those cases, do you tend to see evidence of that heating up? That is, tinfoil or torches or
certainly, yes, those things can be present at the scene.
Okay.
Commonly are seen at the scene.
Okay. Now, is it common for the people who are left behind to call the ME's office to find out what's happening in the case of their deceased person?
I wouldn't say it's common, but it's not uncommon. I mean, I spend a lot of time, most days I was in the office speaking with family members.
Typically that would be whoever did the autopsy would be talking to the person who's calling?
Yes.
Okay. Dr. Ulmer retired in January of 2023?
Yeah, technically, her last day of work was the end of December of 22.
Okay. And did you receive a call from Kouri Richins then?
I did, subsequent to her retirement.
And did you return her call?
I believe I didn't return her call. I believe she was just put on hold and then connected with me.
Okay. Have you had an opportunity to listen to a recording of that phone call?
Yes, I'm not sure where it came from either, but yeah.
Is it consistent with your recollection of that phone call?
I did not have any independent recollection of it until I heard it, but yes, it's me on the phone call.
Okay. And have you had a chance to look at the transcript of it?
I have.
Okay. And is that accurate to your,
Yes.
when you listen to the
Yes,
tape?
it appears to be.
Okay. State would offer States Exhibit 2-60 and 2-61T.
Objection hearsay?
He indicated he's reviewed it. Certainly we could ask questions if he needs his recollection refreshed, then I think we could move to admit at that point, but if the state would just
I think
ask
the state's admitting it as evidence of defendant's words and statements in the relevant time frame.
I misunderstood. No objection.
And so, okay.
We'd ask permission to publish it then if it's offered and admitted.
So 2-60 is the audio recording, correct?
Correct.
And 2-61T is the transcript.
Correct, Your Honor.
Okay. Those two are admitted. Scott, give me just a moment here, sir. Give that a try.
Okay. I'm going to ask you to listen to this. It's about 9 minutes long, and then I will ask you 3 questions regarding it. Okay, thank you. Can we advance it 30 seconds?
Right now, okay? Thank you
the
so much.
first 30 seconds
Thank you so
is...
much. Okay, sorry about that. I'm going to transfer you right now, okay? Thank you so much. Thank you so much. No problem.
I'm not hearing it.
Did we lose it, Scott?
I think so.
All right, no problem. Let's start over.
This whole music
we're getting
was all
quicker
a
at this.
strike.
Scott, if you would disconnect and reconnect on your end, I'll do the same on mine.
Unplug it, plug it back in again. Fixes everything in this courtroom. Is Nate Ayden in court today? Does anybody know? East Idaho News?
I'm going to transfer you right now, okay? Thank you so much. Thank you so much. No problem.
What's that, Chris?
Hey, this is Kouri Richins. Hey, I just have some quick questions for you. I'm just trying to understand the toxicology report, and I promise I won't take up a ton of your time.
Oh, you're fine. You're fine.
Can you just kind of explain to me, I guess, she was saying that this kind of supplemental report, I guess, was left out of the first autopsy, and so nothing has really changed. Do you have it in front of you?
I do. Yeah, I got the file here.
Scott, did we drop that again?
Every time you...
All right, I apologize, folks. Let's try that again.
Every time he changes the transcript on the screen, we're losing it. I'm going to listen to the music again.
Scott, if you would disconnect from the system. Thank you. Then reconnect, please.
That HDMI port is getting its workout today.
If we do any additional microscope.
I'm going to transfer you right
so much.
Thank you so much. No problem.
What's that, Chris?
Hey, this is Kouri Richins. Hey, I just have some quick questions for you. I'm just trying to understand the toxicology report, and I promise I won't take up a ton of your time.
Oh, you're fine. You're fine.
Can you just kind of explain to me, I guess, she was saying that this kind of supplemental report, I guess, was left out of the first autopsy, and so nothing has really changed. Do you have it in front of you?
I do. Yeah, I got the file here.
So can you...
So just so you know, so we issue supplemental reports, like if once the original report's issued, if we do any additional testing, if we do any additional microscopic examination, anything like that, then we include that. You know, we issue a supplemental report to include that additional information. And sometimes it does change the cause or manner, but in this case it didn't.
Okay, it was just like extra testing done?
Extra tox testing, yeah. So originally the testing, the only toxicology testing that was done was on blood. And so then this was additional testing on stomach contents.
Okay, and so is there difference in that, I guess?
Well, they just tell you different things in the sense of, it tells you something about what, was it, is it been there a long time? Is this something the person's been using for a long time?
Okay.
Is it something they ate? Is it something they, injected? Is it, whatever? And there's different things you can learn by looking at different substances. I mean, we fully expected to find it in the stomach. It's just a question of what was there.
So does this tell you, like, if it was, like, injected, if he ate it, is that what this, can you tell from this report?
Not definitively. I mean, it seems like, with what the amount that's there, that it probably was ingested. Probably taken by mouth.
Okay, and so so the 15 ng, like, is that like a substantial amount? Is that like a trace?
That's a lot. That's a lot of fentanyl in the blood. Yeah, I mean, that's people die with half that amount or less in their system.
Okay, so that's quite a bit.
Yeah.
So what's the next one down? The norfentanyl.
It's a metabolite of fentanyl. It's what your body changes fentanyl into after you take it.
Oh, I gotcha. Okay. And then, sorry, just the third one, the acetyl. I don't know how you say that.
Acetylfentanyl.
Oh.
Yeah, that's just it's a form of, it's a variant of fentanyl that is usually only present in the setting of illicitly manufactured fentanyl.
Illicit manufactured, like a pharmacy?
No. Like a lot of most fentanyl that we see that ends up leading people to die these days is related to fentanyl that's manufactured by drug cartels as opposed to by pharmaceutical companies.
Oh, good Lord! So this is like more of like a cartel. No, I mean that's not what it is.
You call this street fentanyl as opposed to
prescription. Okay, I see. And then is the ethanol, is that alcohol?
That's alcohol. Mm-hmm.
Okay, and is that like the 279? Is that kind of like a substantial amount, or is that like one drink? Is that 5 drinks?
You can't tell how much it is, and in this case, since this testing was sent, quite a long time after the original autopsy, most likely that's related to post-mortem change, but it could be stuff that he drank. There's not really a way to sort that out. It could be related to decomposition of the stomach contents, or it could be related to stuff he drank. But either way, in the stomach contents, there's no way to know what that level means in terms of, if that was a blood level, that would be the same as a 0.28, which would be, that person would be pretty substantially intoxicated. But because it's gastric contents, you could in theory pull something out and it would be 100% ethanol, if depending on if they just drank a stomach full of, if they just drank a bunch of Everclear or something else. Mm-hmm. So it doesn't really tell you much about how much they drank or what they drank or anything like that.
I gotcha.
In the stomach, and it's not present in his blood. So
I gotcha. Okay. So it's not present in the blood, just the gastric or whatever.
Right.
Okay.
Yep.
And then just the last one. What is quetiapine? Quetiapine?
Quetiapine is an antipsychotic medication. It's called Seroquel.
Okay. Gotcha.
It's a prescription mental health medication that's prescribed for different things.
I gotcha. Okay. And it has like 16,000?
16,000 nanograms per milliliter. Mm-hmm.
Okay, and is that, quite a bit? Like, can that?
That's a big number, but it doesn't really mean that much. So a nanogram is a millionth of a gram, and a gram is not very big. So even 16,000 of them is not a huge amount.
Okay. Is there could those have been mixed, or is that not kind of a?
What's that? Could what be mixed?
Quetiapine and the fentanyl, or is that drug a normal? I guess.
drug thing. I don't know. Like,
It's not, I mean, you know, most of the time if we see those together, it's because somebody was taking quetiapine as a prescribed medication and they were abusing fentanyl. But, you know, there's, you know, do you have any indication he was abusing fentanyl?
no, that's why all of this is just like, what the heck is this and going on? So I guess that's why I'm confused just about all of this, honestly. So yeah, I don't know. So, I mean, I know it doesn't mean anything now, but just kind of something for me to, you know, try and figure out, I guess.
Yeah.
Yeah. And then I'm assuming the acetopian, is that like a aspirin or something?
Acetaminophen, that's just Tylenol. Yeah.
Oh, that's fentanyl too?
No, that's Tylenol.
Oh, Tylenol. I was like, holy shit. Okay.
Yeah.
So just like Tylenol, caffeine, and then the naloxone, I'm assuming, is just something that they gave him while he was here?
Probably would be my guess. It'd be, you know, somebody that's unresponsive. It's a very common thing for EMS to give people.
Okay. Okay, no, that,
She just snapped her fingers at
that
her
works.
kid.
I was just trying to figure out, you know, if this is anything different, if we found out anything new with this up.
Oh, come on.
Pause there. It's okay. We can fix it. Scott, don't change anything. Okay. It seems like
some random video of grass.
if I do this, press play again.
Yeah, like she said, it doesn't change anything in the cause or manner of death. It's still, you know, definitely, you know, death from fentanyl intoxication, and we still don't know how he got it into him.
Yeah, and I mean, is that anything you could ever find out if it was, I mean, do people normally eat that, like take it, swap, like, is that something you like shoot?
It's not usually something people eat. Well, that's not even true anymore. So with illicitly manufactured stuff, sometimes people take pills that have that. So yeah, these days you can't really tell.
Yeah. All right. Well, I appreciate your time. I do. Thank you very much. And
Yep. And if you have other questions, don't hesitate to give me a call.
Okay. Awesome. What was your name?
Dr. Christensen.
Oh, Christensen. Okay. Perfect. Thank you so much. I appreciate it.
Okay.
Okay.
Yep,
Bye-bye.
you're welcome. Yep.
I'd like to follow up on a couple things there. You mentioned to her about if the gastric contents were blood, it would be 0.28
Yes.
blood alcohol, but it's, in fact, not in the blood. It's in the gastric, and so there's no way of conveniently figuring out how much it is, much less its source.
That's correct.
Are you okay? Do you need a glass of water?
I've got water. I'm good.
You mentioned in that call, at first you said, we typically don't see it eaten, but you can't say that anymore. Could you expound upon that? How, in cases where there's pills, is it common to see them eaten?
Okay, a few things about that. So over time, I'd say the last 20 years, we saw a rather dramatic change in the deaths we saw related to fentanyl. Until the early 2010s, pretty much all fentanyl deaths were related to prescription fentanyl being used incorrectly, most commonly by healthcare providers and other people who would, have access to it and would abuse it. And it was just not a common thing. We just didn't see a lot of deaths related to that. Once patches became available, which were designed, primarily for, treating cancer patients with bad pain and things of that nature, people became creative with how they used those patches as well. Some people would, put on multiple patches, or they would put on patches and a heating pad to sort of drive it into their system more quickly. Seen people that would smoke them, people that would insert them into their rectum, people that would chew them up. Sometimes we find, multiple chewed up patches in the stomach, and certainly other ways have been described as well with patches. But once the illicit drug supply and primarily the heroin supply came to be, either augmented and or replaced by fentanyl, we saw, we saw much less in the way of the prescription abuse and much more of the illicit stuff being used. And some of that was in the form of what was heroin. Most heroin in this area was black tar heroin, which then became ended up having fentanyl within it. So people that had been heroin users would still be using what they thought was heroin, and it would have fentanyl in it, many times mixed with heroin. Eventually, some cases was not mixed at all, but was just straight fentanyl. Counterfeit fentanyl pills, or counterfeit oxycodone pills. Fentanyl in pill form, made to look like it was an oxycodone pill, also became a fairly common thing. And as we discussed before with other pills, people will abuse those in different ways. Sometimes they can ingest them directly, but they can also grind them up and inject them or smoke them. So they can be used in all kinds of different ways. But in the phone call, what I'm referring to, we mostly did not see anybody eating fentanyl before illicit fentanyl. With the advent of these counterfeit pills, we saw it somewhat, more often, or would assume that was the route. But we, even then, most of the time don't know how somebody gets the fentanyl into them, even if they have it on their person.
In this case, there certainly wasn't any injection sites noted.
No.
Are there tests, forensic tools, that could aid in the determination of whether one is a chronic or habitual or a naive user?
It's a good question. So there's been a lot published on the assessment of fentanyl levels in people that have died, and ways that you can try and parse some of those things out. The bottom line for all of them is you can't look at a number in isolation and make a determination based on, this is a lethal level, so this level has to be the cause of their death. There are certainly people who become tolerant. Most opioids, people will develop tolerance over time, and so they can have very, very high levels and not have the same effect as someone who doesn't take it all the time. We had no history in this case in particular to suggest long-term chronic use, but also didn't know. And there are things that could potentially be looked at to try and assess longer-term use. The only published data I've seen around that revolves around comparing the fentanyl to the norfentanyl level, and levels where that ratio is more than 8 are believed to be consistent with an acute intoxication. Ratios of 2.5 or less are consistent with chronic use. In this case, that ratio is about 4.6, so it's right in between, so it doesn't really provide us helpful information either way.
Okay. That's the ratio between fentanyl and its metabolite.
Correct.
As you find it.
Yes.
Have you ever heard of pseudo-allergic reaction to opioids?
Yes.
Could you tell the jury a little bit about that?
Sure. Most allergic reactions are because the body has developed an immune response to some specific protein substance, whether it's nuts or grasses or whatever, pollens of different types, and your body reacts to that and triggers a reaction through your immune system that elicits what we typically think of as allergy symptoms that can range everywhere from, a stuffy head all the way up to anaphylaxis and death. In the setting of opiates do not elicit a true allergic response, but there are many people that take opiates who have an allergic-like reaction, but it's because the drugs themselves are directly triggering those cells that cause those symptoms as opposed to going through the immune system route. And so some people will, that chronically take opiates and opioids for pain, will pre-medicate or medicate around the same time with things like Benadryl and other things to minimize those symptoms because they know they have that reaction. Certainly most people that take them do not have that reaction, but some do. And
if one didn't know and one took some opiate, could they have hives and those sorts of allergic-like responses?
Yes.
Given all the symptoms that you talked about, the lungs, the edema, and the data from NMS labs, do you have any concern about the cause of death in this particular case?
No.
And the 15 nanograms, as you explained to Kouri Richins, was a lot.
Yes, it's well within the range of levels that we see in people that die from fentanyl.
Do you remember when that phone call took place?
Do I remember what?
When that phone call took place?
I don't off the top of my head.
Okay. Does your office take notes when you receive calls and reply to calls, et cetera?
Yes.
Okay.
That changed a little bit over the time I was there. It used to be we'd get a little scrap of paper with a note written on it, return this call. We turned that into a digital log before I retired, but yes.
Would it help to look at one of those notes to refresh your recollection as to when the call took place?
Sure.
May I approach the witness?
Of course.
It's weird. He never really gets the witness to say he doesn't remember when it happened. He just goes straight to refreshing the recollection.
Yes, this is from the log. Just said that an incoming call came to me from Kouri Richins, and she had questions. And that this is my notes.
And so what day did that phone call?
On January 12th of 2023, a couple weeks after Dr. Ulmer's retirement.
Thank you. That's all I have.
Could I get some more water?
Of course.
Waterboy bailiff, refilling the shots, or the water, excuse me.
Thank you.
Still no bottled water in this courtroom. We've already had one spill on the witness stand.
Good morning.
Good morning.
We've spoken before. I'm going to ask you some follow-up questions to Mr. Burmisters.
Sure.
I'll start off with that final thing that Mr. Burmister showed you. You indicated that you would take calls from different individuals, correct?
That's correct.
And did you receive other calls in this case from law enforcement?
I believe I did, yes. Mm-hmm.
Okay. Would it refresh your recollection, or do you recall a call around the same time in this case?
I don't recall the timing of it.
Okay. I'm going to approach you with the same case notes. And it's that first one.
Yes.
Mr. Ramos here for the defense.
And did you in fact receive a call before Ms. Richins?
Yes, the day before.
And was that law enforcement?
It was.
And was that also regarding the supplemental report?
Yes.
Okay. And either your recollection or what's in your notes, do you recall if most of the questions were the same that Ms. Richins asked you on the 12th?
I don't have any specific recollection, but my general recollection was that we discussed the supplemental tox findings.
Perfect. I'll take that back. Now, the questions that we just heard Ms. Richins ask you, very similar to what we're asking today, correct?
Yes.
Okay. I'd like to talk to you about the allergen discussion you just had. You indicated that perhaps an individual could have a reaction like hives.
Yes.
If someone is allergic, in this case to an opioid, as you indicated, does that allergy disappear?
I'm not sure what you mean. Does it go away over time?
Over time or within a certain amount of time? Or
I mean, allergies certainly are things that can fluctuate. People can receive treatment and their responses to different things will go away.
Were there hives on Mr. Richins' body, to your recollection?
No.
We were talking about illicit fentanyl and counterfeit pills.
Yes.
Containing traces of fentanyl?
Milligram amounts.
Okay. Now, the tablets or pills that would contain these traces, what kind of pills would those be? Generally.
Objection. The discussion, if we're talking this Oxycontin, is that what you're saying?
I've not said it. I've just said pills.
Okay. Well, there's no pills.
What's the legal objection?
That they have that you can make.
Would you provide a little more foundation for your question
Sure.
so we know what we're talking about?
Objection foundation.
Your testimony
Judge
just
safety.
now was that, in your experience, you started to see that fentanyl or fentanyl overdoses were coming in through your office, correct?
Correct.
And in those overdoses, you gathered information, and because you would see that there was a presence of acetyl, I say that right? Acetyl fentanyl?
Acetyl fentanyl.
Acetyl
is also fine.
Okay, acetyl fentanyl. that was more likely a result of illicit fentanyl, correct?
So it is a form of fentanyl that in some cases there were a variety over time of different fentanyl variants that were developed primarily in response to controlled substance legislation. If fentanyl is outlawed, then we'll add an acetyl group to that molecule, and then it's no longer controlled. And so we can distribute that as a non-controlled substance. And then that one gets controlled. And so then, there were dozens of variants of fentanyl that were developed over time. Acetyl fentanyl was one of the more common ones that we saw early in this wave of progressions, but was one that we saw not infrequently.
Now, with that, what was the acetyl fentanyl contained in, usually in your experience?
I don't recall ever having seen acetyl fentanyl in a substance form in any of our specific cases.
Because it was always inside whatever pill or however it was administered, correct?
I don't even know if it was pill administered. I don't know.
Or injection.
Or I don't know how we would see it in people, but I don't recall ever seeing that correlate with a specific pill that we had tested that was shown to contain that. I know generally the crime lab identified acetyl fentanyl in some pills, but I don't recall a specific instance in my casework where those two were correlated.
Describe counterfeit pills.
Counterfeit pills are essentially illicitly manufactured pills, and sometimes very sophisticatedly, where people will buy the same kind of a pill press that a drug manufacturer uses, and they put their stuff into it and press pills that look very, very similar to legitimate prescription pills. The most common counterfeit pills that we've seen have been fake 30 milligram oxycodone pills that, when tested, contained only fentanyl. And there are also some benzodiazepine pills, things like Valium and Xanax and other things where those, what look like Xanax pills, have also contained fentanyl.
And you just indicated two different things, that in some instances it was purely fentanyl. Those pills contained only fentanyl, correct?
Correct.
And then there were other times where perhaps they were still traces, or there were still the other benzos, for example?
Those would be different pills. I don't know.
Sure.
I'm not aware of any where it was both fentanyl and benzos, are made to look like benzos that didn't have. We've seen counterfeit benzodiazepine pills and counterfeit oxycodone pills, both of which contained only fentanyl.
Correct. Now, in this case, you were provided, or your office rather, was provided with a hydrocodone bottle, correct?
Correct.
Now, that bottle you keep in your office, correct?
We do. Until the case is done, eventually it's discarded, but yes.
You talked about would it be fair to say that fentanyl, right now you discussed how you would find acetylfentanyl, and that was one part of it, and then you had to make sure that legislation got that specific one into the books so that it would then become a controlled substance, correct?
Yes.
And so I imagine that was really fastly evolving.
Yes. I mean, I was a member of the state's Controlled Substances Advisory Committee that would provide recommendations to the legislature to include in the Controlled Substances Act. And every year for, this time from the late teens to the early 20s, it seemed like every year we were adding things. They did eventually make some changes where relatedness became, if it wasn't changed enough, it was still covered. But it was an evolving process. And what we would see in the deaths that we saw related to fentanyl and fentanyl analogs also changed.
And with that, also peer review literature as to the effects of fentanyl, correct?
I would assume so.
That would make. You kind of hesitated. I would assume so.
Well, I mean, the peer-reviewed literature is evolving all the time, and so I don't know if there's a specific thing you're referencing. I don't know, but certainly, initially there was not a lot of. As the fentanyl supply changed from primarily pharmaceutical to primarily illicit, there in the early stages of that there was not a lot of new literature to look at the postmortem levels in people that have died of this illicitly manufactured fentanyl as compared to the different ways that people used to take it as a diverted pharmaceutical before.
And that's exactly where I was going. The postmortem, these levels that we've been discussing. Mr. Burmester asked you about the postmortem levels, and you received from NMS reference comments, correct?
Yeah, that's part of their report.
Correct. And do you recall what those numbers were in terms of the femoral blood as it relates to accidental drug overdoses?
I don't recall specifically what the numbers were, but generally speaking, the levels that we see in accidental overdose deaths from fentanyl, overlap the levels that are seen as described with, prescription usage.
And part of the reason for that is going back to the literature is that there is no, I'm trying to find the right words for it. There's no set number, universal number that that the medical community can attribute in terms of what becomes lethal, correct?
That's correct.
Okay, and the reason for that, or part of the reason, and add to this, is both the individual's own use, prior use, if any.
Yes.
Perhaps the toxicity or rather the amount of fentanyl in it, correct?
The dose.
In the dose.
Yes.
Mm-hmm. The potency of that dose, correct?
Fentanyl is going to be relatively equipotent, but the fentanyl analogs may have different potencies.
Okay. A fixed fatal threshold? Does that sound?
Yeah, there isn't one.
Okay. You were discussing the ratio of fentanyl with norfentanyl with Mr. Burmester. Do you recall that?
Yes. Mm-hmm.
I got lost, to be frank.
Not surprising. I'm not always good as explaining as I'd like to be.
No, I think it was just going over my head. But tying it together with the post-mortem literature out there and this ever-evolving world that unfortunately we're dealing with now with fentanyl, is there any literature on how that ratio can be affected that you're aware of?
I'm not aware of any specific literature that looks at the ratio of fentanyl to norfentanyl in determining, is it a cause of death? Is it, is it a a recent, a one-time use or multiple time use. I'm not aware of any literature that discusses that. There certainly has been some literature added over the years to discuss comparing, for example, the amount of fentanyl seen in the heart to that seen in a peripheral site. We call it like something like from the femoral vein, to try and assess, things, or looking at other, what we would call substrates, other sample types, fluid from the eye, testing the liver, urine, other things of that nature.
Let's talk about that. We discussed this when we spoke. Could you?
They spoke this morning.
You talked about things that you, looking back, you could have done.
Yes. Mm-hmm.
Could you explain to the jury some of those?
Sure. There is, I guess they say hindsight is always 20/20, but you can certainly. There are a number of things that are in the literature now suggesting that you might gain additional information if you test, for example, urine, which is not something that medical examiner's office routinely does in any case, because what's in the urine is simply a reflection of what has gone on before, and what we need to know is what's in the blood, what's in their system circulating at the time they die. So we don't routinely test that. There is some suggestion that that can help you sort out how quickly or not quickly a given death related to fentanyl might have occurred. And then there's been other evaluation of other substances like fluid from the eye, what we call vitreous fluid, as well as liver, and looking at both of those as a means of perhaps augmenting the understanding of what's going on in the blood as well. When you take something, for example, by mouth, it goes through, down into your stomach, gets absorbed, and then anything that gets absorbed goes through your liver before it goes anywhere else. And so an oral ingestion, in theory, might show up as a higher level in the liver than if it's taken IV or something in some other method. So there are other things we could do that would certainly, potentially help our understanding of how, how the fentanyl played out in Mr. Richins' case.
And you had also mentioned in our discussion, the brain, the heart, and maybe you mentioned blood. Are those also helpful? Looking back again, hindsight.
Yeah, so the brain, there's good literature that suggests the brain takes up fentanyl, and that is the cause of both the central nervous system and the respiratory depression. It's interacting with opioid receptors in the brain. There's not any published literature that I'm aware of that talks about what a given level in the brain would mean. Same with other solid organs. There's starting to be some literature discussing what a liver level might mean, but I'm not aware of any other specific organ sampling sites that might add light to that.
What about hair follicles?
Hair testing in the setting of drug use is primarily used as a means of evaluating drug use over time. Drugs do get taken up into the hair. And when we collect samples to send for hair testing, which pretty much we only do when we're requested to, but you tie off a bundle of hair. They want usually about a centimeter, so a little under half an inch bundle of hair. And we tie it off at the roots, cut it off, and then that gets sent to the lab, and they take sections of it starting at the root going back to see, based on how fast hair grows, how long has this person been exposed to this substance.
And you indicated unless you're requested, I imagine, for example, law enforcement.
Yes.
Okay. That wasn't done in this case?
That was not done in this case.
Now, as we heard, Ms. Richins, she indicated that that Eric was not using fentanyl, correct?
Correct.
And there was, going back to the initial conversation or the initial testimony regarding the different categories, when you're trying to really determine what to put down on the death certificate, one of the unanswered question was, well, was he using, correct?
Yeah, that was part of it, certainly.
And in our prior discussions, you've indicated that, at times individuals didn't tell family, correct?
That would be not uncommon, yes.
Okay. And certainly in this case, a hair follicle test, if it had been requested of your office, you would have sent it out.
We would. I don't know, and I think as I told you, I don't know what the literature says about hair follicle testing for fentanyl specifically, whether that's a useful endeavor or not. I don't know.
Fair enough. Certainly it wasn't asked of you, and certainly you didn't get the results back.
No.
Now, had that been done, had you gotten the results back, and it did show long-term, that certainly would have played into your determination as to the manner of death, correct?
Objection calls for speculation. The testimony has been...
Yeah, why don't we have a
little sidebar here? Sorry, I've got pop-up windows and software update. Okay, that's objection number 87. Did I hold up the yes? Eric was buried. Then I misunderstood the testimony when the family got up. I think it was Katie who got up and said that they had planned this whole funeral, and then Kouri's mom said, I guess we need to talk about how Eric wanted to be cremated. Which one won? I'm confused. Did the family win or did Kouri win? Because Kouri said yes, cremation. They pushed for cremation but ultimately buried. Okay. I misunderstood that. Thank you. Thank you for the clarification on that one. This is a good line of questioning. Yes, a couple of you asked about the hair follicle tests and what that would show. They didn't do it. It's the woulda, coulda, shoulda.
You are not aware of a hair follicle test, in your experience, being done for fentanyl?
I am not.
Okay. You don't know if it can be done?
I do not know.
Had a hair follicle test just for any drug, including fentanyl, any just hair follicle test to be sent out to see if there's any type of drug use whatsoever, your office would have done that, correct?
Objection.
overruled?
If we were requested to, that's certainly not something we would ever routinely do.
Absolutely no, and I'm not implying that. And to be fair, the reason you wouldn't do that is because your office is tasked with what's at hand, which is what do you have in front of you to determine the manner and cause of death, correct?
Correct. Why is this person dead right now?
Correct.
As opposed to some other time.
And in terms of your checklist, the hair follicle just doesn't come in terms of what you do, correct?
I mean, it can, or it could in theory, but yeah, mostly no.
But if it were to be requested of you, you would or could do it.
We could.
Objection, I think the answer was for this particular job.
What's the objection, Mr. Burmester? Asked and answered?
Asked and answered, and calls for speculation.
Sustained. I'll ask you a different question.
So I'm going to go back with all that in mind. Had you sent out if you send out a hair follicle test, is your practice generally, when you receive the results of said hair follicle test, to use those said results in your determination of whether or not to change a manner of death?
They would be part of, all the information that we look at to come up with our final cause and manner of death.
Perfect.
Yes.
Thank you for that. Fair. Mr. Burmester asked you about the sequence of items that were ingested or not ingested. Do you recall that?
Yes.
You indicated that there's simply not enough information at hand to be able to determine that, correct?
Yeah, not just from this case. In forensic toxicology, generally, you can't tell when something was taken just based on a number.
And that's what I wanted to make clear, whether it was just in this case or just generally.
Generally, you can do that.
And that means that there are no tests or nothing else that you can go back and do to make that determination, correct?
Correct.
Okay. Bear with me, I'm almost done. Okay. Now, in involvement in this case. Something unusual did occur in this case in terms of the investigation, correct?
You'd
of
have to be more
I'm sorry,
specific.
yes, I will.
Yeah,
In
what
terms
were
of
you
me,
talking about?
I'm going to rephrase.
We're about to find out.
Yeah, I apologize for poor
What
question.
sort of objection
I'll
was
start all
that?
over. We saw your case notes.
Yes.
And there you spoke with one law enforcement officer, correct?
Yes.
Legal
Now,
objection.
you also received other communications from other law enforcement officers, correct?
I believe so, yes.
And do you recall being invited to a meeting to have a discussion about this case?
Yes,
And do you recall if the DA was involved in that case?
I believe so.
And other prosecutors, correct?
I believe so, yes.
As well as other law enforcement agencies, correct?
I don't know.
Okay. And that was unusual in your practice?
It's not common. It happens, but not commonly.
Okay. No further questions, Judge. Thank you so much, Doctor.
Mr. Burmester, within the scope of cross, please. Oh, my apologies, maybe not yet.
Apologies,
Do you have
Judge.
some order, sir?
Yes, I do.
Okay.
New post-it just came in from the defense table. Mr. Ramos shakes his head and says, nope, not going to ask that one. Ms. Lewis argues for the inclusion of the question. Mr. Ramos checks the note again, looks at the back,
We're good, Judge. Thank you, Doctor.
waves it off.
Mr. Burns.
Just trying to figure out this meeting you said. Is it the one you testified earlier when you got a call from law enforcement?
I believe so. From my notes that were in the log that I looked at, I was invited to a meeting. It was my recollection, it was some sort of virtual meeting. I don't know if it was WebEx or Zoom or whatever. And I believe it was with Mr. Hemingway's computer, but there were other people in the room who were introduced to me, but I don't recall exactly who was there.
You don't know who that was?
I don't know who. I couldn't give you
And
a list.
when defense counsel says the DA, presumably the Salt Lake DA was not interested in this case.
No, I think you said DEA.
DEA.
Oh, yeah, I don't recall.
Drug Enforcement Agency
I
as opposed to
misunderstood that. I
the
thought
district
I was
attorney.
asked DA as well.
So my apologies, I want to make sure I don't get involved in any confusion here. Would you please clarify what this testimony is?
I think you've said you received notice to attend a virtual meeting and law enforcement was there.
Yes.
And you don't know who specifically in law enforcement was there?
Besides Mr. Hemingway, no.
And this was the day before Kouri Richins called?
That's what the log says. Yeah, I don't have any recollection of that specifically.
Hydrocodone doesn't look like this M30 you talked about, imprint of M30.
No, I've not seen any counterfeit pills made to look like hydrocodone pills.
Okay. In this case, there were no traces. That is, you testified there was a lot of fentanyl in the blood.
Yes.
And there was no traces of anything else related to fentanyl.
In the blood, yes, correct.
These other things you talked about, urine, vitreous, liver, brain, heart, blood, none of those, based on your understanding of the literature, et cetera, would give you a definitive forensic proof of long-term use or not long-term use?
Definitively, no.
I have no more questions.
Mr. Ramos, anything further for Dr. Christensen?
Yes, Judge, 1 second.
Mr. Ramos does have a little bit more. Her demeanor on the phone with the state medical examiner did seem a little strange. And some of the questions, would you be able to find that out? Would anyone be able to find that out? Was wild.
We're good. I apologize, sir. Thank you so much. Thank you, doctor.
Is this witness released, counsel?
Yes. Yes.
You're free to go, sir. Thank you. Please watch your step.
You may stop billing the state now.
What time did this start?
Judge checks the schedule.
You want
looks
to
at the
keep going,
clock.
counsel, or you want to take a restroom break?
Your Honor, may I just confer briefly with
Of course. Yes.
They need to see if they're on the same page with this video. If defense needs more time to look at it. This would be the Robbie interview.
Your Honor, this might be a good time for a break.
Okay, folks, let's take a restroom break. Please rise for the jury. Please have a seat. Mr. Bloodworth.
Your Honor, back to the video of the May 4th, 2023 interview. I think, I don't want to speak for him, defense has had a chance to review it, but we'll still have an objection.
Ms. Lewis, please.
Yes. Your Honor, we still object on two grounds. One is still hearsay. There's not only just the statements of Mr. Crozier and Detective Davis and Detective, I think Hamilton maybe was the other one there.
It was Ben Carino.
That's okay, that's fine.
I'm certain it was Ben Carino. So you can think all you want. It was Ben Carino.
We have law enforcement side, and then we have the Mr. Crozier side.
Right, but then we also have law enforcement making statements to Mr. Crozier, statements from Nicole Cummings and Carmen Lauber. So there's those hearsay statements in there also.
Hearsay.
And the other thing is, it says that it can be admissible under 801D when the person is subject to cross-examination. I know Mr. Crozier was subject to cross-examination, but he's no longer subject to cross-examination. It seems as if this video should have been introduced prior, because then we would have had the opportunity to show him portions of the video and cross-examine him on the video. That opportunity is now lost.
Why?
Well, he's been released from his subpoena. We don't know if he's been out talking about the case, I suppose.
Well, you could ask him about that, but he's not unavailable.
Well, that's correct. We could subpoena him and bring him back in. That's true.
And I just want to make sure I understand the procedural history here. Defense had the video, right?
Yes.
To the extent it had wanted to cross-examine him regarding the video when he was on the stand, you had the opportunity, and there may have been good reasons to not do it at the time.
Well, the main reason was he had no memory of it, so that made it difficult.
Well, that's exactly the condition that triggers 801D1A.
You're losing here, Ms. Lewis.
801D1A is if there is inconsistencies in it.
Or has forgotten.
Yeah, I'll take your word for it. I don't have it in front of me.
I mean, I think that is the basis to have a discussion regarding admission of the video, his side of it, right? Under 801D1A is that he was testified numerous times under oath in open court that he couldn't remember the interview. Right. Even to the extent of saying that piece of transcript does not refresh my recollection.
Correct.
The question is the whole video.
So I can instruct the jury to not consider anything other than Mr. Crozier's statements for the truth of the matter, that they can only consider the law enforcement half for context, as to provide context for why Mr. Crozier is responding. Other than that, any other hearsay concerns?
No, no other concerns.
Any other concerns?
No.
You had two reasons, you said.
Yeah, I gave them the hearsay of the other people
and okay.
The subject to cross-examination
All right.
on the video.
Okay, Mr. Bloodworth, anything further on that?
No, Your Honor.
How would you propose we do this, Mr. Bloodworth? Play the video with the scrolling transcript for the jury nowish?
Yes, Your Honor. Maybe in 5 minutes-ish.
Sure.
state drank a lot of coffee.
No, you and I both. Let me make a ruling here and see if either side needs clarification.
Yes.
Mr. Bloodworth, as I understand it, the state seeks to admit and publish to the jury a 13-ish minute audio-visual recording of Mr. Crozier's interview with law enforcement in May of 2023. The recording is accompanied by the transcript that plays below the video in real time. Is that correct?
That is correct, Your Honor, and it is labeled 8-64, D as in dog.
Okay.
The state drank a lot of coffee this morning.
864,
Thank you. Having had the opportunity to listen to Mr. Crozier's sworn testimony in open court, and given that defendant had the opportunity to cross-examine Mr. Crozier when he was on the stand, has had the video, and that there's no evidence before the court currently that Mr. Crozier is unavailable to be re-subpoenaed and brought back into the courtroom by defense if they determine it's necessary to do so. The court determines that Mr. Crozier's half of that interview with law enforcement from May 2023 is admissible as categorically not hearsay under Rule 801D1A because he testified under oath that he couldn't remember the statements he gave during that interview.
What about the
And
Russian doll
therefore,
hearsay?
the statements that he makes in the interview qualify as statements regarding which he has forgotten, quote unquote. The court will instruct the jury that they cannot consider any portion of the law enforcement side of that interview for the truth of the matter, which resolves any hearsay issue with regard to the law enforcement half of the interview. Mr. Bloodworth, any clarification?
No, Your Honor.
Ms. Lewis?
I don't like it.
No, Your Honor, nothing.
Okay. It will be.
You're basically saying
64D, as in Delta, is admitted on that basis.
One half of this.
Let's take a 10-minute break. This clock in here shows 20 of 11. We'll come back at 10 of 11. Thank you.
Before we recess,
Yes.
may we get just the lineup, just so while we're on the break, we can take advantage of that and be prepared for whoever.
Who's coming in after
Yeah,
that?
it hasn't changed from what I emailed you on Saturday, so I think.
Okay, perfect.
Yeah.
All right, folks, 10-minute break. Thank you. Court's in recess.
That's a little power move, forcing the other side to answer your question in front of the judge, and the state says it hasn't changed. It's the same. It might still change, but it hasn't changed yet. All right, so I don't like it only because the jury is going to hear a lot of comments from the police that they're not allowed to consider, but they are allowed to consider the other parts. And I don't like it because my juror brain has a hard time partitioning that off and saying, okay, wait for Robbie. Now Robbie's talking, I can consider that. Nope, Robbie's done talking, now I can't consider it. I don't like the split between those two, especially when you've got nested hearsay, the whole Russian doll idea. We've got the cops telling you what other people said inside there that also can't be considered for the truth of the matter. As difficult as it was, I really think they should have taken this and chopped it up. Chopped it up so that you got just the question and the answer. And as messy and as spliced as it would be, I think it would be a lot cleaner than having all these comments, in the 13-minute period. I don't think Robbie just free spools and just talks for 13 minutes straight. We're going to have a lot of state, police discussion in there that the jury needs to chop out. Jury would have objected to rule of completeness, but it's a hearsay thing, so you can't. I don't know. I don't think they want it in, but I guess they do want the state's part in because it makes the state look bad sometimes. Personally, I'd consider it all, says Mary. Just play it. All right, a couple things I wanted to talk about here just briefly. With Dr. Christensen, talking about the drugs and the street level drugs and what they see with the the mixture of the illicit drugs and how they're made to look like the legal pharmacy version, and how prevalent fentanyl was. That was insightful. That completely blew Robbie out of the water when we're talking about whether or not he was buying scripts off people or if he was buying illicit stuff. He has no clue, especially with what we heard there. The Seroquel in his system, and it's funny how Kouri, nails the drug pronunciation and then pretends to not know how to say it every time. But the Seroquel that was in his system, I believe Kouri had a prescription for that, and that shouldn't be there, but it was. And she's trying to say, is that something they do? They mix these two? No, he was like, no, that's not a thing. Nope, that's not a thing. That looks bad. And what looks even worse for Kouri is her emphatic no when asked, does Eric abuse drugs? Does he use fentanyl? No, like definitely no. Of course not. Compare that to the walk the dog letter. So we'll just keep that in your mind as we're going forward. All right, Dr. Christensen was good, says Wager. I thought he showed no bias that I saw, and he was just there to report what he saw and knew. Yes, and I especially like that he had a phone conversation with Kouri. We got to hear it, and got to hear Kouri sort of giggling and laughing her way through questioning, feeling the waters out, and like, what do they know? What did they find out? What's the supplementary report? What does it mean? What does it mean for me? She had said it doesn't change anything. Obviously, Eric's dead. It's not going to bring him back a new report. But she was very curious as to every aspect of that and where things might have come from. Kouri acting not to know her own medication. Yes. That's bad. She's got a script for it herself, and Seroquel is in his system. Let's see. I wouldn't be laughing if my husband died. I know people handled grief differently. I personally don't think I would as well, but that alone is something that I can't fault somebody on. The way they handle grief. Grief hits differently, and sometimes we're in a position where we can cope with it immediately. I've seen people who have lost a lifelong partner, and because of their mental preparation and knowing ahead of time what was coming, and when the expected thing happened, their grief was almost relief, especially when there's a lot of suffering and pain involved. And that I've seen other people who just felt it appeared from the outside like all of their heart was ripped out when their spouse suddenly died unexpectedly. And some people in that situation have been able to just be like, look, I can't deal with that. I can't deal with this right now. It's happening, okay? So I'm just going to keep functioning in life the way I know how. And at some later point, I'm going to allow myself to grieve and look at this. But right now, I just have to get through today and move on. So not knowing how it was, I can't fault her with that. Let's see. She was definitely relieved. All I care about is Kouri asked for and got strong drugs. She has given up who she allegedly bought them for? No, it was a client, just some client, right? Yeah, might never hear about that client. Was that recording taken from Kouri's phone? It looked like a recorded video. I believe it was. I believe she recorded that in her effort to figure out what was going on with the investigation that she would need to maybe reference. There are a couple things in there that turn up later in her conversations with people, specifically cartel. I think that shows up in the walk the dog letter. The doctor brought up cartel as a source for something, and she glommed onto that, and that'll come up later. Let's see. Under Cruft's Legacy says, I found it strange he wasn't shocked about the fentanyl being present, despite the fact that she also said in the call he doesn't use drugs. Such an odd reaction, just to accept it. Yes, but do remember this is a supplemental report. So she's already had one report that gave this indication first, and this is the supplemental one. So a lot of this is not new. Some of it is. Under Utah law, she's still responsible for murder if she intended to buy Roxy's and accidentally bought fentanyl because it was illicit, and she gave it to him. Let's see. If Kouri testifies, she's not going to testify. She's going to tell us the drugs were for Eric. Let's see. My dog got run over, and I wasn't home when it happened. I got depressed, and my grief was crazy. I didn't cry until he received her ashes. Yeah, I have a hard time judging people on how they grieve, mostly because I don't know how to do it myself. The difference is expected versus unexpected. I lost my husband in an accident. It was devastating. He was 41. I am sorry, Julie D. I'm truly sorry. I definitely, there's a big difference there. Didn't the Walk the Dog letter say to have Robbie testify a particular way? I think we're going to see that part of the letter. I hope we get to read all the juicy parts. It's going to be good. Hopefully parts that say, have him tell my lawyer, those come in. Tell Sky. Sky was the lawyer at the time. It's a great letter. If you haven't seen it yet, it's amazing. Also where she got the Mexico idea being, he said it's an illicit cartel drug. Yeah, we have read the entire letter online. We've got a read through. We're not going to pull it up right now just because we're so near court. We're in the trial that I don't want to present stuff to people who are following along as if they were jurors that might not come into court that the jurors wouldn't see. So parts of that letter might not come in. So let's wait till it comes out in court. If it doesn't come out in court, we might revisit it again after the trial. Camilla, also, for the same reason, I understand that. Who grieves by looking at celebratory gifts? I call them gifts, by the way. Just hours after death, though. I think we can judge that. Yeah, I'm rich. I'm stinking rich, right? Let's see, when I lost my daughter, stillbirth, I didn't really react till I was home and calling funeral homes. It's just like I was on autopilot till I had to say it out loud. Let's see. Brain goes into a deep analytical phase where it's overloaded and I appear to be shut down. Recognizable grief comes later. You can't spell grief without gif. There you go, Greeners. That's great. That's just great. Let's see. Eric hunted in Mexico, but Kouri has implied that he was there for dope. He hunted all over the world, just looking at the mounts that he had in his house. I mean, the giraffe. You know how far you have to go to get a giraffe? It's not here. I can tell you that. It's not one of the states. Is Walk the Dog letter code? And what is this letter? Elizabeth Goodyear. Yes. We call it the Walk the Dog letter. Actually, on the thumbnail, let me see if I can pull it up really quickly. I'll show you. On our thumbnail of... When to cancel. There we go. Here, let me switch to Media Player 1. This is our thumbnail. And it's actually underneath me. You can't see it very well. But the letter, that's literally a picture of the Walk the Dog letter that we used on our thumbnail for this trial. There we go. It's a letter that Kouri wrote and we believe was going to be shown to her mom, because it's written sort of speaking to her mom, shown to her mom at a visiting time where it's held up to the glass and her mom could either read it or copy it down on her side. And then presumably the letter would be destroyed on Kouri's side after she got back to her cell. But it was found during a search of her cell. But the circumstances and how it was found, it may have been included in documents that were labeled for her attorney only, which normally those would be privileged documents. The officers shouldn't be able to look at them, or once they ascertain that that's what they are, they shouldn't be able to look at them. So there was a big battle prior to this trial, rulings about that, and we're going to see how much comes in because of that. All right. Let's see. I need to turn this back on to tie that in. Got it. All right. 91 objections so far. Possibly a little more this afternoon. The Walk the Dog letter is Kouri's coaching witnesses what to say to cops. And not just, I mean, this is like textbook witness tampering. It is so bad. And then her defense said it was just a script. It was a manuscript for a book she was writing, but it has like her lawyer's name and then all the witnesses' names, and it was so bad. Yes, right now sound effects are broken for the most part. What I did is I formatted one of my SSD drives in my NAS storage for Windows instead of Mac. And I rebooted my NAS storage based on that drive. And now my PC can see it, but my Macs can't. So I broke the funny buttons. We'll get them fixed. That one works, but I've got them turned down a little bit. I missed the land to the plane. I'm not even sure if we have that one. Do we ever have a land the plane soundbite? It was a long time ago. All right. Let's see. Janet says, I'm curious, is her mom involved too? Her mom has not been charged with anything, although there's lots of questions out there.
I think I'm about to catch her.
Zimmy123 says, Kouri will sink her own ship with her own words. Zimmy, by the way, I think you were first or second in chat today. Congratulations on that. Kouri will sink her ship with her own words. A lot of the damning testimony we're going to hear in this trial is...
You are banished from the state of Georgia.
Okay, guys, here we go. Is straight from Kouri. So it's going to be interesting on that front. All right, the judge said we'd be back 3 minutes ago. Clearly we're not. So let's see if this is taking just a little bit longer. He said 10 of us when we were going to come back. I found the funny buttons that work. How rude to pick on Georgia, of course. That was who was the judge that said banished from the state of Georgia? I know it's the not relevant judge. She normally says stay out of Fulton County, but McBurn. I think it's McBurney or something.
This is not Burger King. People do not get to have it their
McBurney.
way.
I think it was McBurney. Another great judge with a great voice. Has anyone ever had the commands pop up in your head while having a basic conversation? Happened to me over the weekend with my hubby. You just wanted to play a command in the middle of the conversation? That's funny. What I'm going to do is I'm going to move all the commands off my NAS storage onto my computer so it doesn't have to make that jump. And then it'll work.
In front of the Walmart.
But to do that, I have to mount one of my hard drives onto USB and copy and stuff. I just don't want to pull it out right now. I can. All right. Loving this extra monitor. I wish you guys could see it. Look. If I turn the screen, you can see I've got another monitor right back here, and it lets me see live the hyperdeck and see how much space we're taking up with our recording. So it just makes me a little more confident in how things are going with that. Your screens are like a clown car. You move one slightly and another screen appears. I've got screens stacked on screens. Funny you mentioned that, Laura, because I'm doing some volunteer work with an organization that needed 4 new computers installed. So I went and set them up over the weekend, and in return they're like, oh, and by the way, can you decommission these 7 computers? So I took 4 computers down, brought 7 computers back, and I just had monitors everywhere in my kitchen over the weekend, just trying to get them all drives wiped and everything to get shipped out. But they're all going to be recycled and everything. Do you think the case will go to the full amount allocated or wrap early? Bobby, I wish we'd get an indication right now of where we stand. Speaking of standing, I think the judge will be in here in just a minute. I wish we knew time-wise if we could just get that, just a clock check, and see if here we go. Are we where we're supposed to be right now? Because that's the indicator. I think the defense agreeing early on, right, like basically day one of this trial, that they were going to stipulate to a lot of things, sped this up probably by a week. A lot of witnesses, chain of custody stuff that is very time consuming and monotonous and not really probative. They're just going to stipulate to that being allowed in evidence. So that's huge. So we probably would, I'm thinking we're about a 4-week trial right now. There's the judge. Takes a sip of whatever the good stuff is he's got in his mug. All rise for the jury. Here we go. There's Selena in the green with the glasses, sort of behind Kouri, 2 rows back. That's our court watcher. We expect to hear from her on lunch. We'll save the phone opening for that.
All right, have a seat. We're on the record. Mr. Bloodworth, I understand, will be admitting State's Exhibit 8-64D, a recording of a May 2023 interview with Robert Crozier. Is that correct?
That is correct, Your Honor. The state moves to admit and publish 8-64D.
Ms. Lewis, any other objection other than the one I've already ruled on?
No, nothing further.
Okay. State's 8-64D is admitted. We'll get that queued up now.
Might have to unplug it and plug it in again, Judge.
Please proceed.
Robert?
What an opening.
How are you? Confused. I imagine you are. We'll get to why we're here in just a minute real quick. But let me just get a little bit of basic information from you, okay? How about an address for you? 216 East.
Well, he gives it out.
What city?
Your Honor, I'm so sorry, but you were going to give an instruction?
That is true. I appreciate that. Thank you for the reminder. Ladies and gentlemen, Mr. Crozier's side of this interview, this conversation, you may consider that for the truth, give it as much weight or as any as you determine it deserves. There are other speakers during this conversation. So the other side of the conversation, there may be 2 or 3 other people on the other side of the conversation. You cannot consider any of what they say for the truth. The only thing you can consider them for is to explain why Mr. Crozier is responding or to provide context for his responses. But the non-Robert Crozier side of this conversation is hearsay that cannot be considered for the truth. Anything further, Ms. Lewis?
No, Your Honor.
Okay. Please proceed.
Seems like we've lost the audio now.
That's all right. I'll fix it.
Try to move out of the way so you guys can see the transcript and follow along. Judge wants to
Scott, please give it a try.
And a phone number for you.
Summit County.
Yeah. We'll get to it.
I'm about to say, I haven't been in Summit County.
I know you haven't, but you've had involvements with people in Summit County that we're looking at. That's what we're here to talk to you about.
What?
Phone number for you, Robert.
He's trying to remember his phone number.
I couldn't even tell you. I'm so confused right now.
Okay.
I really can't. My phone's new anyways.
Okay. Don't know your phone number then?
No.
Okay. So we'll get to why we're here to talk to you in just a minute. But before I do that, I'm going to advise you of your rights because you're obviously in custody here in jail, okay? So you have the right to remain silent. Anything you say could be used against you in court. You have the right to talk to an attorney, have him with you during questioning if you wish. If you can't afford to hire an attorney, one will be appointed for you before questioning. And if you decide to answer questions now without having a lawyer here, you can stop questioning anytime until you've spoken to a lawyer. You understand those rights I've explained to you?
Sure.
Having those rights in mind, you want to talk to us today?
I mean, talking now.
Okay. So we're here to talk to you about a transaction that you made a little over a year ago with a female named Carmen Lauber that Nicole put you in touch with. You met her at a Maverick and Draper on 2 separate occasions in February of last year, so a little over a year ago.
Okay. It's not
Ringing a bell at all?
Not ringing any specific bells, no.
Okay. Well, let me give you a little more information then. So we've talked to Carmen, we've talked to Nicole. We talked to Nicole yesterday, got her phone and downloaded everything we needed off of her phone. You sold Carmen blues on 2 separate occasions there at the Draper Maverick. As a result, somebody died from that transaction. So we're not interested in jamming you up or anything like that. We're simply here for information. But we know that you sold those to them. We can prove that through cell phone records and that kind of stuff. But right now, your information for us is more valuable than you being charged federally with selling fentanyl that results in the death. I know you're in on some drug stuff. Do you know anything about the federal rules with fentanyl and M30s? And
I don't know anything. I know I've got a distribution of, I got a cop of 30 of them in December.
The M30s?
Yeah.
Okay. So tell us what you know. Like I said, right now your information is more valuable, but at this point we can prove, we know that you met with Carmen at that Draper Maverick on 2 separate occasions, sold her fentanyl. That fentanyl is then used in a death case basically, so we've tracked it back to this point. But we're not interested in jamming you up. We're here to try and corroborate information.
Corroborate.
Validate.
I know
what Carmen and Nicole have both already told us. So you're in the position right now of either telling us what you know about it and basically not hurting anybody because Carmen and Nicole have both already talked to us. We're tracking you here and you're verifying information that we have.
Okay.
Or if you don't want to talk to us, that's fine. We will pursue it federally because we know that you sold them the fentanyl that resulted in the death. So that's kind of where we're at.
Okay.
And I'm not trying to bullshit you. I'm just kind of laying it out exactly how it is right now.
So, I know who Nicole is.
Okay.
About a year ago.
February 5th and 25th is when Carmen messaged Nicole. Nicole gave her your information.
Okay.
Then you guys set up 2 transactions at the Maverick and Draper.
Okay. Of last year?
Yes. It's not this previous February, a year before that. It's been a bit.
Yeah. And to be honest with you, going like this, so I'm still quite a bit of this. So I'm not trying to be a douchebag or nothing, so it's hard to remember that much time passed. And do you have a number that she bought from me? Was it a quantity?
She said between 20 and 30 pills both times.
Okay. Then probably, yeah.
Do you remember going to that Maverick and Draper? Were you living down there at the time, or?
She lives, I want to say she lives pretty far away.
She lives in Heber.
Yeah, so like that was just where we were meeting. It was.
Where were you coming from? Where were you living at the time?
Man, I've been living a little bit everywhere. Okay. You know what I mean? The last couple of years. So
it's kind of ringing back. You're kind of getting a little bit more. Well, tell me what you can remember about it.
I remember Nicole calling me and saying, "Hey, will you be my friend?" And I was like, "Yeah." So that, and then she was like, "Oh, she wants a lot." And I was like, "All right."
Is 30 a lot for you, or is that a lot for Nicole? Or?
I think it was a lot for Nicole. It wasn't a lot for me, but
okay.
I was like, "All right." I didn't know anybody died. You know what I mean?
Yeah, and we didn't expect that you knew that. And like I said, that's why at this point, your information is more. We're not interested in jamming you up or the distribution of it or anything like that. We're doing our investigation. You're kind of just on the edges of it a little bit as kind of an involved player, as being a hook basically for it. We're not interested in jamming you up or anything like that, but we are interested in the information you have you provide to us that validates what people have already told us.
Okay, as far as I know, I met her just 2 times. I think I talked to her a couple more times after, but just to see, you know what I mean? Hey, you know, because when somebody's spending, you know what I mean, $500-600
is that what 30 would run about $500 or $600?
Yeah,
something
like that. Yeah.
Okay. And did you hit her up afterwards to see if she wanted more, or did she hit you up afterwards?
I think I asked her one other time, and then she just didn't.
She's like, "Hey, you looking for any more?" or something.
Yeah, something like that. And she just didn't respond to me. You know what I mean?
Do you remember how you contacted her? Was it through text messaging, Messenger?
I want to say it was through text messages, but I haven't had that. I haven't had girl's number in a long time.
What phone would it have been on?
My phone. Fuck. Maybe a 333-6156 number.
You still have that phone? No. Okay. The phone you have now is a newer one then?
Yeah.
Okay. Have you contacted that Carmen at all through that phone or anything? No. Do you know where that old phone would have been that would have had those text messages on it?
No, I lost that phone. a while ago.
Okay. But what did you think the phone number was, you said?
385-333, 615.
Okay. So with these transactions, when Carmen hit you up, what did she tell you?
She just told me that she had a friend that wanted, you know what I mean?
Did she ask for blue specifically or fentanyl specifically, or did she ask for oxys, or what did she ask for?
No. I think she might have asked me for blue. Man, I can't remember.
But you sold her M30s, right?
Yeah, I told her what, she knew what she was buying.
Okay, so she,
You know,
it wasn't like she's asking for oxys or something like that, and she got the M30s.
Right, no.
Okay. So
No.
she knew that there was fentanyl in those pills.
Absolutely.
Okay. Do you remember where you got those pills from?
I don't specifically.
Okay.
I don't
What else can you
specifically.
tell us about that? That's all we're here to talk to you about, was that transaction, those two transactions, I guess, a little over a year ago. We don't care about anything else, but what else can you remember about those?
She was with the older guy.
You remember what kind of car they showed up in or anything?
No. Well, I think one time it was like a truck. Like a white truck or something.
Okay. When you say she was with an older guy, do you remember about ballpark how old he would have been?
I don't know, 50s probably, basically.
You thought maybe one time in the truck, but you couldn't remember the other one?
No, so they were in a car the other time. I don't remember what car.
Okay.
Like the first time she was in the truck though, for sure.
When you guys were to show up at the Maverick, where would you go? Would you go around back to Maverick or just right there at
Just
that
right in
office?
front. Yeah.
Just a quick hand-to-hand.
Yeah, it's, hey, how you doing? You know what I mean?
And you just said about $600 or so is what you charge for those.
Something like that.
Okay. Do you remember? So I think she would have ordered more the second time. Do you remember the quantity on the two?
I don't remember the exact.
But you remember meeting her twice.
Yeah.
Okay.
I really remember meeting her twice because you guys told me I did it twice. I would have said once. Really.
But do you remember now they're kind of
Yeah.
jogged your memory?
Yeah.
Okay. Do you think of anything else about those meetings with her or anything?
No, those are the only two times I talked to her.
Okay. How do you know Nicole?
There was a dude named Cam. I was staying with him, Roy, for a while. And she stayed there for a little while, and then she took off, and then Cam's a fucking widow, and we all ended up taking up one point or another. So.
Okay. So Nicole just hit you up and said, hey, would you want to meet with my friend?
Yeah.
You're like, yeah, that's cool. And you were in the apartment. Did she call you or text you? Do you remember?
I believe she called me.
All the time or just that one time? Or?
I think she would she would text me like, hey, what's up? And then one of us would call the other one.
Like, hey, I'm Nicole's friend or whatever.
Yeah.
Okay. All right. How long was your? Like, hey, I'm Nicole's friend or whatever.
Yeah.
Okay. All right. How long was your?
I think she would she would text me like, hey, what's up? And then one of us would call the other one.
Why are we looping?
Would you press pause? We'll fix that.
Yeah.
My apologies. Go ahead, Scott.
Out there, or drug court or some shit, wherever she was living. She was on, she was either on AP&P or on drug court or something. I don't remember, and she had to hurry. It was always in a hurry, she was like, okay, well, I'm leaving here now, so I can meet you halfway. Can you meet me halfway? I'm like, yeah, I can do that.
And halfway was that Maverick there at Draper?
Yeah.
Okay. You said one time she came with an older guy. Do you remember if that was the first time or the second time?
I believe it was the second time.
First time, do you remember if she showed up with anybody?
I don't.
Okay. Okay, I think those are all the questions we had for you. If we have any more follow-up questions, you want to talk to us again as we kind of progress with this a little bit further?
Yeah.
Okay. Well, I appreciate you talking to us, Robert. Like I said, we're not here to jam you up over anything. We're just here to try and get some information and see what you
I
got.
don't fucking one day wake up with some fucking manslaughter charges.
No. We're not going to pursue that. Like I said, if you didn't want to help us out or anything, we kind of have this for you right now that the people we're interviewing, we've got enough information. We're just trying to verify it. You're kind of either helping us out or you're not. And if you're not, you might, honestly. But all you've done right now, so we've already talked, Carmen's already talked, and Nicole's already talked. So you're not telling us anything we didn't know. You're not protecting anybody by not talking to us. All you'd be doing is basically rolling the dice with your future if you didn't want to talk to us, is essentially. Because when the deaths are involved, the prosecutors do get a little spun up over it. And with fentanyl in the federal system, if you don't know this, if you get caught dealing fentanyl that results in a death, you could potentially face federal charges. It doesn't matter if you intended to cause the death or anything else like that. They're cracking down on it. So I don't know how long you're in for with. I know you're on possession with intent stuff, but if you are still dealing, don't be dealing with that shit anymore because the feds are coming down hard on it, and it's only a matter of time, especially with how nasty that shit is.
And these, both of them gave me my name. I'm like, oh, yeah, we're going for Robbie. Nice.
Well, we'd already verified it through phone records. We already knew who they got it from. It wasn't like they told us anything we didn't know either.
Yeah.
We've been able to find everything we need through digital evidence, like all the contacts, all the messages on Facebook, all that stuff.
Yeah, we knew all of that before we made contact with anybody.
Yeah.
So it wasn't like they were diming you out or anything.
Yeah,
like
but I don't think me and Carmen even were friends on Facebook.
We actually were the ones that brought up your name to Nicole because we already knew that Nicole had put you in touch with Carmen, and we already knew all of that information. So we're just trying to verify stories is all we're trying to do at this point. So, do you have any questions for us or anything like that?
Other than this isn't going to backdoor me here?
No.
No. All right.
We're not here to jam you up or anything like that. We don't give a shit about what's going on down here or anything like that.
I was just going to ask you, do any of your people ever tell you what if they're going to use it for themselves, if they're going to try to sell it to anybody else? What their intents are?
Everybody that I deal with does it themselves. You know what I mean? Like, I do it myself, they do it themselves. You know what I mean?
Okay.
So it's.
Did Carmen ever mention anything about hooking it up for somebody else or anything like that?
Like I said, like she was just, like I met her twice, but you know what I mean?
Yeah, and I figured it was a long shot twice. You met her a year ago. I knew it was going to be a bit of a stretch for you to remember, but anything else you can think of or anything else you can remember?
No.
Okay. As you think about it, if you do think of something, let one of the COs know or one of the investigators here at the jail know. They'll reach back out to us if you think of anything else you want to talk to us about or anything like that, okay? Any other questions or anything like that for us?
That's it.
Okay.
Thanks.
Okay, go ahead. All right. We'll go grab the CO and let them know you're ready. Okay.
All right, that was quick and dirty.
Mr. Bloodworth, the state's next witness, please.
Your Honor, the state calls Molly Crosswhite.
Didn't seem very confident on her last name. Molly Crosswhite. She would be witness number, I believe, 22. Is that right? Or am I missing one?
Miss, if you would step in front of Brittany, we'll get you sworn in, please.
She's a green.
Can you please raise your right hand? Do you solemnly swear the testimony you're about to give in the matter before the court to be the truth, the whole truth, and nothing but the truth, subject to the pains and penalties of perjury? Thank you. Thank you. Please have a seat.
Thanks, Please proceed.
Thank you, Your Honor. Good morning, ma'am.
Pull the mic closer.
What, ma'am, is your name?
My name is Molly Crosswhite.
And is the last name spelled Crosswhite?
Yes.
Do you know who Kouri Richins is?
Not personally, but through this trial, yes.
Okay. Did you purchase a home from Kouri Richins?
I did.
When did you purchase that home?
It was January 26, 2022 is when we closed on that property.
Scott, can I get
The Midway
8-12,
House?
please?
That cute little one?
Your Honor, permission to publish. This has been admitted already.
What if she still lives there?
No objection.
Ms. Crosswhite, do you recognize that house?
I do.
Is that the home that you purchased from Kouri Richins?
Yes.
Did you ever move into that home?
No.
Did you rent that home?
I did.
When did your renters occupy that home?
They moved into the property March 30th of that year. Their lease began March 1st, but they did not move here till the 30th.
You said you closed on that home, I'm sorry, the 26th or 27th?
I think it was January 26th.
January 26th, 2022.
Yes.
And was that home occupied between the date of the closing and the end of March when your renters moved in?
It was not.
Were the locks on that home the same as they were on January 26th when you closed to the time your renters moved in?
They were the same.
And did Kouri Richins rehab that home for you?
Prior to us purchasing it, it's our understanding she had done a renovation.
And did she have the keys to that home throughout that renovation process?
I would assume so.
Am I right then, as far as you know, that home was unoccupied between January the 26th, 2022, and the end of March 2022?
That's correct.
Thank you, ma'am. That's all the questions I have.
Ms. Lewis.
Good morning.
Good morning.
She just turned her mic on.
So, oh, excuse me.
They coughed in it. Excuse me, ma'am. The water is for the witnesses. No, defense has their own water cooler.
So before you closed on the home, you entered into a real estate purchase agreement?
That's right.
Right. And can you pull up Defense Exhibit 1024, Katie? Thanks, Alex. Ms. Crosswhite, do you recognize that as the real estate purchase contract that you entered into?
Yes.
And do you know the date that you entered into that?
Looks like it was January 14th, 2022.
Your Honor, we'd move to admit Defense Exhibit 1024.
No objection.
Defense 1024 is admitted. Would you like to publish?
Sure.
Okay.
And then, Ms. Crosswhite, you closed on the home January 26th, was your testimony.
Yes.
Between January 14th and January 26th, did you do a walkthrough of the home?
Yes.
And what was in the home at the time that you did the walkthrough?
The home had been staged when they were marketing it for sale. So at that time, there was furniture in it. I think by the time we did our final walkthrough, which was a couple of days before we closed, all of the furniture had been removed from the property.
Was there anything else in the home once the furniture was removed, such as boxes?
Not that I recall. I don't remember exactly what was still there, but I do know that we had wanted the home to be fully vacated and all of the debris, and there was some garbage and things on the premises, like old cars even, that we had asked to have removed.
So do you recall if there were any boxes or cups or any items left in the closet of the home?
I don't remember.
Had there been, would you have asked that that be removed when you did the walkthrough a couple of days before closing?
I think that if it was something significant that we would really notice as a bunch of garbage or something that was going to be troublesome for us to remove from the property, we would have asked for it to be removed. Like a small item like a cup, I can't say would have stood out.
All right, that's fair. Now, you said the renters, their lease began March 1st. They didn't move in until the end of March. But was there work being done on the home during the time you closed and the time the renters moved in?
There was.
And particularly, was there work being done throughout February of 2022?
Yes, I think I provided a list of dates that was on record with our contractor. I think there was maybe 7 different days in February when there were contractors working on the property.
Okay. Would some of those dates have been February 10th, 11th?
Yes, that sounds familiar.
12th, 13th, and 14th? Does that sound familiar?
Yes.
All right. And you think there were additional dates other than those 5?
I think there was 2 more dates the following week, maybe that the 19th and 20th, if that's, I'd have to look back at the records, but according to my contractor's records, there was 2 more dates in addition to those 5 that you named.
Okay. And when they were working on the house, do you know if they were there all day, most of the day?
I don't know how long they were there. We were having things like insulation added into the attic and mortar added to the pot rock because there was animals coming into the home and things like that. We needed to get it ready for the tenants.
Okay. When you closed on the home, did you take possession of the keys?
I think that the key that was provided for us to access the home when we toured the property and made our offer remained at the property. I can't remember if it was hidden underneath, like somewhere at the front door. And we left that same key there for our contractors to use while they were working on the property.
All right. Did they keep the home locked?
I don't know.
Did you ask that they kept the home locked?
I would expect for them to. I mean, that's the point of a key.
Right. And the key wasn't in a visible spot, true?
No. I remember us having it hidden somewhere near the front door, maybe under a pot or under where anybody would think to hide a key. Probably not a great place.
Where everyone would look
to hide
find a key.
And it was your expectation the home would be locked throughout that time?
Yes.
Is that fair? All right. After you closed on the home, did you have any further conversations with Ms. Richins?
No, I never had any conversations with her directly. She was represented by another real estate agent.
Did you have conversations after you closed on the home with that agent?
I doubt it. I can't remember, but I would be surprised if I did.
Would you have been, would you have told them the work that was going on in the home and who was in and out of the home? Would they have been aware of that?
I think that prior to us closing on the property, we definitely communicated our plans. It was part of our negotiations because we discovered quite a bit of work needed to be done in addition to the renovation that Ms. Richins had done. So I definitely had communicated, hey, we're not going to be able to rent this out the way that it is. We need, I think it was a $10,000 credit so that we were able to, complete the renovations in a way to make the home habitable.
Okay. And is there any reason they would have known the Ms. Richins or her agent that you were talking to when, in fact, renters were moving into the home?
I don't know if we shared that or not. I know that we definitely communicated we could not rent it out right away. Okay. And we had to take care of quite a bit before we felt comfortable having people move in.
Have to evict the raccoons.
If I have one moment.
Raccoons are a nuisance animal. They're found pretty much all over the United States. Don't have possums. I'd hate to think it was rats, but porcupine, skunk, and raccoon would be probably the most common thing in the Midway area.
Just one or two more. Do you recall Ms. Crossway being interviewed by Mr. Bertram, in this case, the defense investigator?
Yes.
And do you recall telling him that when you took possession of the house, there was nothing in the house at that time?
Yes.
All right. And do you recall telling him at that time that you actually turned the key over to the contractors?
I don't remember. I never met the contractors on site, so I'm sure I did communicate to them where the key could be found on the property.
All right. Nothing further.
No, Your Honor.
Defense got nothing from this one. It would have helped if she said the house was completely
Yes,
empty.
Your Honor.
Yes.
Okay, you're free to go.
Then
Thank you.
it doesn't support the story that there was
Mr.
the whole
Glover.
box of cups in the cupboard.
Oh, Ms. Shervinick, wow, I shouldn't make assumptions. I apologize.
Allison Wright, Your Honor.
Let's do it.
Hey, mods, can you give me, just in mod chat, day 5, a list of the witnesses, day 5 and 6, and their numbers? I'm missing one in there somewhere. No rush, no rush. Thanks, Red. 1, 2, 3, not it, says Amber. I've got the best mods in the world.
Miss, if you'd step in front of Brittany, we'll get you sworn in. Right here, please.
Do you solemnly swear the testimony you're about to give in the matter before the court to be the truth, the whole truth, and nothing but the truth, subject to the pains and penalties of perjury?
Look at that arm. Just locked in. Other people have a little tentative raise, but she's like, boom.
Good morning.
Good morning.
If you could please state your name and spell your last name.
Allison Wright, W-R-I-G-H-T.
Ma'am, where do you work?
C&E Stonemasonry.
How long have you worked there?
Since established in 2010.
Did you know Eric Richins?
Yes.
How did you know him?
I first met him in junior high. He was a friend of my sister's. They were both in high school. He spent time at our house, and eventually we ended up in high school at the same time.
And is your husband, was his business partner? Is that
Yes.
correct? Did you know Kouri Richins?
Yes.
How did you know Kouri Richins?
When I met her when she was dating Eric.
I want to talk with you about a couple of handwriting items before I ask you a few other questions. That's State's Exhibit 8-49 for the record. Sorry, I've got too many things on my podium here.
It's a lectern.
All right. So I'm going to hand you this booklet.
Okay.
Okay, if you could turn to tab 4 for me. Do you recognize those items in tab 4?
Yes.
Is it, and if it's multiple pages, you can look through all the pages. Is it just the one page?
There's multiple pages.
Okay, and the first page is the one that you recognize, is that right?
Correct.
And go ahead and turn to tab 12 for me.
Okay.
And do you recognize those items?
Yes.
What are, in tab 4 and in tab 12, what are those items?
They are returned checks from C&E Stonemasonry's banking account.
And are those checks that you gathered and gave to Katie Richins Benson?
Correct.
And you gathered those from C&E's accounting books and things like that, their bank records?
Correct. The check on tab 4 was collected on an online banking, and the other ones were printed checks from our files.
What do you do for C&E?
Admin and bookkeeping.
Okay. So I want to switch gears. I want to turn your attention to February of 2019. Do you recall that time frame?
Yes.
Was there a time in February of 2019 that you took a vacation with Eric Richins and Kouri Richins and your families?
Yes. No, just the adults.
Just the adults, okay, no kids were there. And do you remember a conversation during that trip with Kouri Richins that stood out to you?
Yes.
Go ahead and describe for the jury what you remember about that conversation.
On our vacation, Kouri and I ended up alone for a moment, and just talking about our families, life, kids.
Your Honor, objection, can we approach?
Yes.
Ooh, you know it's getting good. We have an objection. It's getting spicy. You can't object to hearsay because it's a statement by the defendant. I wonder what she's about to say. This is objection number, let's see here. Number 92. I'll go up to 92 now. The approach for this one. Kouri's casting daggers in the direction of the witness stand.
Please stand up and stretch your legs. We'll invite you out of court. Please rise for the jury.
jury gets to leave. Do we get a voir dire? Might have a voir dire here. It's going to turn into a long break. That's what happens. What's the objection? Is this spicy?
Please have a seat. We're still on the record. Ms. Sherbanek, if you would just ask your next several questions, we'll see where this goes.
Certainly. And so now that we're outside the presence of the jury, we're just going to get a preview of how you would answer the question that I just asked you. So describing what you remember from that conversation with Kouri Richins from the vacation.
While we were sitting there, we were discussing life, and Kouri then explained how things weren't super great in her marriage, how she felt trapped. She explained to me that there was a prenuptial agreement that was put in place, and I had never heard of that. She continued to say how I think the trapped was mostly due to financial, is Eric would, because of the terms of the financial agreement, Eric would end up benefiting financially and continue to live as they currently were, where she would be in a different circumstance. She explained how she feared that the kids would be drawn to Eric's life and felt like she was unhappy in there, but feared what it would look like if she ended the marriage.
And is it okay if I ask a follow-up question?
Of course.
Did that conversation kind of give you context or inform you about Kouri, kind of what she was doing with her business at that time?
Yeah, things started to make sense. Like, I was impressed that she went and got a master's degree. Kouri's motivated, hardworking. I always admired that. And she was very motivated, it felt like, to become financially independent.
Your Honor, this conversation, can we get a foundation of exactly when in 2019 this conversation took place? Sometime in that year?
It was February, but
Mid-February. Okay. I think the trip started on the 17th. And
Yeah,
I'm not sure what day.
Do you want to have this discussion with the witness
I
present?
do,
Okay.
outside
the
if she
presence of
could
the
step
witness.
down and step out.
Do you want any more for recollection before we have the conversation?
No.
Okay. Do you mind just waiting out in the lobby for us for a
Yes.
minute?
Is this a new disclosure by the witness? Are we blindsiding the defense? What's the objection here? They don't want this coming in. It looks terrible. It looks terrible for Kouri. Goes to a lot of motive.
Your Honor, may it please the court. According to Mrs. Wright, this conversation took place in February of 2019. 3 years prior, more than 3 years prior to Mr. Richins' death. In the interim, in between 2019 and 2022, the Richins attended marriage counseling and worked on their marriage and a bunch of water under the bridge. This, to allow a conversation on a vacation in a situation where two women are just chatting about the condition of their marriage, 3 years, there's certainly no allegation here that Kouri Richins was planning to murder her husband 3 years in advance. Outrageously prejudicial due to the temporal distance in the statement that is being made. No relevance because it's 3 years prior.
Why isn't it relevant to show that Ms. Richins was aware of the outcome financially that would flow to her from a divorce based upon the prenuptial agreement?
She's aware of that when she signs the prenuptial agreement. They've entered the agreement that she signed.
This is, well, I mean, I think you've answered my question. It is relevant to show she's aware of it.
No, sir. The conversation in 2019 certainly isn't relevant. They have introduced a prenuptial agreement that she signed. It's clear that she knew.
I apologize for interrupting you. It's not clear because it doesn't, I have no evidence that she read it. I don't have any evidence that she understood it. Here, I have a witness saying she understood it, was aware of it, was fearful of it.
Felt trapped in it.
Was taking steps to mitigate.
Okay. If that's going to come in over my objection, certainly respect your ruling. We've made our record, but I would ask that all the rest of that conversation be stricken as too far away, about being trapped in her marriage, about being unhappy. Everything about that is utterly irrelevant and outrageously prejudicial. And we would ask that it be stricken and only be allowed to say that she discussed her prenuptial agreement, and that's it. And we also would like a continuing objection to any questions of this witness about any conversation in 2019. And we respect your ruling on that.
Okay, so
Nestor's good.
Defendant's objection to this series of questions of Ms. Wright is overruled. The testimony that was put on the record through the voir dire requested by defendant is relevant because it shows defendant's genuine subjective awareness of what she believed were the financial consequences that would flow to her if she and her husband divorced. It provides additional probative value because it shows that she was concerned about having less money than her husband if they divorced by virtue of the prenuptial agreement. She was taking steps to mitigate that potential potential financial effects. She was concerned about how her children might associate more with her husband by virtue of the lifestyle that he would be able to maintain in a post-divorce financial environment. That is all probative to the issues in this case, and it is not substantially outweighed by the danger of unfair prejudice.
Your Honor, can I also get a ruling just to avoid having to take another break when the jury comes back? Obviously, I have a right to go into her credibility and bias at this point, no matter what's being asked on direct, correct?
That's a very broad statement. You can certainly go into potential sources of bias.
Thank you, that's all I need.
Okay.
It's going to be spicy.
Folks, let's take a 10-minute break. We'll come back at 10 of 12.
Okay, so
thank you.
That surprised me.
No one is allowed to speak to Ms. Wright during this break. Please give her some space. Thank you. Court's in recess. All rise.
It's going to be spicy on cross. Ms. Nestor, first of all, is going to be the one doing the cross. And I'm actually surprised the judge let it all in. It did seem like this conversation encompassed more than just the acknowledgement that Kouri had a good understanding of the financial impact the divorce would have on her financially because of the prenup. Yes, I think part of it should have come in, but the whole conversation, you know when they do a voir dire like that, the wording of the questions incites, it sort of draws the witness to summarize, right? To give a summary. And then once the voir dire is over, the questions are asked in a way that encourages the witness to be more specific and share more details. So when we hear this in front of the jury, there's a really good chance we're going to hear a more spicy version, a bigger, a more elaborate version than what we just heard outside the presence of the jury, which means more is coming in, which means there will probably be an objection because it's expanding on what the judge already ruled on. I do like the judge's record. He was thorough that way. He definitely considered everything, but it does seem, well, very, very prejudicial. Ivan's going to give us a call here real quick. Let's see what we got here.
Call from
Ivan, my friend.
Hey man, how common?
Yeah.
How common are wives just like secretly joking about our murders and casual conversation amongst each other? This is the topic of the conversation
I think we need to do a poll in chat that only wives can answer because I'm curious.
This is a revelation I was not privy to. I didn't realize how common this comes up.
Okay, I'm guessing it probably happens when they go to the bathroom together, because that's like a gray area I just have no insights into. I rarely, when I'm out with the buddies, we're like, hey, you want to go hit the bathroom real quick? We just don't do that, right? I'm figuring that's probably what happens.
Well, I'm here to learn. I'm here to learn. And what's the statute of limitation on jokingly offing your spouse in day-to-day conversation?
I think they can hold it against you forever. I'm not sure. I'm not sure if there's like a legal statute of limitation.
Okay. I don't know. I just think this is all rank gossip, but I'm here for it. I'm glad the judge is just curious. This seems like silly. Are we going to just bring out imagine if every guy who we ever let off steam to got drug up there. I mean, at some point there's got to be, I don't know. I think it's silly, but hey, if we were going to give Robbie 2 rounds, we can bring on the silly.
It seems Ms. Nestor's argument about the temporal disparity between these two, that was a good argument with me. That resonated. And then when she just, doubled down, she's like, and keep it limited to this. And I liked how she presented her argument. That was really good work. She lost on all fronts though. And then because she knew she lost, and the judge knew she lost, she went for the sympathy vote. Well, if they get to do this, can you at least give me free reign to rip her a new one?
I got a spoiler alert. Got a spoiler alert. Ain't nobody like Kouri. Okay, there ain't nobody from the past who's, even if they did like Kouri, ain't nobody like Kouri now. So this is like a dead horse on repeat. I'm venturing to guess ain't nobody like Kouri from day one. Okay, people like Kouri aren't liked for good reason.
I don't know. But, I think a lot of people are distanced from her because of these accusations, but I think she had a friend circle like anyone else would. I mean, she had all the contacts and people. I think it's these charges that are causing people to be like, whoa, we probably ought to just cool it a little bit. I can't talk to you very much, which is sad, but because she is.
Well, I'm sure the idea of what Kouri did repulses a woman like who's on the stand now. Like it just like so this is your idea to just the thought of what even occurred is just sort of like inconceivable. Yeah,
I can tell you that the woman on the stand here is probably naive about a lot of things. She didn't know what a prenup was, right? She'd never what people before they get married they make an agreement about in case we split up. It was in her mind it was like you happily ever after. So yeah, there were some differences there, but interesting.
Yeah, it's well, and Kouri's just as naive. That's why she had to use people like Carmen and Robbie. Like, let's get real. Like, we all have our naiveties, that's for sure. And worlds we just aren't members of, and yeah.
I don't know how naive Kouri was, because she started doing a lot of work on her own. I mean, when we start getting into the hard money lenders she was dealing with, she was traveling in some pretty interesting circles then. So
yeah, but she's as dumb as a box when it comes to the world that Robbie's dealing in.
Let's be polite. Let's be polite. But I hear what you're saying. Yeah.
Okay. All right. I'm gonna go.
All right. Thanks. Love you, man. Bye. The judge has come back in. He popped in. We saw his head just briefly, so he sat down. We might be back before we know it. Well, we'll know when we're back, but we might be back before we expect it. Wonder if Kouri or Eric initiated the idea of a prenup. Did they say? I think it was Eric. Eric had an established business. It was doing well, and there's concerns. I guess he had concerns, maybe even early on. He met her at Home Depot. Are you serious? That's interesting. All right, Kouri used her position in life to use people outside her social standing. Could be argument for that. Ivan's calls are always fun. I'm always just hovering my finger on the mute button. You never know. No, I trust Ivan pretty well. We go way back. Let's see. Yes, she worked at Home Depot. I did not know that. She was his cashier. Let's see. Did she... Prenups are the norm in my family. They're in many parts of the world. They're the norm. The prenup is sort of like a DTR, define the relationship, trying to figure out where we're at. Well, let's get a prenup in place if we're moving forward. Judge is back. We're getting audio. That was a quick break.
Is Nestor ready for the jury?
Yes, sir.
Ms. Sherbanek?
Yes, Your Honor.
Okay.
Bring the witness.
Yeah. They can come in when they're ready. You have a glass of water?
Yeah, thank you.
Okay.
I'm going to have to check the closet picture we have from Kouri's closet and see if that was one of the sweaters in the closet.
All rise to the jury.
Please have a seat as you come in. All right, please have a seat. Ms. Sherbanek, please proceed.
So, Ms. Wright, before we took our break, I had asked you about a conversation you had with Kouri Richins on a vacation you took. When did that vacation take place?
February of 2019.
And what was that conversation? Describe for the jury what happened during that conversation.
Kouri and I were finally in a position where our husbands were no longer with us. We were just discussing life. We both have kids, our marriages, and Kouri opened up and shared that things were difficult at home. A word I remember is that she felt trapped. At this time, I learned that their marriage had a prenuptial agreement, and she explained that she felt like she was frustrated in the relationship, but also it would be difficult to leave. Eric would end up financially secure, and her the opposite. She feared what would happen in divorce. She mentioned that maybe the kids would prefer him with the lifestyle that they had, four-wheelers and toys and opportunities, where she would have less. She feared how she would be represented by him in the community. I felt for her. It was a hard conversation. I knew that things had been hard since their youngest child was born, and I was tender towards her current circumstance.
Thank you. And did that conversation give you any context to what was happening in terms of Kouri's business at that time?
Yeah, Kouri is super ambitious. She went back to school and got a master's degree. I was impressed. I had young kids. I wasn't sure I could do that. She then went and got a real estate license and was trying to build that business. That conversation kept playing in my mind as I think this is a way to become financially independent and secure.
Thank you. Those are all my questions for you. The defense may have some. Thanks.
Thank you.
May it please the court. Good morning.
Good morning.
This conversation you're talking about happened in Hawaii, didn't it?
No.
Where was it?
Costa Rica.
I'm sorry, Costa Rica. And the reason you all were talking about her marriage, there was a reason she was upset in her marriage at that time, wasn't there?
Not that I know.
Think hard.
Oh.
Crazy, she was upset. What I understood from the conversation is things were frustrating at home.
And that's because she believed he was having an affair with a coworker? Is that right?
Overruled.
Is that right?
She and I never discussed her thinking about an affair.
Is that the context of the conversation you were having that day, that she believed he was having an affair with a coworker, and that's why she was upset with her marriage and talking about divorce?
I don't recall that.
Were you aware of it at that time, that there was an affair going on between Eric and a coworker?
I don't recall that conversation versus when I found out.
When did you find out?
She knew.
Or wait, I'm sorry, will you repeat that question?
When did you find out that Eric was having an affair with a woman that worked with him?
These are facts, not in evidence. Assumes facts, not in evidence.
Foundation. You got to lay foundation for this. I'm not sure this witness knows anything about it. Why don't you ask her?
You just testified that when you found out, you weren't sure if it was during this conversation. So when did you find out?
That's not accurate. You have to ask it open-ended.
Okay. When did you find out? Was it any time near this
It's the same
conversation?
Will you repeat that question with more detail?
When did you find out that Eric was supposedly having an affair with another woman in context to this conversation? Before, after, during?
I'm having a difficult time understanding because help me understand affair. Because, like, I think there was a friendship with a lady, but I don't know, so I don't know exactly what was going on.
Understood. That's fair. So let me rephrase
But
it.
it's not an affair, is it?
Did you become aware that Eric had intimate feelings towards a woman that he was working with?
Your Honor, assumes facts, not in evidence.
She's
Argument in the
asking
question.
whether this person ever became aware of it. Overruled. It's a yes or no question. Ms. Wright, could we start there?
Can you repeat the question?
Did you become aware that Eric, at around this time, 2019, had intimate feelings towards a woman, that another woman that he worked with, that was causing problems in their marriage?
I don't remember when I became aware of it.
Ballpark.
This Nestor's a bulldog.
I'm sorry. I think I'd heard of it like twice, and I don't remember. I'm sorry, I don't remember.
When you were having this conversation with Kouri, did you know at that time?
I don't believe I did.
All right, these vacations, you had vacations with Eric and Kouri on more than one occasion, didn't you guys?
Yes.
And then at some point, those totally stopped, didn't they?
Yes.
And what happened that made you guys stop going on vacations together?
COVID was the next year.
Besides COVID.
Our family life was busy.
In fact, didn't Cody and Eric have a big falling out? Your husband is Cody Wright, correct?
My husband is Cody.
And how does Cody Wright know Eric?
We were friends in high school. They went on to work together, broke off and started a business together, and maintained their friendship.
So they were business partners.
Correct.
And they both owned C&E stonemasonry together, right?
Correct.
And at some point, your families quit hanging out, personally.
We continue to go to birthday parties and like that kind of an event. No longer vacations. I think we had a vacation planned in 2020 that got canceled due to COVID is the one that I recall.
In fact, didn't Eric and Cody have a falling out over Cody calling the police on Eric?
Cody didn't call the police on Eric.
Did Cody provide testimony against Eric with relation to an investigation against Eric for
Objection,
violating
Your Honor.
hunting laws?
Lack of foundation.
Well, this is a different question.
Is this involving the giraffe?
Are you aware that Cody provided information to law enforcement against Eric for a violation of hunting laws? Okay.
Yes.
And Eric and him, as I would say, fell out over that. I don't know another word. Had a disagreement about that.
Yes, temporarily.
And you guys never vacationed together again after that, did you?
No.
All right. Now, you said that you did the payroll and the bookkeeping at C&E, is that right?
We have a payroll service company.
Oh, sorry, sure. Okay, but you do the bookkeeping.
Yes.
So you know how much money's coming into that company, right?
Correct.
And you know how much money's going out, right?
Yes.
And do you and your husband have joint, do you share your marital money, or does he keep his business money separate?
We share our marital money.
Pause for 1 second, Ms. Nestor. Go ahead, Ms. Sherman.
This is outside the scope of correct.
Sustained.
All right. Setting aside your personal financial affairs, you're very aware of C&E's financial affairs, correct? Because you do the bookkeeping.
Correct.
All right. And
Objection, Your Honor, this is still outside the scope.
no, it's not.
Yeah. Please approach. I'm not sure where you're headed here.
Whoa. Okay, so we just dragged in some, I don't know what it was, a wildlife officer citation that Eric had about violating hunting laws, where Kouri testified against him in the case against him. Kouri probably felt like he was telling the truth. It sounds like they were hunting together, or at least the Kouri had inside knowledge about what was going on. But we do know Eric was an avid hunter and hunted all over the world. Not sure. I can tell you, as someone who's been hunting and fishing, a lot of times a violation limits your rights to hunt in that area. So it makes you have to hunt elsewhere, like overseas. Next question.
Since Eric's death, you and your family have grown pretty close to the Richins family. Is that fair?
Objection, Your Honor.
Goes to
Outside the
bias.
scope.
Goes to bias.
Overruled. If you would please restate the question.
Since Eric's death, you and Cody have become very close to the Richins family. Is that fair?
I would say the relationship didn't change.
So you were very close to them before?
Yes.
All right. And it's true that since Eric's death, your husband has even accompanied them to court hearings and sat beside them. Is that right?
Yes.
All right. Have you?
Yes.
And I think everything else is going to be when we recall. Ma'am, we're going to recall you later, and we would ask that you're not released from your subpoena, and the judge will instruct you about that. That's all we have at this time, Your Honor.
Okay. Anything within the scope of cross, Ms. Sherman?
I could just have a minute.
Of course.
Ma'am, be worried. Be very worried. I'm sorry. I meant Cody, and I said Kouri. I apologize for that. That Kouri was with Eric.
Okay.
Or knew about the hunting.
Ms. Wright.
Not.
You're free to go
Excuse me,
today.
but Cody did, not
You're
Kouri.
still
So
subject
bad
to
at
the
this.
subpoena that you were served with. You may be called back. Between now and then, please do not speak to anybody about your testimony, including your husband, okay? And please don't watch any coverage of this case. Don't read, listen, watch anything about it. Do you agree to do those things?
Yes.
Very good. You're free to go. Thank you for your time.
Thank you.
Good time for a lunch break, counsel? Or do we have another short witness you want to get on and off?
What's wrong with their height?
Your Honor, we can break. I understand there's some legal issues to address too, so.
Understood. Okay. Any objection to a lunch break,
No, sir.
counsel? All right.
No, sir.
Please rise for the jury. Folks, quick reminder, you know what I'm going to say. Please don't discuss the case. Don't read, watch, or listen to anything about it. Please don't do any research. Enjoy your lunch. 12:40, counsel, is that reasonable?
Yes, sir.
Yes, sir.
Okay,
It's a
12:40.
40-minute lunch. It's a short one. Okay, the legal issues, I think the judge has to put on the record the whole mistrial call that Miss Nestor was involved with early on when the evidence witness talked about the jail calls for Kouri. That happened at
Thank you.
sidebar. Let's see if that gets put on the record here now.
We're on the record. Mr. Bloodworth.
Your Honor, we're going to quickly next call Detective O'Driscoll just for a phone download. He'll have perhaps more time later.
Okay.
But then it's Mr. Cochadimos, and I understand the defense has some objections related to Mr. Cochadimos.
Mr. Ramos, tell me more.
Thank you, Judge. I figured we'd do this just outside, that way we can speed things along. We've been provided with some exhibits that appear to rely, and correct me if I'm wrong, on some CDR data, call detail records, from Verizon and T-Mobile, I believe, and AT&T. Those items, we were not provided notice of their use under 901.11, and so we would just make an objection under that.
Forgive me. They were provided some reasonable time after being received by the state.
Yeah, no, the information was provided to us. We've had that for a while. Just notice of their use under that business record exception.
Can you give me that citation one more time?
Yeah.
901.11, he said?
Apologies. Rule 902.11, I believe is what they would be coming into.
See, 901 doesn't have an 11. To 11, certified domestic records of regularly conducted activity.
And specifically, I'm referring to the written notice.
Why isn't inclusion of these records on the state's exhibit list fair notice under 902.11?
Just based on the case law, Judge, I could give you a citation. I have two cases that I think are fairly on point. 32P3D 976, State v. Webster.
What's the other one?
And then 322 P3D 624, State v. Pereira. We just bring this up, Judge, now. We could have a ruling after lunch, is fine.
Judge is ready to rule now.
And that would be our only objection.
Okay.
Thank you, Judge.
Mr. Bloodworth, I made an assumption there, if you could just confirm it for me. These call detail records were in fact concluded among the state's proposed exhibits on its exhibit list?
Yes, Your Honor.
Okay. Anything further on this, sir?
Judge is ready to rule.
Yeah, right, Your Honor. Just to clarify that, they've been disclosed, and the disclosure included the certification from the whoever returned the subpoena.
Right. The declaration. I understand your point to be slightly different than the self-authenticating piece. Got it?
Correct.
Okay. Pause there for a minute. I'll take a look at those two cases, Mr. Ramos. We can pick this up at 12:40. After Ms. Crosswhite testified, and after we took that break, one of the jurors passed out the following note. I'll read it. I don't think this is an issue, but just letting you know.
It may be.
Quote, Judge, I have met witness Molly Crosswhite professionally. She has done one transaction for a home where I work. Any concerns, Mr. Bloodworth?
No, Your Honor.
Defense might dig this one. They go sidebar. Defense is looking for anything they possibly can on Molly. So I think they are going to dig into this and ask some questions, possibly pull the juror out, ask a little more detail as to what this is, because Molly's still retained. They're going to call her back, and they're going to do their best to destroy her. Well, let's see if they're going to dig into the Nestor's like, what?
my to-do list.
Sure.
Either following lunch or at the end of the day.
Mistrial.
May we address the motion for mistrial that you made at sidebar following the mention of jail calls by Ms. Gibson?
Yes, I'm prepared whenever you are.
All
Just
right.
let me know.
Let's do that after lunch as well.
Okay.
Thank you.
Okay,
We will be in recess
Lunch.
until 12:40. Thank you.
We've got some good stuff right after lunch. Okay, let me quickly, while they're in recess and they're talking, let me tell you, we're talking about the rule of evidence that Mr. Ramos cited, rule 902 dot, I think he said 12. Was it 11 or 12? I don't remember. But either one, they had the same word in he was reciting. Before the trial or hearing, the proponent, that's the person who presents the evidence, must give an adverse party, that's the defense, reasonable written notice of the intent to offer the record, and must make the record and certification available for inspection so that the party has a fair opportunity to challenge them. And this counts for both domestic and foreign records of regularly conducted activity, business records or certified records. So the judge saying, I hear you. Yes, you're citing the rule correctly, but how does them filing a document with you saying, here's what we're going to use and here's the certification, not meet that standard? Did you want like a separate letter with a little plaque that says, by the way, here it comes? I think the judge is going to rule soundly with the prosecution on this one, and it's coming in. If the state had just said, hey, by the way, we've just added this new evidence, we've just got this business record coming in, yeah, clearly it says before the trial or hearing, and we're during the trial. In that case, it wouldn't work. But I think I've got Selena on the phone. Just one second.
Call from Selena.
Hey, Selena, our court watcher today. How are you doing?
Oh, my goodness. This is a trial that just keeps on giving.
It is spicy today. It is spicy.
Oh, good grief. So, do you have any questions first? I'm just going to say what I wrote down.
Start with what you've got, and I might have a few questions, and chat might have a few that I'll try to keep an eye out for.
Okay, so Dr. Christensen was interesting. When the part that he testified, or that when the defense asked him, I just wrote the note. First thing, he met with the prosecution or investigators on a Zoom call with no one else on. I thought that was a little unusual, talking about the case. Usually there's both sides represented. Let's see. The hair testing that wasn't done, that was kind of interesting.
The end of that ended with them basically saying, I don't know if you can even test hair for fentanyl. And I haven't Googled that yet. It seems like he probably should know that. He in his position would know if that existed.
Exactly. Okay, and here is what came to my mind on that point is we all know he had a prescription for naltrexone, which is supposedly can be given for Lyme disease, but it also is a medication to help with addiction withdrawal. So, under the circumstances, I just wrote down, wonder why the hair was not tested.
Yeah, and that's
okay.
And I think that might go to the hindsight. He said, "Yeah, 2020, looking back, we probably should have done this."
Yeah, and I think there's a lot of things that you can do that way, for sure. Oh my goodness, let's see. Oh, the video interrogation of Mr. Kroger.
Yeah.
Robbie, I'm sorry, but it was so silent in the courtroom, I could barely hear him. I could hear the detectives, so
you missed out. Our copy was good. We were connected straight to the system.
I know. I wanted to be in my living room watching RA because I was
basically
straining
says,
to hear.
In that, he says he did get a fentanyl. He doesn't know if they asked for fentanyl, but he said if they got fentanyl, they had asked for fentanyl. They knew what it was. And he's not sure. It was almost like it was a surprise. He walks in there having no clue what they're going to ask him. He's like, why am I here? I'm just confused. What's up? And the police are like, oh, we're not going to get you in a jam. We're, just need some information about this. It's as long as you help us, you shouldn't be any charges, coming around to you. So Interesting.
The only thing I did hear is what the detective said, and they said the jury couldn't consider that. But I did I caught that he met 2 times. He said he believed he met to do a sale, and then I dared to hear the detective say, you're fine as long you won't have any federal charges, anyway.
Yep.
But then, real quick, so that I'm going to have to go home and rewatch because I couldn't hear. Molly Crosswith, who bought the home from Kouri, the thing that stuck out to me there is the key issue. The keys were turned over. Contractors had availability to that home.
Right. So
that kind of put a little question mark there on that, where the drugs were left there and the whole 9 yards. That the jury really keyed in on that.
And now remember that Carmen was working for Kouri. She would clean up. She was basically another contractor that Kouri would have working at that place. And if the key under the flower pot thing was a carryover from when Kouri was having it worked on, it would make sense that Carmen would have access to the house that way.
It was after it was turned over to the new owner.
That's the questioning. But if it sounds like they didn't change anything, it's the same locks they had before that Kouri Richins had.
Yes, true. They didn't. You're right. But I'm just saying more people than just Carmen had access to that home and knew where the key was. Because there were other contractors working on different things. The lady that she said that, Miss Crosswith, Molly Crosswith. Okay, anyway, I'm hurrying. Allison Wright was the last witness, and I did not keep my poker face, but I didn't get caught. When came up about her knowing that Eric possibly not
the affair, or at least some
the
interest.
affair. Yeah. Wow. And she knew about it, and she'd heard it 2 times, and she worked close with him. So that was, and then her husband turning him in for hunting law violations too, and they kind of had a falling out. But now they're close with the family. But I didn't see that affair coming from that he having one. We knew we've heard Kouri's whole deal, but that just kind of blew me out of the water, and I kind of my mouth dropped open a little bit, and then I'm like, poker face. So anyway, because that was totally not expected. Okay.
And then now after lunch, it's going to get spicy again. We're going to hear a couple things. We get to hear what happened way back on what was that, day 1 or 2? Let me just check. I think, day 3 with Chelsea Gibson when we had the testimony about the jail phone calls, right?
Yes.
That's when the mistrial motion was made. That's when Ms. Nestor's like, Your Honor, move to strike. May we approach? That part. We get to hear what was said there. Plus they get to argue.
Yeah, that's going after lunch that's going to be brought up. So
we know that not Molly, but Allison Wright is going to be back on the stand when defense calls her in their case.
That's going to be something.
I'd be nervous if I were her. Miss Nestor has shown a little bit of what she's capable of.
Miss Nestor, I don't think. Did you hear what the judge? She's like, okay, if that gets to come in, then I get to.
I get to cross her on credibility or bias or something like that.
Yeah, bias. Yeah, and boy, did she ever! She came out swinging.
Yep, and there's more. And so I'm not sure with what just happened with the juror's note. I'm not sure. Did you see that? The juror's note?
Yes, it was just okay. So the lady that talked about owning the home, the real estate lady that bought the home from Kouri.
Yeah.
One of the jurors had done a transaction with her.
Probably all the jurors were shown the names of witnesses pre-trial, and they probably didn't recognize it when they saw her walk in. Right. They're like, oh, her.
Yeah.
That's her name.
Yeah, and so both attorneys, both sides said, that's fine. We have no issues with that. So, but I think it was, the jury's very careful and very attentive and very, doing what they're ask, because, I'm sure they've been, if you recognize, but yes, you're right. I'm sure he was shown her as a witness, but didn't recognize her name. So anyway, or I don't know if it was he or she, but it was just one of them that had actually done a real estate transaction.
Well, it's going to get spicy. Today already the tensions are a little high in the courtroom, and they get to start right after lunch with a re-argument, or at least putting on the record their reasoning for the mistrial, which the judge denied, or at least took under advisement, didn't rule in favor of them for. When we're going to figure out which one that was after lunch. So you don't want to go anywhere. And we've only got 25 minutes before lunch.
Yep, I got to go. I'll let you go. I've got to
eat.
I got to throw some food in my mouth. And
Selena, thank you so much for being a court watcher. You're doing a fabulous job. Appreciate you.
Oh my gosh. I'll talk to you after court, but buckle up, Buttercup.
All right. Thank you.
Okay.
We'll see you.
Bye.
Bye. All right. We are not going to go anywhere. We're keeping the live feed going through the lunch hour. It's only 25 minutes. So basically I'm going to stand up and step away for just a moment, but then when we come back, we continue with what the judge just teased us with. Let's see. Ooh. Thank you. I just got a notice that somebody sent me some healthy snacks. So always appreciate that. Thank you. Let's see. This.
From the state of Georgia.
Hang on a second.
Call from Angela.
Hey, Angela. This is Scott. Caught me just before I'm headed to
lunch.
Yeah.
Yes, I'll be very quick. Am I the only one who realized that the person who brought the house from Kouri, she slit another motive that we didn't know? The whole house, so supposedly Kouri is this flipper person that loves to flip houses.
Right.
And yet she bought a house, flipped, and then sold a house to this person, forgot her name, sorry.
It needed a lot of work.
And then that needed a lot of work. So, I mean, if she's that good of a flipper, why would the new owner need more work?
I can explain this a little
bit.
I can explain a little bit because I have myself failed business in my history with flipping houses, so I know a little bit about this. It is not uncommon to buy a house and then sell it to someone else who will flip it before you finish the work. So it's a quick deal, and especially if Kouri was upside down financially, looking for a buyer who was interested in getting it at maybe a little bit of a premium because you hadn't put all the effort into it to get it ready to go. That makes sense.
But sure, that makes sense. But then also that's where the Eric's I don't want you to buy that other house comes in.
Oh yeah.
Because
if she can't do that little house in Midway, how's she going to do the mansion?
Yeah. And that's where is everyone ignoring this? My brain was screaming when she was saying this. I was like, oh my God, another red flag. Why is nobody saying this? Like, no one in the chat, I think, said this. I was like, how are people not hearing what I'm hearing? Is jury thinking of this?
That mansion looks good on paper. It is just a frame. It needed everything done to it on the inside. It needed everything. And her thinking, yeah, I'm going to buy it and you would just rehab it. It wasn't rehab. It was basically they poured the foundation for you and put up a few walls. And other than that, you're building from scratch on that mansion. It needed so much money put into it that it was never going to be a flip. That was Kouri's dream castle.
And she wanted to go for, my brain was just screaming, oh my God, I think the prosecution put her in the wrong place. I think they should have put her later on, so it comes in with financial crimes, because this kind of puts Eric's motive as to why he wants to stop Kouri from purchasing that other home.
Yeah.
I'm not a lawyer. I'm just thinking like a juror.
Yep. Angela, thank you very much. I'm going to grab a bite to eat. I appreciate the call. Thanks for the clarification on that.
Thank you.
We'll talk again soon, I'm sure. Have a great lunch. We'll see you.
Yeah, thank you. You too. Bye-bye.
Bye. Great stuff. We're going to break for lunch right now. So I'm just going to get up and walk away. I'll leave my lights on so you can see It's actually live. As we always have it, the courtroom audio is hot right now. So if they turn the sound up, you're going to hear anything that happens there in court. Let's see. DVE inputs 1. Let's go to 4. There we go. So the lights are flashing. You can see us moving. So I'm going to grab a bite to eat. I'll be right back. It's going to be spicy, so maybe get some spicy rice. I think that's going to be a great lunch if I've got some of that. A little bit of extra hot sauce today. Getting ready for the spice this afternoon. You guys, see you in a little bit. Bye.
When are we going to break for lunch, Judge?
You are banished from the state of Georgia.
Because he's the guy.
In front of the Walmart.
Don't miss the forest for the trees.
Thank you, sir. You're my new best friend.
I was kicked back, taking it easy.
There's nothing in the order that restrains you from talking to cats.
Thank you.
I think I'm about to catch a whooping.
I'm not a cat.
It's not your turn to talk. I'll tell you when you can talk.
Hush! Now I'm trying to have court. You don't raise your voice again.
And now let Murdoch stall it.
How does he do that?
Somebody just sent me a video of roaches fighting. I don't know who won. The zombie apocalypse may be upon us.
I saw a chicken fight.
You don't put a diplomatic plate on a hoopty.
What more do you need to see?
Is that correct?
Shame on you, sir.
I was kicked back, taking it easy.
Are we going to address subject matter jurisdiction?
You're talking about stuff that is not relevant.
Have them send someone with more experience.
Don't miss the forest for the trees.
Even a blind squirrel finds a nut every once in a while.
In front of the Walmart.
You are banished from the state of Georgia.
I was told council wanted to see me at sidebar.
Happy birthday. You look good.
I'm going to sustain my own objection.
Alex stole it.
I'm not going to argue about semantics here.
I'm the one who gets to say that. If they didn't, I would lose my mind.
This is not.
I was told council wanted to see me at sidebar.
There's nothing in the order that restrains you from talking to cats.
Thank you.
Even a blind squirrel finds a nut every once in a while.
In front of the Walmart.
Scratch all that. Oh, that was terrible. I apologize.
Have them send someone with more experience.
I don't like podiums, Your Honor.
The zombie apocalypse may be upon us. This is not Burger King. People do not get to have it their way.
You are banished from the state of Georgia.
The zombie apocalypse may be upon us.
I object.
When are we going to break for lunch, Judge?
It's bigger than you. It's bigger than me. It's bigger than all of us.
There's a lawsuit.
Don't miss the forest for the trees.
Alex stole it.
The zombie apocalypse may be upon us.
You are banished from the state of Georgia.
I think I'm about to catch a whooping.
Have them send someone with more experience.
You don't put a diplomatic plate on a hoopty.
Thank you, sir. You're my new best friend.
Shame on you, sir.
I'm not going to argue about semantics here.
All right, guys, I'm back. I'm just going to be working really quickly on trying to fix the commands that are broken.
Because he's the guy.
I was told counsel wanted to see me at sidebar.
Somebody just sent me a video of roaches fighting. I don't know who won.
Talking about stuff that is not relevant.
Something I'm doing there is causing my...
You don't put a diplomatic plate on a hoopty.
It's because my recorder did stop.
When are we going to break for lunch, Judge?
Okay, set network location. Black Magic Cloud.
I don't like podiums, Your Honor.
All right. We're getting ready to go back to court here in the Kouri Richins case, day 6.
Bigger than you. It's bigger than me. It's bigger than all of us.
Day 6 is halfway in the books, and we're expecting to start the second half with a little bit of spice and some argument, as well as putting some things on record about a mistrial request or an objection asking for a mistrial that defense made earlier in the case about day 3. Now is going to be entered into the record with probably a little argument just for the record by the defense as well. So good stuff. I cannot get the commands to work, which is weird. Let me stop the record just a second. No, don't have time. Got to keep it going. The judge is going to be back any minute now. I can't miss anything. I do have a safety, a failover, so I'm actually recording on 2 hyperdecks. So this is a hyperdeck with the red light lit right here, which you can't see because it's behind my stream deck. It's okay, I have another. The hyperdeck's recording here. I've got another one off to the side of me that you can't see, so we've got a fail safe in case one feed goes down, because we only get one chance to capture it live from our pool media feed. All right, let's see. Let's get me back on camera. There we go. Do you think they should get a mistrial? No, I don't think so. If for no other reason, it was elicited by the questioning of the defense. I think even if the witness knew that she was not supposed to bring it up, the way the questions were asked, it would have led her to believe that she was supposed to now. That's why she hesitated and was asking those clarifying questions. So I don't think it would be granted for any reason. Defense cannot cause its own mistrial, right? right. We do have a clean feed. If you like a feed without the commentary and without the chat on the screen, over at Top Mark Media. So you can go over there. That's our channel as well. You can watch it if you'd like there. There's just a handful of people, so it's nice and quiet. Lets you focus on the court without my voice or any chats on the screen. All right, here we go. In just a moment, we'll be back. The judge will be back, call everything to order. Jury will probably stay out for just a moment or two, maybe 10, 20 minutes, depending on how long the arguments are. So we have a little bit of spice, a little bit of stuff to put on the record, and then...
You are banished from the state of Georgia.
I just got banished. Are you calling us loud? Yes, that was loud. That was loud. Judge said he already denied the mistrial. They're just making a record of it. Does the state even have any fight left in them? Yes, today's been better, Joe. Today's been better. They've argued very well. Not everybody. One guy for the state today made the most inartful objection I've ever heard. All he needed to say was objection foundation, and instead he's like, "What are you even talking about?" Like that's what he shouted from the bench. What are you even talking about? The objection is foundation, and the judge helped him out a little bit. Yeah, thank you. Appreciate it. Glad that you're here. Glad that you're here. There's lots to come from the state, a ton, and a lot of it's spicy. You know when it's going to be spicy because the defense starts objecting before the witness even takes a stand. They have objections before they even get called. And that's when you know it's going to get spicy. Kelly, I should do a little ASMR. Yeah. No. I'm not good at that. I feel the video helped Robbie and hurt Carmen. Okay. I was thinking about it and bringing out that Eric was having an affair. Wouldn't that lean more toward a motive? It could, but then the timeliness and they went to marriage counseling between the two. I don't think that could be considered for that reason.
I'm not a cat.
I have a package that just arrived. I have no idea what... Oh, it's a light. It's a light from my wife's kitchen. One is broken and I'm fixing it. I'm fixing it. My marriage counselor is American Express. What's in your wallet? This is as close to AM radio as it gets, which is love. AM nighttime radio, of course, is what you're talking about, because AM radio transmits, the signal goes a lot further at night than it does during the day. That's when all the good stuff is on. Here we go. We're back. We're back.
We're back on the record in 231-500-139. Mr. Ramos, may we talk about the defendant's objection regarding the call detail records that I understand Mr. Kontradimos is going to testify regarding? Is that correct, Mr. Vladimir? Ms. Shervanek?
That's my understanding.
Kontradimos is the gentleman that they'll come in through?
I'm not going to be seeking to admit the call detail records.
I'm confused.
I imagine they were used for some of their demonstrative exhibits.
He relied on call detail records to create some of our exhibits.
Got it. Good enough.
But I'm seeking to admit the visual representation of those call detail records that he helped create, that he'll testify came from the call detail records, although the call detail records themselves, the state is not seeking to admit as an exhibit.
Got it. Okay. I've looked at the Webster case. It certainly talks about notice with respect to Rule 807, which has a notice provision, and case law talking about how that notice provision works. The Webster case doesn't mention 902 at all. I'm not sure I was following your argument, Mr. Ramos.
Explain yourself, sir.
Judge, the 902, 803 rules and those identified in the residual exception in Webster, they reference the same language, which is the notice language. That's what we were focusing on. I think Your Honor has enough to make a ruling.
Okay.
I understand your position.
Got it.
Yep.
All right, so under Rule 902, subsection 11, records that can be self-authenticating under that rule, before the trial or hearing, the proponent, in this case the state, must give an adverse party reasonable written notice of the intent to offer the record and must make the record and certification that makes the record self-authenticating available for inspection so that the other party, in this case defendant, has a fair opportunity to challenge them. All of those things have occurred.
It's coming in.
The call detail records and the certifications under Rule 902 that are included with them from the mobile service providers have been made available to defendant for inspection through the discovery process, and by virtue of the fact that those records have been part of, or at least the portions of those records that the state seeks to publish to the jury have been part of the state's exhibit list, the state has given the adverse party reasonable written notice of the intent to offer the record. The court finds that defendant has had a fair opportunity to challenge those records. Any objection to the admission of that call detail record information under 902.11 is respectfully overruled. Anything further, Mr. Ramos?
No, Judge. There will be through Mr. Kouri some testimony regarding the .pmg files or the GIFs. I would, at that point, probably ask to voir dire the witness, assuming they're going to be asked to be introduced to evidence. So I just let the court know now and based sure on that.
Hang on.
Which file type was that?
They're like GIFs. They're those.
You mean GIFs?
GIFs that were presented during the.
Oh, the pathways that link to those?
Correct.
Got it. Okay.
He says he's going to do a voir
Can I
dire of
ask
the
just
witness.
a general question, just to avoid, because I think it's going to come up. So it's my understanding that the extractions have now been put into evidence, correct?
The phone, yeah, not the physical documents,
But
of
the-
the extraction, but the testimony about who extracted or downloaded the phones, yes.
And we've put the phones in, but we have not put in the actual, we've not put in the reports, the
Celebrate
data
reports.
that's been fed into the Celebrate software platform. Is that in?
The raw data is not readable.
I know. The raw data is in through the phone, but is the Celebrate data that has been extracted by Ingtao, was that put in?
Not yet.
Okay, so if that's not in, how do we have from Coaster Demos, how can he put in the demonstratives that are based on that? Because it's just basically a different, it just makes it into a picture, but it's the data from what's not in yet.
So you have witnesses talking about the physical device containing electronically stored information was secured.
Correct.
You have testimony creating a chain of custody to the people that downloaded it through a two-step process.
Right.
The gray key, right, forensically mirrors that phone. And then Cellbrite is how, among other people, I imagine Mr. Katradimos would say, I was able to read and process and parse out, quote unquote, that information. Not everything on that phone is relevant, so not all of it goes in. We're going to see what parts the state believes are relevant through Mr. Katradimos. He hasn't testified yet.
So he's going to be allowed to testify what's the information that's in something that hasn't been put in yet. Because without putting in the extraction,
There is
it's
no
not
basis
readable.
to admit the extraction. There is a lot of information on that phone that I imagine is not relevant under
Sure.
401 or 402.
Agreed.
So there's no basis to put in the entire extraction.
So
It's
this
not
is-
like an encyclopedia.
Well, then this is getting to the core of what my concern is.
Yeah.
And I'm just thinking out loud to try to avoid wasting Coaster Demos's time. But let's say, hypothetically, we want to get some of the extraction information in at a later time.
Do you have an expert that has looked at those extractions with Cellbrite and can testify and lay foundation?
We do.
Okay.
No problem. But my question is whether our expert can do the same thing theirs is doing, which is relying on data they saw in Celebrate and parsing it out without the Celebrate extraction coming in. Because as long as we can do it too, I'm totally fine with this whole process. But what's worrying me is we're going to get to my side and they're going to say the extraction's not in, your expert can't testify. So I guess I just want to make sure we're all on the same page. The extraction doesn't have to come in as long as our expert has reviewed the extraction and they've laid a foundation for authenticity of the extraction, which, by the way, I don't think either side is challenging the authenticity of the extraction ultimately. But the same thing's going to apply when our side gets up and our guy says, this is what I pulled out of Celebrate. I'm going to use this in what we're going to present.
Are you talking to me or them?
I'm talking to you.
I'm not sure what you're asking for.
I'm asking if we need to have a hearing now about whether the extraction has to be admitted for all this to come in, or if the extraction doesn't have to be admitted, there's no problems.
The only reason we've talked, as I understand it, about the extraction process at all is to lay foundation for the expert testimony of people like Mr. Katradimos.
Perfect. So you will not require for Kostradimos to testify about the data that he read from the extraction. You are not going to require the extraction to be admitted into evidence. Because if that applies, then that applies to us too, and we're fine with that.
As long as your expert is an expert and doesn't say or do something else objectionable, I don't know who your expert is or what they're going to say, so I need to be a little bit circumspect here. But the fact that a copy of the extraction from Gray Key on a portable hard drive has not been admitted as an exhibit is not an impediment to this kind of expert testimony.
That is exactly what I needed to know, because if it is, we need to have a hearing on it, and if it's not, then there's no problem. But I just want to make super clear that we're all on the same page, that it doesn't have to come in for us to pull things out of it and admit it.
Yeah, I think we need to keep in mind the life cycle of these things. There's information gathering, there's chain of custody and information preservation, and then there's what's admissible and how it comes in.
Sure. The only reason it's just unique is because the phone itself, without the extraction, the hard data is not readable, as the witnesses have talked about.
Right.
I mean, like, if the juror was given what was extracted out of the phone, they couldn't do anything with it anyway.
You and I agree.
Okay, I just want to make sure that we don't do that wrong, so that the extraction, the hard drive extraction itself doesn't have to come in, and we can all pull pieces out of it that we want because the foundation's been laid.
Yeah, I want to be careful. You're saying the extraction. There are several.
There are.
I'm familiar with the ones for which foundation has been laid so far. I don't know whether you're talking about some other devices regarding which foundation has not yet been laid.
Eric, Kouri's phone.
This is, again, I feel like you're talking to the state, not me.
No.
Part of me feels like she's fishing
I think
for
we're
the
all in agreement that the
objection.
extraction doesn't have to come in. As long as the extraction doesn't have to come in and we can use pieces of it, I'm totally fine.
Provided sufficient foundation
Sure,
for the
to show it's
extraction has been laid.
admissible. To show it's admissible under other grounds, 401, 403, hearsay.
Authenticity, yeah.
Well, authenticity is an issue, right?
If you're talking about a device that we haven't talked about yet, you're going to have to lay some foundation.
No. Assume for purposes of this conversation, it's only devices that have been admitted. So they
So
should
for the
just
purposes
stalling
of
for
this
time.
conversation and putting aside other 702 related objections that the state may make when your expert witness is testifying, what's good for the goose is good for the gander.
I said
with
that.
respect to the extractions.
Perfect. Perfect. That's all I needed. Thank you very much for taking the time. I do think that's really complicated and strange because of the way that the extraction is a different data set than the actual guts of the phone, which is unreadable. So that's why I just wanted to clarify that. So thank you very much.
Why not give the judge the finger while you sit down, telling him his ruling's strange?
I forgot how that began.
Oh, the juror issue. We got to talk about the juror issue.
We can switch to that. Anything else regarding Mr. Kotradimos before he takes his stand? Ms. Shervanek?
Nothing from the state, Judge.
Mr. Ramos?
Nothing.
Okay. The juror note. Go ahead, Ms. Lewis.
Your Honor, we do have some concerns about the note that came out from the juror.
Yeah, I told you they would.
First off, I believe that had we had this information during jury selection, this juror would have been weeded out in the process because they had a business transaction with the witness. So now we have someone on the jury who I believe, based on our parameters, wouldn't have even made it to the final pool, so that's concerning. The other concern is we don't know anything about the interaction with Ms. Crosswhite, positive, negative. I did have to push back a little. That concerns me a little bit that, if he thinks very highly of her, that could be some bias, that I did have to get up and push back. And our position would be out of an abundance of caution, we dismiss that particular juror.
Are you prepared to address this now, Mr. Bloodworth, or do you need some time to think about it?
I would grant it. Dismiss the juror.
Your Honor, we can address this now.
I want to be transparent. I'm not going to rule in this moment. I will need to just take a look at what legal standards, if any, there are regarding this. But if there's anything you want to put on the record now.
Can I just add, I'm sorry, Brad. It is our understanding that Ms. Crosswhite went by a different name, so I'm not implying this juror intentionally withheld information. He may have known her by a different name.
Understood. Go ahead, Mr. Bloodworth.
Your Honor, I don't know that the jury note provides the court with sufficient information to make a determination at this point. It seems to the state that a little bit of voir dire would probably benefit the court, but based on what the information the note contains, I don't see cause to strike or dismiss this juror.
All right. Ms. Lewis, my sense of this is I don't need to rule on this right now. I can give it some thought. There's no harm in leaving the juror right where they are for the time being.
Agreed.
Okay. I won't lose track of this. Let me think about it for a minute. It may be that I just need to ask this person a few questions and then we'll go from there. Okay. Motion for mistrial, Ms. Nestor?
Sure.
So
Just
many
really
issues.
briefly. As the court will recall, during the time that I had Ms. Chelsea Gibson on cross, I was trying to lay a foundation to later get in some of the home wave calls that had been downloaded. According to her reports that we were provided, she was the individual who downloaded all of them and stored them into evidence. And I believed that I had to at least lay a foundation of authenticity if I later wanted to admit those calls.
They were the jail calls.
So I was trying to do that. I was trying to do it very carefully. I warned her to please copy my language. I looked right at her. I used very specific language. And her response was, "You mean the jail calls?" I understand things like this happen in trial. But the case law that's relevant, I believe, it implicates Ms. Richins' Sixth Amendment right to a fair trial. It affects the presumption of innocence because if the jury is aware that she's been incarcerated, there's been case law that says that can impact your presumption of innocence. There is a pretty recent case in Utah, State versus Bernejo, Bernejo. The site is 476 P 3rd 148, which acknowledges that evidence of custody status can carry the risk of prejudice. I will absolutely concede All the case law gives you so much discretion in this area because every circumstance is different, every situation is different. They really, really do rely on the trial court judge to make a call in the moment. You know, now we have this situation through no fault of mine where the jury now knows that at least for some period of time, my client was in jail and communicating with family, and she did use the phrase calls with an S to indicate there were multiple calls, although she didn't say how many or for how long, and I concede that. So we would, and also the case of State versus Atkin, Atkin, 135 P3rd 894. Again, there's a quote, it may be prejudicial in certain cases. Full disclosure, both of these cases, the court did not find sufficient prejudice to overturn the call the court made in the moment. I think actually Bernejo may have been not, that they weren't, they were challenging whether the lawyer was ineffective, I think, for failing to make a mistrial objection. If I'm not mistaken, I think that was Bernejo. So I'm not even sure the judge made a call on that case, but I do believe on Atkin they did. So based on the authority, the recognition that it can bring prejudice, based on the fact that this case did happen so long ago, so the jury would put 2 and 2 together and realize my client's been in jail the whole time, possibly. It's an inference that could be made. We did move for mistrial. I will state for the record, the court did provide a special instruction, limiting instruction, warning the jury not to consider that. That's one of those, you know, difficulties because it does then again highlight that that comment was made, but we were trying to do in the moment the least amount of damage going forward. I did agree to that instruction being made. I did not object to it because at that point I felt like something needed to be addressed. But that was the basis of the motion, and that's all the record we need to make.
Okay. Anything further, Mr. Bloodworth? I think I have this firmly in hand.
Yes, Your Honor. The state rests on the record that we made at the sidebar.
Okay, very good. The issue before the court is a motion for mistrial made by defendant following Ms. Gibson's reference to jail calls, quote unquote, during her cross-examination.
Now the judge is making a
court
ruling.
finds that that statement, while improper, was not intentionally elicited by either party. It was inadvertent. It was made in passing. It was a short, quick reference. It is relatively innocuous in light of both the volume of testimony that the jury will hear in this case over the course of 5 weeks. It is relatively innocuous in light of the fact that this is a homicide trial, and so it would not come as a surprise to jurors that the defendant in a homicide trial may have been in custody at some point in the case. And moreover, the court gave a curative instruction that specifically instructed the jury not to consider that comment and not to speculate about whether defendant was or is in custody at any time in this case. Based upon those findings, the court finds that a mistrial is not required. Defendant's motion is respectfully denied. Anything further on that, Mr. Bloodworth?
No, Your Honor.
Ms. Nestor?
No, Your Honor.
Okay. Ms. Shervinack, anything else before we invite the jury in?
No, Judge.
Ms. Lewis? Ms. Nancy? Okay. We're ready for the jury.
All right. Crisis averted. Trial may continue. No, you don't get your mistrial that you almost created, but the judge was nice and said you didn't. You asked the question twice, literally trying to get the jail calls foundation in, and then objected when she said, "Are you talking about the jail calls?" Yeah, that's that was something else. All right, Selena is 2 rows back, directly behind Our court watcher is directly behind the person who's behind Kouri Richins. So Selena's almost completely obscured. She's wearing the glasses and the dark hair right against the wall on row 2. That is our court watcher today, and we heard from her at lunch. We expect to hear from her as well at the end of the day today. Are we to 100 objections yet? I'm only up to 98. Let me show you what we've got here. Where's the jury? Out on the playground? It's taking forever to get in. Let's tie this and then go there. Okay, I've got 98 objections. That motion for mistrial, that was already counted before, as were the other issues we brought up today. So, Kouri's sweater is very nice. Let's see. I've got a picture from the crime scene of the closet, and I'm curious if the sweater she's wearing right now, I think it was in there. I think that was in the closet at the crime scene. So that could indicate that it might be her own clothes.
Folks, have a seat as you come in, please. Thank you. Please have a seat. Ms. Shervanack, the state's next witness, please.
Detective Jeff O'Driscoll, please.
Detective, let's get you sworn in.
Do you solemnly swear the testimony you're about to give in the matter before the court to be the truth, the whole truth, and nothing but the truth, subject to the pains and penalties of perjury?
I do.
Thank you. Have a seat.
This guy was very caustic in some of the interviews. He was not a friend to some of the witnesses who've testified already.
If you could state your name and spell your last name, please.
Detective Jeff O'Driscoll, O''DRISCOLL.
Where do you work?
Summit County Sheriff's Office.
How long have you worked there?
10 years.
What's your assignment with the Sheriff's Office?
I am a detective in the Major Crimes Investigation Unit.
During your investigation of this case, did you seize a cell phone belonging to Miss Carmen Lauber?
Yes, I did.
Was that in April of 2023?
Yes, it was.
Was that a black Samsung phone?
Yes.
Was the phone number on that phone ending 6127?
I believe so, yes.
Did you book that phone into evidence at the Summit County Sheriff's Office?
I think it was collected by crime scene technicians on the scene, and they booked it into evidence.
Did you later retrieve that phone from evidence and, with the help of Miss Chelsea Gibson, download that phone?
Yes.
Was that done using the Celebrate software?
Yes, it was.
Those are all my questions for you.
Within that scope, I don't think the defense has a lot to chase after. I think there will be more heated testimony with this.
Just to make
witness
very
later.
clear, good afternoon, sir.
Good afternoon, Ms.
You are the O'Driscoll, that's the chief investigator in this case, right?
Yes, ma'am.
Okay, that's all I have for now, Your Honor. Thank you.
May this witness step down, Ms. Shervanack?
For now, please.
Yeah, okay, very good. The state's next witness, please.
Chris Kotradimus.
So he has not been released. He will be back.
Sir, if you'd step in front of Brittany, we'll get you sworn in.
Please raise your hand. Do you solemnly swear the testimony you're about to give in the matter before the court to be the truth, the whole truth, and nothing but the truth, subject to the pains and penalties of perjury?
I do.
Thank you. Have a seat.
Please proceed.
Sir, if you could state your name and spell your last name, please.
Sure, it's Chris Kotradimus, Kotrodimos.
Let's go through your employment background. Where are you currently working?
I currently own my own business. I own a company called M20 Solutions.
What's that company?
We do investigations, training, and consulting for prosecutors, defense teams, and law enforcement.
This is an unpaid
Is
commercial.
part of that business focused on digital forensics?
Yes.
Prior to that, where did you work?
I worked in law enforcement. I started my career in North Carolina with the Raleigh Police Department. I worked there until 2003. I took a position with the Salt Lake City Police Department, where I worked there until 2017. My last 5 years at Salt Lake City were spent in the homicide unit. In 2017, I took a position with the Salt Lake County District Attorney's Office as an investigator in the homicide unit and worked there for just shy of 6 years until my retirement in 2022.
And that's when you started your own business?
Yes.
Were you asked to analyze phone downloads and phone records for this case?
Yes.
Were you asked to do that process, look at the phone downloads and the phone records for 3 phones belonging to Kouri Richins?
Yes.
1 phone belonging to Eric Richins?
Yes.
Phone belonging to Carmen Lauber?
Yes.
A phone belonging to Josh Grossman?
Yes.
And phone records related to Robert Crozier?
Yes.
Let's talk a little bit about your qualifications. What type of specific education or training have you received to be able to analyze all of this phone data?
Sure. As it relates to this case, I've taken some formal training. Of course, once you get the formal training, then you get a lot of your experience in the field, in practical experience using that training. I'm a Cellbrite certified operator course. I took that. I took the Cellbrite certified physical analyzer course as well. And then from the call detail records standpoint, I am certified and took a course in, it's called TRAX. It's owned by LexisNexis. It's a location and data analysis program for call detail records and geolocation.
Have you testified before as an expert in digital forensics?
Yes.
How many times?
At least a dozen times in major cases.
And have you testified for prosecution and defense in those cases?
Yes.
How many phones have you done analysis for in your time doing this work?
Phones, hundreds, and call detail records, I'm probably over 1,000.
Have you done downloads yourself?
I have. Yes.
For other cases?
I have.
So let's start, we'll treat it like a funnel. We'll start big picture. Let's talk about digital forensics. What is digital forensics?
The best and easiest way to describe it is the analysis of electronic devices. As it relates to this case, and my specialty is mostly phones and some computers.
So let's talk about specialties within digital forensics. What is, you mentioned that you're certified Cellbrite analyzer user
Yes.
or certified
Yes.
in that program. What is Cellbrite?
Cellbrite, they have several products, but generally what they do is they provide extraction tools to extract data from devices, and then they also provide analysis tools so that you can analyze then those readable files.
You mentioned call detail records. Is there an acronym we refer to those in shorthand?
Yes, CDR.
What is a CDR?
So a call detail record or a CDR is exactly what it sounds like pretty much, okay? It's a record from your carrier, from your cell carrier like Verizon or AT&T. And what it is it is a record of all your call details, so your incoming and outgoing calls, texts, data sessions, things of that nature.
You mentioned location analysis. How do you perform something like location analysis using cell phone data or CDR data?
Yeah, so you can map both, but prevalence is call detail records. So law enforcement can obtain call detail records that include location data with them. And location data is essentially, the carrier reports and maintains a record during their normal course of business which towers you're using, where that tower is located, and what antenna or sector of the tower that you're utilizing for that communication.
When you're analyzing phone data, what are the two main sources of that information?
Oh, so like for phone data, like in general?
Yeah, when you analyzed phones for this case, what were the two main sources of the data?
So the phones themselves, which is the content of the device, and then the call detail records, which are the communication records associated with those devices.
So when we're talking about call detail records, I think most people understand the phone contents. That comes from the actual device, correct?
Correct.
And the call detail records, you said they were stored by the carrier, is that correct?
Correct.
And the call detail records, would those be located on anyone's device, or are those solely maintained by AT&T, Verizon, T-Mobile?
Yeah, the records themselves are maintained by the carrier.
And what is contained in a call detail record?
There's a lot of information in there. There is typically a timestamp, so there's a date and a time that the communication occurred, amongst whom the communication took place, between which carrier or which numbers the communication took place. So, which phone numbers, whether it's incoming or outgoing, the duration if it's a phone call, and then of course the tower information, the tower location information.
Would a CDR record contain, for example, it would say a text is incoming or outgoing, would any of the content of those messages be in the call detail record?
No, not in a call detail record.
How do you start or how do you analyze the contents of a phone? What do you use to do that?
So in this case, I used Cellbrite Physical Analyzer.
And how do you use Cellbrite Physical Analyzer? What does that provide you to allow you to analyze the contents?
So Cellbrite Physical Analyzer is a software package, and what it does is it allows you to analyze readable files from the extraction. So the phone is downloaded, a readable file is created, you load that readable file into Analyzer, and then you can analyze those results.
How often is, are there other programs besides Cellbrite that can perform that function?
Yes.
Is Cellbrite the most commonly used one?
Yes.
Why is that?
It's very popular because it's got a very user-friendly interface. It's widely known, it's widely regarded. Analysts and people that do extractions and downloads and have learned that they can rely on the results of those. They're pretty good, and so it's commonplace in this industry, particularly in law enforcement.
So now you testified that you've done downloads yourself of some phones.
Yes.
Can the person doing the download, extracting that raw data from a phone, can they change the contents of the phone when downloading it?
No.
Can they manipulate it in any way when it's going from the raw data into the Cellbrite reader format?
No, I don't know of a way to do that.
Why might a cell phone be downloaded or extracted more than once?
Usually it's different products are being applied to the phone. There are software updates, but more importantly, there's different products that might be available to obtain more data versus the other, particularly.
When you receive the download report from the phone in the readable format, what is contained in that report?
In the report is going to be all the system files. So there's going to be, most importantly, is the calls, texts, the web history. There can be biometrics. There can be like activity, movement of the device, biometric information, web searches. There's pretty much everything that is contained in the phone that a user might utilize or it would be available in that download.
Can a download report show if there have been things deleted off of the phone?
Yes.
How does it show that?
Yeah. In Physical Analyzer, if the extraction software recovers something from a database that has been set for destruct or for deletion, it can find that and then repopulate it into the phone as to where actually into the report for where it belongs. And when it does that, in the program, it signifies that with like a small red X in a column next to it to let you know that it had been previously deleted from the device as an active user, or by the active, the active file. But the software has been able to go in, find it in the database, and repopulate it.
So if a user deletes an item, it might still be stored on the phone that can be pulled by that report.
Correct. They may not be able to see it and think it's gone, but it may still be within a database that can be retrieved and repopulated.
Now, is that possible for all items that a user deletes?
No.
Why not?
Some of those deletions are system files, and so they're maintained in the background. The average user would not, or probably be able to delete system files. They literally run the phone.
So if I'm a common user of a phone and I delete a photo, how long would it be kind of in the background of that phone and able to be downloaded by this report before it's gone forever?
Right. Well, it kind of varies, and it varies by, there's a lot of variation there. But typically, when an item like an image is deleted, the image itself, that process, the original, like if it was sent to you or whatever, and you deleted it, it would be gone from your view in the phone, but it would be in a deletion file. And so that deletion file eventually has to make room for more deletions, so then it pushes deleted files out to make room for more deletions, so that it can refill it. It only has so much room, so it has to purge that at some point. And that time can vary. More deletions are going to make that process typically happen more rapidly than less.
So if items have been deleted by a user and that phone gets downloaded in maybe that sweet spot where it's still somewhere in the background of the phone,
right,
that could be in the report.
It could be.
But if you miss that window, and then the item is gone for good and can't be found in one of those extraction reports.
Pretty much. Once it's deleted from the system file, it's a process called a vacuum. Once it's vacuumed out and those files are reduced, it's essentially, you're probably not going to find it.
Now, if a user deletes a text from a phone, from their own phone, does that affect how the text message would show up on the receiving end?
No.
Shifting over to the CDR, the call detail records, you kind of described what that is, and that it's stored by the cell phone carrier. How long is that data stored by the different major cell phone carriers?
They're all different, so they maintain their records for varying amounts of time. Verizon typically will keep call detail records for 18 months to 24 months, but they will only keep the associated location data for about a year, whereas AT&T and T-Mobile will keep that information for a much longer time.
Now, because this data is maintained or kept by, AT&T or Verizon, can a user access that information?
No, those are business records maintained by the carrier.
Okay, I feel like we have a good groundwork now, and I want to turn your attention to what you did, what you did in this case. Okay. When were you brought on to work on this case?
I came on in May of 2023.
And in general, what were you asked to do for your part in this case?
Analyze phone downloads and analyze call detail records for pertinent information related to the case.
And so you analyzed phone downloads for this case. And you talked about the process for doing that. Did you perform any of the downloads for the phones, in this case yourself?
The downloads, no.
And in viewing the download reports for the phones you analyzed, did you learn who the phone belonged to?
Yes.
How do you do that?
Well, besides the record or file being designated as belonging to that person, when you open the physical analyzer report, it gives details about the phone number, the IMEI number for the phone, and whatnot, and that can be matched to the user, whomever was using it at the relevant time.
As you analyzed phones for this case, did you generally become familiar with the people involved?
Yes.
Did you become familiar with what they look like?
Yes.
How did you become familiar with what these people look like?
Law enforcement shared that information with me, but in most instances, when I looked into the phone downloads, there are pictures of those people inside those phones doing various things, hanging out with family or, contact photos, that type of thing.
I first want to turn your attention to Eric Richins' phone. Did you do an analysis of Eric Richins' phone?
Yes.
And was that a phone with the number 801-792?
Yes.
Did you receive a download report from the Summit County Sheriff's Office for that phone?
Yes.
And was that download performed by Changi Entau and Marcos Garicachia?
I believe so.
When you reviewed the report for Eric Richins' phone, did you find any evidence of mass deletions on his phone?
In Eric's phone, mass deletions, no.
How would you be able to tell if somebody had made batch or mass deletions from their phone?
Usually, if it's not evident in the actual phone download, whereas you can actually see the software has reported that those items were found as deleted and recovered. Outside of that, you would compare it to other types of evidence, such as like the call detail records.
So how would you be able to tell if there were deletions when comparing the phone to the call detail records?
It's basic. You just take the call detail record and you look and you see who that person was communicating with through their call detail record, and then you would be able to verify if those communications were maintained in the call logs on the phone themselves. So if I called you 5 times today, it would show in my call detail record, but if you downloaded my phone, it would also show in my call log that I called you 5 times today and what time of day and how long our phone calls were.
Did you review text message conversations from Eric Richins' phone?
Yes.
And in addition, did you review device activity data?
Yes.
You mentioned biometric data. What type of biometric data can you recover from a phone or review?
Right, it's kind of hand in hand with the activity report that you just mentioned. When a device moves or a connected device moves, it reports that movement to the device, and it's found in that activity sensor report portion of the download.
Did you look at Eric Richins' phones for evidence of THC gummy use?
Yes.
And did you find text messages between Eric Richins and Kouri Richins as it related to THC gummy use?
Yes.
Was that 3 conversations?
It was.
Okay. Was that 1 conversation in November of 2021?
Yes.
And 2 conversations in January of 2022?
Yes.
Scott, if we could show the witness 2-118D. Is it on your screen?
It's not. I've got
Okay.
a desktop.
You have Blue Bear Law showing.
Not on my screen, John.
Oh, my apologies.
The Blue Bear of Law showing? Is that what he just said? Do you have the Blue Bear of Law showing? There's some new software. I haven't heard of that.
Is this the conversation you referenced from November of 2021?
You may need Scott to zoom in. It's pretty small.
Oh.
It is. I'm wearing my
There we go.
Blue Bear Solutions.
Yeah, better. Thanks, Scott. Yes, this is a November of 2021 conversation.
And that's between Kouri Richins and Eric Richins?
Yes.
Scott, if you could show the witness 2-119D, please. Is this a conversation between Eric Richins and Kouri Richins in January of 2022?
It is.
Thank you. And Scott, if you could show the witness 2-124D. And is this another conversation from January of 2022 from Eric Richins to Kouri Richins?
It is.
Did you also analyze Eric Richins' phone for information about illicit drug use?
Yes.
Did you find anything in Eric Richins' phone about illicit drug use?
No, outside THC, I didn't find anything.
Any communications on Eric Richins' phone about buying drugs?
No.
Now I want to talk about Kouri Richins' phones. Did you analyze 3 phones that belonged to Kouri Richins for this case?
I did, yes.
Scott, if you could put up 3-37D, please.
Meanie Banana, thank you for 31 months. OG.
Do you recognize this?
I do.
What is it?
This is an exhibit that represents the 3 phones that you just mentioned that were being used by Miss Richins that are relevant to this case.
Did you help create this exhibit?
I did.
I'm going to move to admit 337D.
He admits them and then publishes, so we might be able to see these in just a moment.
States 3-37D is admitted.
And publish, please.
Jamie, OG, thank you.
Okay. I have a pink pointer that I'm going to try to use.
All right.
What do you think, Scott? Okay. Let's start at the top.
All right.
What phone is at the top of this exhibit?
Okay, so the phone at the top of the exhibit on the left-hand side is Miss Richins' white iPhone, and the 2 numbers that are there, next to the 1 and the 2, those represent the phone numbers that were being used on that device during the time of September 2020 to April of 2022.
What do those dates represent?
That's the duration of the time that phone was being utilized.
So you mentioned for Kouri Richins' white iPhone that there were 2 numbers on that phone. What number were you able to determine was maybe the primary or most used number for that phone?
Right, so the number ending in 1987 is going to be the primary number. That is the carrier subscriber number through Verizon that phone was utilizing. And then the 1152 number is a VoIP number that was being used on that device as well.
So you said VoIP number, but tell the jury, how do you get 2 phone numbers on 1 phone?
You just use an app.
Okay. How is, in this case, the number 1152, how is that different than what you called the subscriber number, the 1987? How is it different?
Right, so that number, a VoIP number, it uses the internet to make calls, make and receive calls, make and receive texts. You can use that number like you would your normal carrier number. The difference is it uses data, and so it typically doesn't show up on your call detail records when you use it.
Did you view a download from Kouri Richins' white iPhone?
I did.
And that came from the Summit County Sheriff's Office?
It did.
And that download was performed by Cheney Ingtao and another download by Marcos Gary Cuchilla?
I believe so, yes.
Did that download contain text messages, call logs, web searches, things like that?
Yes.
In addition to that, were you also able to view what we were calling activity data or device sensor data for that phone?
Yes.
When you did the analysis for that white iPhone, was there evidence of deletions?
Yes.
Was there evidence of text message deletions?
Yes.
evidence of call log deletions.
Yes.
Describe what time frame you were able to recognize those deletions happening.
The time frame essentially for that device is mid-March. So specifically as it relates to some of the other items I looked at related to this case, we're looking basically January 1st through middle of March 2022.
What was missing from that phone for January 2022, February 2022, and March 2022?
Hundreds of text messages at least. They were also missing most of the web history artifacts in that device.
Call histories as well?
Call logs, etc.
So turning your attention to the middle phone here, what are the dates for the use of that phone?
April 14th, 2022 to May 8th, 2023.
Now I noticed that silver iPhone has the same number as the white iPhone. How did that occur?
So this is a new device that Ms. Richins began using on April 14th, and she basically just had her old number assigned to this new device.
Were you able to view a download for this phone?
Yes.
And that was performed by the Summit County Sheriff's Office?
Yes.
Now, comparing Kouri's silver iPhone that she began using in April of 2022 compared to the prior phone, the one that she was using leading up to that point, were there patterns of deletions in this phone similar to the white iPhone?
There were some deletions noted, but not in the same manner as the previous phone, no.
What do you mean not in the same manner?
Meaning there were not big chunks of hundreds of text missing from the device that I noted, compared to the new phone did not have that type of deletion in it.
So now let's talk about the third phone on this exhibit. It says Kouri Richins' blue iPhone. Did you also view an extraction for this phone?
I did.
Or I guess extraction and download. I'm using them
Download,
interchangeably. Is that
so
okay?
do I. That's fine.
They're the same thing.
Yeah.
And that download came from the Summit County Sheriff's Office?
Yes.
Now, similar questions about the blue iPhone. It seems that the date ranges for that are the same as the silver iPhone. Is that correct?
Correct.
So, based on your analysis, Kouri Richins was using the blue iPhone and the silver iPhone at the same time.
Correct.
Same question for the blue iPhone. Were there mass deletions on the blue iPhone when comparing it to what you looked at for the white iPhone?
No.
Now, you did an analysis of a phone belonging to Carmen Lauber, is that correct?
Correct.
And that's the phone with the number ending 6127?
Yes.
Did you analyze CDR data for Carmen Lauber's phone?
I did.
And did you view an extraction or a download for that phone?
Yes.
And that came from the Summit County Sheriff's Office?
Yes.
On Carmen Lauber's phone, were you able to tell if there were deletions on that phone?
Yes.
What were you able to note about items being deleted?
Essentially in the same manner as with Ms. Richins' original phone. When comparing Ms. Lauber's call detail records, there were hundreds of texts and dozens of calls contained in those call detail records for that period of time, but they were no longer contained inside the device. Like there was pretty much all of it was gone.
Did you also look at call detail records for Robert Crozier's phone?
Yes.
And was that for a phone with a number ending 0540?
Yes.
All right, turning your attention to Robert Josh Grossman, did you analyze a download for a phone belonging to that person?
Yes.
And That download was given to you by the Summit County Sheriff's Office.
Yes.
One download that was performed by Marcos Gary Cachia. Is that correct?
Yes.
And that phone had two different numbers associated with it, 1260 and then 0904.
Correct.
When looking at all of these different phone downloads, did you analyze communications between Eric Richins and Kouri Richins?
Yes.
Scott, if you could show Mr. Kouri Exhibit 2-3D, please. Just zoom in a little bit so he can recognize it. Is this a message between Kouri Richins and Eric Richins from December of 2020?
Yes, it is.
Scott, if you could show the witness Exhibit 2-5D. Is this another message between Kouri Richins and Eric Richins from June of 2021?
Yes.
Scott, if you could show the witness Exhibit 2-17D. Is this a text message between Eric Richins and Kouri Richins in January of 2022?
Yes. Yes, it is.
Okay, before we jump into communications between some of these other parties, I want to see if you have analyzed these messages as well. Scott, if you could show the witness Exhibit 2-121. Do you recognize this message as a text message thread that you analyzed from Kouri Richins' phone from December of 2022?
Yes.
Scott, if you could show the witness 2-112. Similar question, do you recognize this as a text message from Kouri Richins' phone that you analyzed from February of 2023?
Yes.
And Exhibit 2-113. Do you recognize this message as a text thread with Kouri Richins from March of 2023?
Yes.
And Scott, 2-14, please. Do you recognize this as a message from Kouri Richins' phone from March of 2023?
Yes.
Okay. Thank you, Scott. Did you analyze communications between Kouri Richins and, I know he goes by Josh, but Robert Josh Grossman?
Yes.
Did they communicate as far back as 2020?
They did, yes.
And through October of 2022?
Yes.
What were the typical volume of calls and texts between Kouri Richins and Josh Grossman?
Particularly from November of 21, which was essentially when the 1152 number showed up on his phone, daily, with a few exceptions.
Now, Scott, if you could put up 337D again, please, for the jury as well.
One moment.
Now, you mentioned that the 1152 number showed up on Josh Grossman's phone. What number did Kouri Richins and Josh Grossman, from Kouri Richins' side, what number did she use to communicate with Josh Grossman?
By text, 1152.
Were you able to tell if she communicated with other people using that phone number, or was it mostly Mr. Grossman?
Mr. Grossman.
Did you find information on Kouri Richins' phone about these communications, or was that mostly from Mr. Grossman's phone?
I found none on Miss Richins, and everything I found was on Mr. Grossman's.
In analyzing Kouri Richins' communications with Josh Grossman, did you locate documents that pertain to this case?
Yes.
Scott, if you could show the witness Exhibit 3-1. And then if you could, I believe there's a second page, if you could show this, the subsequent pages. Do you recognize this?
I do.
What is it?
This is
Generally speaking, is
generally
it a
speaking,
document you found?
Yeah, this is a vacation reservation made or that was located inside Miss Richins' device.
I'm going to move to admit 3-1.
Can you zoom out for a second, Scott? Go back to page 1 for me. It's a 2-page document, is that right?
I don't know if there's a third page. There's a third page that's the...
Fourth. Okay. 4 pages. Mr. Roman.
Objection or authenticity as well as hearsay, Judge.
That's an objection.
Talk to me about authenticity. Why don't you folks approach for a second?
Judge says, hang on. Authenticity, didn't you stipulate? Wasn't there a stipulation? I seem to remember right before lunch or right after or somewhere around there, you guys agreed about the validity of these. That is objection number 99. I think we're going to hit 100 today. But all these call records are coming in. We're getting bits of data. We're getting teased about what they have, right? About the call logs, what was deleted, what wasn't. We have the call records from the company, so we'll be able to put together, the self out. Whoa. Did Mr. Bloodworth get him some water? Where's Mr. Bloodworth? Got the witness some water. That's his first time doing that. But we're getting teased as to what we're going to get. The who was called when and from where is going to be very important as we proceed in this trial. So can't wait for that. Crazy memory, good for him. Trading hype sounds like a way to launder money. Whoa. Well, this guy's job snooping in other people's phones. I believe that Celebrate won't sell their software just to anybody. They only want to sell it to law enforcement. You can't just go buy your own copy. Bummer, huh? Yeah, we'd all get it just to see what we have on our own phones. Check Pirate Bay. Not advice. Don't do this at home. Wish you could just download Celebrate as an app from the App Store and print your own report, or run one on your friend's phone or your significant others. That would be a great business. Somebody needs to make that app and sell it. I'm pretty sure it wouldn't be in the App Store officially. What happened to One Horse, One Rider? As long as only one of them's talking up there, they can all approach. But if they try to tag team a specific the same argument, it's only going to be one lawyer per side. I think you quickly found out why that app doesn't exist. Yeah. Little Stubby, we're so excited to hear about the Google searches. Those haven't come in yet, but we expect them in the near future. Witness looks like he's being nosy. He's just listening into what's, he's got his ears perked up. What's going on in his presence. Average cost of Celebrate is $14,000 a year. Yes, and it is it's an annual thing. You can't just buy a copy and use it forever. So you get to buy it every year. Thanks, Microsoft, for introducing that sales model. Seems cheap. It could be when you look at the cost of, I don't know, divorce and hiring a hitman and everything else. Yeah, it's pretty inexpensive. Hope his ears are better than his eyes. Maybe his ears are finely tuned machines. Google's definitely the girl who drinks all the tea and can't wait to spill. Long sidebar, these objections. Judge seems a little animated. A lot of head movement there. See if I can show this. I've been watching Kouri's choice of wardrobe every day. And going back to this picture right here, I've been trying to see if she wears anything out of the closet. So right now she's got this on, which is sort of like with the horizontal stripes. The knitting, I'm not sure what you'd call that. But I'm just looking to see, is that it? Sort of right mid forearm? Is that the same one, but sort of right next to the red? I'm looking right over here. Just is that one, or is it possibly this one? I'm not sure. You guys tell me. I'm looking for the wrist so I get a better view of it.
All right, let's pause here for a moment. Let's see. You can see that document, right?
Yes, sir.
Would you ask the foundational question one more time?
Certainly. Mr. Kouri, in analyzing Kouri Richins' phone, did you find documents that were pertinent to this case?
Yes.
And you located those on Kouri Richins' device?
Yes.
And looking at Exhibit 3-1 in front of you, is this one of those documents that you located on her phone?
Yes.
Move to admit 3-1.
Mr. Unless any other objection? Yep. Okay. So the record is clear. The objection asserted at sidebar is overruled. Scott, forgive me, you got to go back to page 1. 3-1, a 4-page document is admitted. Do you want to publish?
Yes, please.
Objection at sidebar. That takes us to 100.
And Scott, if we could zoom in on. Thank you, Scott.
You're welcome.
Did you analyze communications between Kouri Richins and Carmen Lauber?
Yes.
Did they begin communicating around December of 2021?
They communicated prior to 2021, but in relation to this case and in relation to the cell phone, the CDR records, in relation to that extraction or her phone download, yes, 2021, December.
From January of 2022 to, say, March 15th of 2022, what was the volume or approximate volume of text messages between Kouri Richins and Carmen Lauber for that 3-month period?
Between the two of them, about 800 text messages.
So casual acquaintances.
Doing some quick math, that's about 11 per day?
Yes, about 10 or 11 a day on average.
So from March 16th, 2022 to the end of that year, so March, April, May, June, July, August, September, October, November, December, approximately how many text messages between Kouri Richins and Carmen Lauber for that 9-month time frame?
About 600, 650.
Okay, we're going to do some quick math. Is that about 3 per day?
It's about 3 per day.
Now, to be clear, I'm not asking you if they communicated 3 times a day, right? Just
Correct.
doing the average, that's about what it would come out to.
Right, it's about a 70% decrease if my math is right.
Why is he laughing?
Where does that data come from?
The call detail records between Kouri Richins and Carmen Lauber.
And because it's a call detail record, we don't have the content of any of those messages.
Correct.
They've been deleted from Kouri Richins' phone?
Yes.
They've been deleted from Carmen Lauber's phone?
Yes.
We don't know what they said.
Correct.
I want to turn your attention to February 11th, 2022. Did you analyze CDR records for Kouri Richins from that time frame?
Yes.
If you could look at Exhibit 3-6, please. Do you recognize this?
I do.
Is this a call detail record for Kouri Richins' phone?
Yes.
Is this one of those documents that you reviewed in your analysis for this case?
Yes.
Remove to admit 3-6.
States 3-6 is admitted.
If we could please publish that document. Okay, we've been talking about call detail records. Is this a call detail record?
Yes, this is the billing version of it, but yes, this is the call detail record.
Why does it say Eric Richins at the top?
He's the subscriber, the Verizon subscriber, so it has his name on it.
Now, when we're looking at the phone number at the top, this clicker
That
is not
pointer.
liking me, but I wanted to point it out. It says 1987, and that's the number that belonged to Kouri Richins, correct?
Yes.
So when we're looking at each of these individual calls on this particular document, how do you know if it's an incoming or outgoing call?
On destination, so there's, what is that, about 7 columns over where it says destination. There is it denotes that in there. And so it'll say incoming. If it's got a switch location on there, like Salt Lake, Utah, that typically is an outgoing.
Does this call detail record show the duration of a call?
It does.
Where is that on the
So
document?
just to the right where it was highlighted, where it says minutes, MIN, right, the abbreviation, that is the minute, or that is the amount per minute of the call. Or, sorry, it's in seconds sometimes, so yeah.
Is this duration in
This
in
is
minutes?
in minutes, yes.
Okay.
I apologize.
Did Kouri Richins make phone calls on February 11th, 2022 at 11:27, 12:36, and 12:39?
Yes, I think it was 12:27, but yes.
I might have said the wrong minute.
It's okay, yeah.
Did you determine who these calls were made to?
I did.
How did you do that?
I Googled the numbers.
Okay, and who do those numbers come back to?
Those are IRS numbers.
So on those 3 occasions, Kouri Richins was calling the IRS.
Correct.
Still talking about, thank you, Scott, for that. Still talking about February 11th of 2022. Did you analyze communications or CDR records for Kouri Richins and Carmen Lauber from that day?
Yes,
And did they communicate that day?
they did.
And do you know that from the CDR data?
Yes.
For February 11th, 2022, do you have location data related to Carmen Lauber's cell tower use on that day?
Yes, from her device, yes.
And did that come from the call detail records?
Yes.
Scott, if you could show the witness exhibit 3-8D, 38D. If you could zoom out just a little bit so that we can see the whole.
We can, it's that screen.
Oh, it's my screen. I see. Everyone else can see the whole thing. Okay. Do you recognize this?
Oh, man.
I do.
Did you help create this?
I did.
And did you do that using the CDR data we've been talking about?
Correct. I provided the call detail information to the graphic designer that created this exhibit.
Does exhibit 3-8D accurately depict the raw data that you analyzed?
Yes.
Move to admit 3-8D.
States 3-8 Delta is admitted.
If we could please publish.
For some reason, I can see this guy at a karaoke bar.
So
Just belting it out.
what are we looking at here? Describe for the jury, and if it's easier for you to step down, you can. But what's at the top?
You know what? Yeah, maybe I will step down actually.
Because I have this clicker, but maybe it will
Gotcha.
work better for you.
It's
You can try to use this.
Oh, he's in his element. Here he is.
If I tap it, it works.
that does not work.
Glad it wasn't just
Mr.
me.
Costa-Demas, would you tap that mic, see if it's working? Yeah, okay. Thank you, sir.
And now a little voice check. You want to sing a little bit for
Yeah,
us?
okay.
Okay,
So
go ahead and describe
hit
what
it.
we're looking at here.
Right. Well, what we're looking at is a representation of the call detail records that Ms. Shervinick mentioned. What you have on the right-hand side is going to be the text communications between Miss Richins and Miss Lauber for February 11th, 2022. There's just a photo so you know whose device we're referring to. A photo of Miss Richins, a photo of Miss Lauber. The blue bubble with the 3 dots indicates that this is a text message, and then the arrow is going to depict which direction that calls. So, for instance, the very first one at 3:22:44 is an outgoing message from Miss Richins to Miss Lauber at that time. And so these are on the right-hand side. These are going to come up so that you can see when the two communicated, the volume of the communication, and then also the direction. Okay. On the left-hand side is a representation of essentially the Davis County and Salt Lake County Valley areas, and you're going to see locations pop up on these on this map as we move through the record chronologically. What those, for instance, there you go. Thanks, Scott. So
there's Robbie.
This is a tower location. It's pointing to the location of the tower. That's important, not the device, but the tower of that Miss Lauber device is utilizing at 4:11 p.m., for instance. Okay. Mr. Crozier's record was also populated into this as well. And at the same time, at 4:11 p.m., Mr. Crozier is pointing towards a tower location in the Davis County area. So you know which tower their devices are using. On the left-hand side, these are going to move. And what that depicts is the movement of the device as they reacquire different towers. Okay? And then on the right-hand side, as we go through the slides, it's going to start populating. So Scott, you can start populating. So at 4:11, this represents a phone or a communication between Miss Lauber and Mr. Crozier, and this is their respective locations. You can see on the right-hand side through the 4 o'clock and the 5 o'clock hour, beginning in the 5 o'clock hour, Miss Richins and Miss Lauber continue to communicate via text. At 5:05, Miss Lauber is still in the Heber Valley area, and that picture that you just saw was a photo from that time frame that was recovered from Miss Lauber's cell phone device. All right, so you can see at 5:05, Miss Lauber is now, her device is now hitting on a tower in the Provo Canyon area out near the reservoir, and Mr. Crozier's device is using a tower at 5:20 p.m. up in the Davis County area. And on the right-hand side, you're going to see Miss Richins and Miss Lauber continue to communicate with one another. And Miss Lauber's device is traveling down Provo Canyon and into the Utah County area. That device is now heading into roughly the Utah County area. It's utilizing towers in those locations. And eventually it's going to move north. And you can see Mr. Crozier's device has now jumped significantly. I want to explain this to you, the jury, because this is important. Mr. Crozier's carrier is T-Mobile. Okay, so his carrier does not provide location data for these records for text. It's only calls. So the only time Mr. Crozier's location is going to appear to change is when his device is utilizing a tower for a call. Miss Lauber's was more detailed. This isn't all of every single pinpoint of every single tower, because every single text she made utilized a tower, but for the sake of not cluttering this up with a bunch of repeats on top of each other, you can assume that from the previous point to the next point, she was utilizing the tower before it. So she was utilizing the tower near the reservoir for several texts, and then now she's using this one in the Utah County area. All right, Scott.
Robbie's on 215.
So Mr. Crozier's device is now moved a little bit farther south and utilizing a tower there. In the 6 o'clock hour, Miss Lauber and Miss Richins are communicating via text. And Miss Lauber is now arriving on a tower at or near the area of, it's in Draper, Utah, near the area of a Maverick store that's there.
I've filled up at that Maverick.
Mr. Crozier is heading in the same general direction, utilizing a tower in the same area. You can see on the right-hand side, Ms. Richins and Ms. Lauber are continuing to communicate via text. And then at 7:21, we have Mr. Crozier and Ms. Lauber utilizing the same tower. They're not talking to each other, but they are utilizing the same tower near that Draper location. And this is that location. So on the left-hand side, you can see there Mr. Crozier and Ms. Lauber at 7:21 are making their respective communications. Their devices are using this tower, which is located across the freeway from this Draper, from this Maverick store in Draper right off the freeway. Ms. Lauber and Ms. Richins continue to communicate into the 7 o'clock hour. This photo was recovered from Ms. Lauber's phone download, depicting her with another woman during this time. There's another photo. And by 8:20, Ms. Lauber's device is now moving south and utilizing towers south of that Draper location. And by 8:47, Mr. Crozier has made or received a phone call, because we know that's the only records his denote towers, and he's moving back north towards the Davis County area. And then Ms. Lauber by 8:56 is utilizing a tower in the Heber Valley area. Ms. Lauber remains in the Heber Valley area, and then on the right-hand side, sorry, Scott, but if you can go back one slide, Ms. Richins and Ms. Lauber continue to communicate into the 9 o'clock hour via text. So from 3:42 to 9:02, the defendant, Ms. Lauber, communicated 34 times via text. During the same time, Ms. Lauber and Mr. Crozier communicated 50 times via text and 6 times via voice call.
Whoa. That's a lot of times.
Yeah, you can just take that. But I think I can walk them through it from here now. Okay, understand.
Yeah.
Did you also look at communications from February 11th, 2022 between Carmen Lauber and Robert Crozier?
Yes.
Did they communicate on that day?
Yes.
And is that information from the call detail records?
Yes.
Scott, if you could show the witness Exhibit 3-33D. Do you recognize this?
I do.
Similar to the last exhibit, something that you helped to create?
Yes.
And using the call detail records that you were just describing?
Yes.
Does Exhibit 3-33D accurately depict the raw data that you viewed in this case?
Yes.
Move to admit 3-33D.
Your Honor, no objection. If the following testimony is going to be similar to the last one, perhaps we can have some questions. I think we all understand where they're traveling and what it means now, just to move things along.
3-33D is admitted. Would you like to publish?
Yes, please. Okay, so similar to the last exhibit that we looked at, is this one laid out the same way?
It is, yes.
And the last exhibit was depicting communications between Carmen Lauber and Kouri Richins, and this one is between Carmen Lauber and Robert Crozier. Is that correct?
Correct.
Otherwise, the different indicators, the bubbles, the arrows, those things remain the same as the previous exhibit?
Yes.
The map that we're looking at, the area of the Salt Lake Valley remains the same?
Yes.
And then similarly, as we see the different pictures of the people moving, that is the cell phone towers that their device is utilizing at those different times?
Correct.
Scott, if we could move through this exhibit, and Mr. Kotridimus, if there's anything that you want to note regarding the communications between Robert Crozier and Carmen Lauber.
Right. I think if we just, for the sake of time, like Mr. Ramos just said, we can just slowly click through those, Scott. And I can just describe to the jury what they're saying. It's the Miss Lauber and Mr. Crozier are communicating at 11 p.m., almost noon, and then into the 5 o'clock hour. And then again, you see Miss Lauber's device move out of the Heber Valley area into the Utah County area, where it will ultimately end up in the south end of the Salt Lake County area. And I believe utilize a tower at or near the Draper once again. And Mr. Crozier's device is moving south out of the Davis County area once more. They're located in at or near the exact same location for a period of time, and then they return. Mr. Crozier returns back to the Davis County area, and Miss Lauber returns back to the Heber Valley area. Yeah, there's another. That's that representation of that 721 phone call.
Thank you, Scott. I want to turn your attention to February 14th of 2022. If we could put up Exhibit 3-6, that one's already been admitted.
Do you want to show it again?
Yes, please publish it to the jury.
One moment.
And Scott, if we could expand on the phone call at 8:53 a.m. So, from these records, did Kouri Richins make an outgoing phone call on February 14th at 8:53 a.m.?
Yes,
Did you determine who that number belongs to?
I did.
Who does it belong to?
That is the Mirror Lake Diner.
Thank you, Scott. For February 14th of 2022, did you analyze communications between Kouri Richins and Josh Grossman?
Yes.
Scott, if you could show the witness 2-27D. And scroll through so we can see all of it. Do you recognize this?
I do.
Did you help to create this, or did you create this?
I created this one.
And does Exhibit 2-27D accurately depict the raw data that you analyzed for this case?
Yes.
I'll move to admit 2-27D.
Sorry, Judge, I just can't see it from over here. No objection, Judge, thank you.
States 2-27D is admitted.
If you could publish that, Scott.
Can you focus that?
And if you could scroll through the pages, and then I'll ask Mr. Kotrodemus about the last page.
You're going to have to read it for us, because it sure is blurry. Leaving the school, Camus headed that way. Liked headed that way. Hour long ride? Yep. There's a drop a pin. A little I love you from K-Babe to Josh. She calls herself K-Babe. Oh no, Josh calls her K-Babe. Okay, got it. With you. That's my love yous. Ooh, here's a big one. My heart is smiling. Will these new words come from you? It's very unique, different from any time I've heard them before. Those feelings, when they come from you, bringing up different feelings in me. Your love reminds me of how much God loves me. It reminds me that I, my mom's son, am secretly the luckiest man on the face of the earth. It gives me immense amounts of appreciation, gratitude, and honor. You wouldn't trade your love for a million of you name it, whatever's next best. Darling, you better believe that I'm one of your. I'll be one of your Valentines. One of. I'll be one of. Please include me in the harem. What? That's a. I wasn't expecting the one of. I can't read all of those.
What are we looking at that's depicted here on the last page of this exhibit?
So this is an image that was contained within that text thread that was sent by Ms. Richins to Mr. Grossman.
And it was sent approximately an hour before that arrival time, is that correct?
Correct. This follows the text in which Mr. Grossman asked Ms. Richins about an hour, and she sent this photo.
Thank you, Scott. Did you also analyze communications between Kouri Richins and Eric Richins on Valentine's Day, 2022?
Yes.
If you could show Mr. Kotrodemus 2-28D and scroll through it so he can see the whole exhibit, please. Do you recognize this?
I do.
Is this an exhibit that you created?
Yes.
Does exhibit 2-28D accurately depict the raw data that you analyzed in this case?
Yes.
Move to admit 2-28D.
States 2-28D is admitted.
If we could publish, please. And Scott, similar to the last exhibit, I'll have you move through. And Mr. Kotrodemus, it's kind of clear from the to and from, but who is going to be typing the messages that are in the green bubbles?
All right, so the green is from, and that's the 9317. That's Eric Richins, and the 2, or the recipient in this would be 1987, which is
My
Kouri
princess.
Richins.
My princess is who
And
it's
so
going
her
to.
responses, Kouri Richins' responses are in blue, is that correct?
Correct.
Why does he go by $bang other?
These messages coming in, if you're on, could give the instructions similar that you've done in the past as to the figure say, as to Mr. Richins. Maybe we could just do it once. We all know that it applies to all of them.
So, fair reminder, the statements by Ms. Richins on her side of that conversation, you may consider those for any purpose. You may give them the weight you deem appropriate.
Your Honor, may we approach?
Sure.
JPC 1960, the best place to be, 28 months OG. Thank you very much. Some of these little messages, I'm trying to read the rest of some of this. Let's see if I could get this full screen or something. How do I do that? I was writing this on the way to Salt Lake. This is from Josh Grossman to Kouri. I was writing this on the way to Salt Lake. I know how you feel. I know how you feel the need to apologize, but just so you know, I like to see you on phone calls. I like to watch you text and to hear you read aloud. I see beauty, intelligence, quick wit, cuteness, and authenticity. It's like seeing a white tiger in a tropical forest instead of remembering one at the zoo. I love it. So that's his Valentine's Day card, I guess, to her. White tiger in a tropical forest. I was just reading a text message between Kouri Richins' significant other than her significant husband. Text that they were sharing back and forth while her significant other was experiencing what the prosecutor says was an earlier attempt at poisoning. So she went to Mirror Lake Diner, grabbed him a sandwich, might have added a little something to it. He ate part of the sandwich, wasn't feeling well, saying, I'm not feeling good. And she's like, hey, just lie down. It'll be all better in a little while. Meanwhile, she's going to visit.
This is a good time to take a restroom break. If everybody would please rise for the jury.
Okay, whatever the sidebar was about, the judge says we need to talk about it a little bit more. I think, look at those sleeves on that white, whatever sweater she's wearing. I think it was in the closet. I know you guys say you don't hang up sweaters. I didn't know that till today. Maybe Kouri didn't know it either.
Have a seat, folks. Thank you. Did you actually want to take a break, Mr. Valletta, or do you want to have further discussion regarding this issue?
Both, Your Honor.
Which order would you like to do it in?
Perhaps discuss first, break second.
Understood. Mr. Ramos?
Fire away.
So we're talking specifically regarding 2-28D. And Scott, I don't have control over these, so I need you to go back to page 1, zoom in for me. Okay.
Do we need to excuse the witness, or are we good?
He's an expert. I imagine the state's going to tell me the exclusionary rule won't apply to him, but
I was just curious.
yeah, so I don't think so. Yeah. If you need to use the restroom, that's one thing.
You can leave if
Okay.
you want, but I can't make you,
So,
says the judge.
the first green bubble in 228, I've already ruled is a present sense impression and is admissible. Any further record there, Mr.
Ooh, the objection
Ramos?
was hearsay.
That was early on.
Yeah.
No,
Okay.
You've ruled on it.
So keep scrolling, Scott. Then we have a blue bubble that represents, I need the second green bubble, please, Scott.
Just the green ones.
Oh, okay.
Yep. Anything from Kouri is allowed.
Second green bubble, please, Scott.
On the first
That's the
page.
first one.
On the first page.
There's your first page, there's only one green on the first.
Oh, I'm sorry. Okay, can we go to the second page, please? And then the,
No, we did that one.
no, we didn't. It's okay. So highlight that one for me, Scott. Oh, wait, I can see it. I'm sorry. I'm so sorry, Scott. Go back to page 2. Unzoomed. Green bubble states, "Are you home?" Any objection, Mr. Ramos?
No.
Okay, third bubble says, "In the office, I've been sleeping out here." That, I think, is also present sentence impression that I've previously ruled on. Okay, go to page 3, Scott, if there's one. Green bubble, no, it's quiet out here. I think it's the same. And then, Mr. Ramos, I'm going to pause if I
No,
just,
I'm just-
okay.
yeah.
And then get to the end of this 228D, Scott.
It's a total of 7 pages, this is the.
Oh, I'm sorry, one page at a time. I just need to analyze each green bubble.
This is the next set of green bubbles here.
This one's good. You can go to the next one.
No, we're not seeing the same thing Scott is. Hold on a second.
Oh, we're not seeing what you're seeing. That's why.
My apologies.
Green bubbles are Eric's.
Scott, if you'd unplug and plug back in for me, I'd appreciate it.
Unplug it and plug it in again. The judge has got this Blue Bear tech system figured out.
I think we're on page 4.
Page 4, Your Honor, didn't have
Just-
any green
just
bubbles.
blue.
Understood. Let's go to page 5. Okay, wish you were here. And then a question mark. Mr. Ramos, any objection?
No.
Okay, go to page 6. Thanks for answering. Any objection?
No.
Okay, page 7.
He's objected on the grounds of hearsay and is
I
like,
can't read it. It's got a, sorry, can you? Thank you, sir.
embiggen.
We are headed in there. Food is on the front seat of my truck. Any objection, Mr. Ramos?
No.
Okay, so with respect to 228D, there are no hearsay issues. We've already admitted certain exhibits. Ms. Shervanek makes a fair point at sidebar. We'll need to be a little bit precise about these going forward. So we can just slow down. If there comes a time when you need to make a specific objection regarding a specific part of a conversation, just say objection, may we approach.
If we can go slow through them, and then I'll just, you can pull them up there. Yeah, we'll be fine.
Okay. Anything further on that, Ms. Shervanek?
Yes, Your Honor, only that, can you give the jury an instruction now that what you told them before?
I didn't complete the thought, but I can clear it up.
If we could just clarify for them
Yeah.
that that blanket
Yeah,
rule does
I
not
can-
apply to this exhibit.
Well, no, and also I shouldn't call it a blanket rule. So that they may consider both sides of 228D for any purpose. Okay.
Thank you.
Thank
And
you.
What we'll do is, we'll meet with them during this break real quick and see if I can just go through them.
I appreciate
That would be great.
All right. Let's come back at to allow you time to do that, 2:40. Thank you.
Judge gives them a 14-minute break.
Court's in recess. You're welcome to use the restroom. Don't talk.
Judge doesn't do blanket rules. Yeah, no blanket rules. So apparently you can have blankets in court. Mr. Ramos objected based on hearsay for some of these text exchanges for Eric's texts. But then on the one at a time going through the text, there really wasn't anything he objected to, so it's all allowed in. But going forward, there will be more texts where we anticipate an objection will be launched and or lodged, and we'll see if everything comes in or not. So we're going to take it a little slower. Not just going to throw them up on the screen there for everyone to look at. The blanket rule is a cozy rule. It is. Who knew Ramos would be the attorney that's nice from the first day? I thought he was the designated pit bull, but now Miss Nestor has switched to that position. Ramos is the friendly greeter that's just all smiles and hugs and chocolate kisses. So I'm not a candy person. That wouldn't appeal to me. Let's see, I saw Scream 7 this weekend. I could not believe the amount of blankets and PJs. Watching the movie, like they brought him to the theater. I want to sell my shoes after I've walked in the theater. But I feel bad at charging anyone money for them. That the theaters are gross. Someone must have taken Ramos and replaced him with his doppelganger. I think they just took him aside and said, that's not going to work. Let's try a different approach this trial. They should have voice actors read out each text. And even full-on actors act them out. That would be great as well. Theaters by me are nice, recliner seats and pretty clean floors. We would go to a dollar theater with our kids. And the idea of a dollar theater, that's pretty much what people who work there earn, is $1. So they have very little incentive to clean. Like at the end of the day, I think they brought like a leaf blower to gather up the debris on the floor that wasn't stuck to something. It was, at movies, that was an experience. Shoes in airports are the worst. The worst. Explain to me what the defense wants excluded and why. And I don't know what a blanket rule is. A blanket rule is when a judge says, I'm ordering that all text messages in this trial are allowed to come in. You can't do that. Who says it, when, if it's admissible or not, whether it's, prejudicial. There's all sorts of rules as to that. A blanket rule would just be like across the board, going forward from now on, anytime this objection is raised, this is the ruling. No blanket rules. Judges don't do blanket rules very often. Defense wants to exclude some text messages that we're going to get from this witness. So in the conversations, which are from a few different people, usually involving Kouri, the defense wants to object based on probably hearsay grounds would be their best bet, that it shouldn't come in. And then as long as there's no legal reason why it would get around the hearsay exception, as long as there's no hearsay exception, they would not come in. Can we have blankets in court? Only if you're watching at home. I'm not sure if... I imagine some courts would allow you to bring a blanket, as long as you're not, waving it around and wearing it like a cape and things like that. I always sit in the last row in a theater. I don't want a popcorn trail. Our dollar theater, you would buy a big tub of popcorn and you eat it. It's mostly just like fat and salt. But you eat it, and then you go back, and they would like sign their name on the bottom of the bucket, and then fill it up one more time. So as long as there was no signature on the bottom of, initials on the bottom of the bucket, you could just get refills. That's what Snuggies are for. I have the last Snuggie I purchased was actually from Walmart, and it's a giant Flamin' Hot Cheetos Snuggie. My son has adopted it. I would in a heartbeat buy an RA blanket. Maybe we need to add a court watching blanket to the merch lineup. I'll look and see if we can find a good vendor that can have a good quality product at a great price. Missed your reaction to the Crozer video. What was the consensus? I think he knew what he was talking about. He says he sold them fentanyl. He says they knew that it was fentanyl. That was his original story that he was sticking to. And he seemed to be with it mentally. Ivan says, not buying your blanket, bro. It's not my blanket. It would be like your blanket at that point. But it's not going to be like my face. I'm pretty sure it's not going to have my face on it. I would give 50 memberships if RA did an entire stream wearing a flaming hot Cheetos Snuggie on the stream. Oh, you guys are just into humiliating me, is what it is. AWOL Podcast member for 23 months says, 23 months, missed my RA family, but the love is still real. I'm watching a different trial either way. Again, love you. Hope all is well. AWOL, love you as well, man. We miss you. Can't wait for your watching the same court as us. Maybe yours will end. You'll come join us and do the catch up and everything. We miss your calls. All right. My other half got me a bolognese takeaway last month. I was ill for a week from it. Should I be asking questions? Is there a prenup? No, I don't know. I'm not legal advice there, nor am I a marriage counselor. But yes, you should be asking questions. Let's see. AWOL, by the way, you're an OG. Thank you very much. Let's see. Do it, all right. I've got a fan on me right now. It's already hot. Yes, need a RA face blanket like Legal Vice's Nicolas Cage face blanket. See, I can see putting like a very famous actor or something, or actress on a blanket, but no, I'd pass. It would have to be the Flaming Hot Cheetos Snuggie. Josh adds to it, says I'd gift $100 super chat. An entire stream. That's like 6, 7, 8 hours in a Snuggie. What does that break down to with dollars per hour? I'm pretty sure it's less than minimum wage. All right, that's the deal. All right. Well, your offer's on the table. Obviously, I can't do it this stream because it wouldn't count because it's not the entire stream. Let's see. Why do they have so many rules in court? Because we give judges so much power. A judge is, in his own courtroom, is both the legislative and the judicial branch. And to some extent, he controls the executive branch. So the executive would be with the bailiffs, which the judge sort of orders around and tells them to do what they do. The judge is obviously judicial. He's judging, and he's the legislative branch because he makes the rules like the legislature does. So he might say, during this court, no one is allowed to chew gum or blink more than twice per hour, whatever the rule is. He can make the rule and then enforce it and carry it out. And if he doesn't like you, he can hold you in contempt, which is jail you. So, yeah, courtrooms are unique that way. It's like dealing with the IRS, right? They don't need any other checks and balances. They sort of take care of it all themselves. Let's see. It's one of the rare judges we actually see rule from the bench. Yes, Laura, as a matter of fact, it's sort of rare that he didn't rule on some of the motions, and he's taken it under advisement while he's doing a little research. So specifically that one, the one issue that we're waiting to hear back from right after lunch, Let's see. What was the issue? I don't remember what it was. I'll have to look at my notes here one more time. Sorry, my phone's ringing. I'm trying to see who it is. Oh, it's Ivan.
Call from
Ivan. Ivan, how are you doing, my friend?
I'm going to need some clarification on just how far the Cash for Stunt RA streams, line in the sand is willing to go here. If we can start offering super chats and memberships for stunts, I'm all in. I just need to know where the parameters
let me tell you where it starts. Later on today, we get the bid from the people who are going to be fixing our roof. We were told when we bought the house that it leaked really badly and we need it fixed. So depending on that bid, my flexibility.
Will this be a weekly? Will this be a weekly weekend thing? If you need help constructing a menu, I got you, man.
I'd rather not be turned into a circus monkey for everyone's viewing pleasure. But
hey, man,
we like to have fun.
Life's a hustle, man. $14,000 can get you the information on anybody. This guy. This guy asked for your phone number in a bar. You've just given him your whole life.
He owns you at that point.
Buyer beware, ladies. My goodness. Yeah. You start passing out phone numbers to guys like this, like your whole life's on. He owns you now. Good grief. I just want to make a motion that if your job is to spy on people, you aren't allowed to have a nervous laugh. People can have nervous laughs, okay? It's fine.
What is it? It is. But I think it's the most inappropriate laugh, right? Because we're dealing with a murder trial, and his specific evidence. He's talking about people who were the victims in a murder trial, and he's
your job
sort of
is creepy, okay? Yes, it's valuable, but it's a creepy job. So if you got a creepy job, you don't get to have a nervous laugh. These are just social constructs we all must live by.
This is probably why he works for himself. He's his own boss.
Yeah.
Nobody can fire him, right?
All right. I just had to throw it in there. Love you guys.
All right. Love you, Ivan. See you, man.
Bye.
Bye. Ivan brainstorming what he can try to make me do for a super chat. Are we raising money for a roof? We've been saving money for the roof. We're hopeful that we can afford it. So it would be nice if it only rained outside our house. That's just the goal. We like it to rain outside the house and not inside. 34 months with the same guy, says Free to Be. OG, Free to Be, thank you very much. Appreciate it. Time flies. It's wonderful, and it wouldn't be the same without you here. Let's see. Recovery Addict, what happened to your Bitcoin? The team didn't win. The Brewers, they choked at the end. It was awful. It was sad. Laughter was out of place a little bit. Mostly because I don't know what he was laughing at. Like if there was a joke there, if somebody had made a little, told a little funny, that I understand that. And sometimes even in a murder trial in courts, the judges will say things that are funny. We watched what it was in the Banfield trial just recently, the au pair trial. The judge told a couple jokes and kept things lighthearted with the jury, usually in the morning. I'm okay with that. But just like in the middle of testimony, just like giggling about something, chortling to yourself, it does seem a little creepy. We aren't discussing Bitcoin. It's on sale right now, Ivan. Bitcoin's on sale. That's what we know. Love True Crimes member for 1 month. Why would Kouri's text be hearsay? Kouri's would not, and let's start at the very basics. Hearsay would be any out-of-court statement. But there's a huge exception around the defendant's out-of-court statements. Those basically all can be brought in because it's what they said. It's against interest. So you can pretty much almost always get the defendant's statements in. And then there are a bunch of other rules about some other statements by other people. Sorry, I got the hiccups talking about this. There we go. They're gone. There are other statements from other people that you can get in under other exceptions like present sense impression or excited utterance or not for the truth of the matter asserted, but for the effect on the listener and all these other little reasons you can carve out. And a good lawyer can almost always get what they want in. But sometimes not so much. This judge, He's cautious. He's cautious. Great question, though. Loves true crimes. Britt Bottoms, member for 25 months on the jury. OG, 25 months of cross-examining every hot take. I love it, Britt Bottoms. You did still, Angela says, you still did not answer my proposal on trying surströmming during a podcast. That's the one where it's like not legal to open it inside a public building, right? You have to like open it outside, like within 20 miles away from the closest residence, underwater or something. Angela, you're going to kill me. It's terrible. I can't eat something without smelling it first. And if it smells that bad, I just won't be able to eat it. I want to raise just enough money to require additional streams. I think the judge's head is back in court. Nicole's here. We're
Call
not sure if we'll
from.
have time.
It's Nicole.
Nicole, the judge's head is here, but if you talk quick, we might be able to.
Just really fast.
Yeah.
I just jumped off a 2-story ladder because
Mr. Ramos,
I had to correct you on your hearsay definition.
Any objection
hang on.
to
The judge is here.
describing
I'll call back.
State's Exhibit 228D as a February 14, 2022 text exchange between Eric Richins in green and Kouri Richins in blue?
No, Judge. No,
Okay.
There was only one other message, and we're good with it.
Okay, very good.
Okay, so they worked it out.
Anything before we invite the jury in, Ms. Shervnak?
No, Your Honor, you'll give them a clarifying instruction about, okay.
I intend to fall on my sword on that one. All right, we're ready for the jury.
I made Nicole jump off a ladder. She's going to correct whatever I said about hearsay as far as the definition. Probably on the next break if we can do it. I know she's painted a house and busy, but this is important. We get it right.
Folks, feel free to have a seat as you come in, please.
Been here 38 months, but YouTube forced my name change. I can't get it back because someone owns it. I'm the someone, but that doesn't seem to matter. That is the most YouTube of YouTube thing to do.
Ladies and gentlemen of the jury, before we took a break, I misspoke and created some confusion. Let me clear that up now. State's Exhibit 2-28D, as in Delta, is a February 14, 2022 text exchange between Eric Richins, as depicted in the green bubbles, and Kouri Richins, as depicted in the blue bubbles. The jury may consider either and both sides of that conversation for any purpose. You may give either and both sides any weight you think they deserve. Ms. Shervnak, take it from there.
The judge did fall on the sword there. Nicely done, Judge. Cass, thank you very much.
If we could put 228D up on the screen. I don't know if we got through the whole conversation before. I forget where we left off, so I'm going to have Scott go through this conversation for the jury with that new instruction in mind.
Are you home? No, in Provo, waiting for my cabinet installer guy. Are you home? In the office, I've been sleeping out here. Weirdo. Go in our bed. No, it's quiet out here. You'll be quiet in there if you lock the door. You sleep through anything. Anyway. How are you feeling? Okay, wish you were here. I would cuddle ya heading back in 20. He just got here. That's the cabinet guy. Or is it Josh? One of the two. Missed that one. Question? Thanks for answering. Did you call? You didn't call. We were headed in there. Food is on the front seat of my truck. What food? What food would that be? What Mirror Lake sandwich would that be?
In addition to these text messages, did you also analyze Eric Richins'
Thanks, Carol.
device data, sensor data, I guess, for February 14th of 2022?
Yes.
If we could show Exhibit 314D, please. Do you recognize this?
I do.
Is this an exhibit you helped create?
Yes.
Does Exhibit 3-14D accurately depict the raw data that you analyzed from Eric Richins' phone?
Yes.
Move to admit 3-14D.
No objection.
States 3-14D is admitted.
If we could publish, please. When you analyzed the movement data from Eric Richins' phone on Valentine's Day 2022, we're looking at a graph here. What does this graph depict?
The graph depicts travel, so in distance in blue, and in energy exertion basically in green, and the in frequency hour to hour on February 14th, 2022.
What?
Was there a gap in Eric Richins' movement and the other data that you just referenced during the middle of that day?
Yes.
Is that denoted here in the blown up portion? What do we see?
It is. There's a data set on the left-hand side for flights climbed, distance traveled, and steps. Depicting, so this is a portion, well, actually, this is the 12 o'clock hour. And then on the right-hand side, there is device activity for depicting steps and distance traveled at 1:32.
And so from this data, we can tell that from approximately 12:05 to 1:32, there was no movement data recorded on Eric Richins' phone.
Correct.
Did you analyze his phone for similar types of movement on other days?
Yes.
And did you compare the data from Valentine's Day to those other days?
I did.
Was it unusual for Eric Richins to have an 87-minute gap in his activity in the middle of a workday?
It wasn't typical, no.
So the answer would be yes.
I want to turn your attention to February 26th of 2022. Did you analyze communications between Kouri Richins and Carmen Lauber on that day?
Yes.
Scott, if we could show Mr. Kotradimus 3-16D. Do you recognize this?
I do.
Did you help create this?
I did.
Is this using the CDR data that you analyzed for this date?
Yes, this is essentially the same type of exhibit that was created for February 11th.
Does Exhibit 3-16D accurately depict the raw data that you viewed for February 26th?
It does.
Move to admit 3-16D, please.
No objection.
States 3-16D is admitted.
And publish to the jury, please. So we saw an exhibit like this before for
Yes.
February 11th.
Yes, we did.
Are we looking at information now pertaining to February 26th?
We are on this. This exhibit is text communication between Ms. Richins and Ms. Lauber on that day.
And similar map of the same area?
Yes.
Arrows denoting who sent the message?
Yes. The times they were sent and received and direction, yes.
Now, these pictures are kind of small, but similar to the last exhibit from February 11th, Ms. Richins is denoted with the red background, is that correct?
Correct. She's on the left side there.
And Ms. Lauber is denoted with the green background?
Correct.
And then we also see Robert Crozier on these exhibits, and he's in the yellow background. Is that correct?
Yes, he will come up. There he is. He'll come up on the map there on the left-hand side.
And again, Scott, if we could move through this exhibit, and Mr. Kotradimus, if you could describe what we're seeing as we go through this
Sure.
process for February 26th.
Sure. On the right-hand side, similar to the other day, there was text communications between Ms. Richins and Ms. Lauber through the 2 o'clock hour. It picked back up in the 5 p.m. hour. And at some point during the 5 p.m. hour, Ms. Lauber's device started utilizing towers in those same locations from the previous day. Provo Canyon, Utah County area, traveling north until it finally stopped in the area of the southern end of Salt Lake County. Same thing with Mr. Crozier's device, beginning once again in Davis County and moving south and utilizing towers along the way. So Ms. Lauber is now on the left-hand side. You can see by 7 p.m. or so, she is utilizing towers back in Provo Canyon, heading back to the Heber Valley area where she ultimately ends up. Mr. Crozier has returned back into the general area of the Davis County area by 8 p.m. And then you saw all the communications between Ms. Richins and Ms. Lauber, 71 texts between 2:25 p.m. and 10:33 p.m. that day. And Mr. Crozier and Ms. Lauber, 65 texts and 3 phone calls.
Now, similar to February 11th of 2022, did you look at the communications between Carmen Lauber and Robert Crozier for February 26th of 2022?
Yes.
If we could show Mr. Kotradimus 3-34D, please.
Excuse me.
Do you recognize this?
I do.
Is this an exhibit that you helped create?
It is.
And does 3-34D accurately depict the raw data that you analyzed for that date, February 26th?
It does.
Move to admit 3-34D.
Okay. States 3-34D is admitted.
And publish to the jury, please. Okay. We've seen one of these before.
Yes, we have.
We know the data that's on here. If we could, Scott, move through this, at Mr. Kotradimus, as you just described.
Yeah, so there's the 4:01 p.m. Call from the previous slide. Mr. Crozier is in Davis County. Ms. Lauber is in the Heber Valley area. To the right, those are the communications between the two. There's text and some phone calls. You can see the date stamps next to those. Essentially, what this exhibit shows is the other side of that communication or that incident or event between Ms. Lauber and Ms. Crozier, Mr. Crozier and Ms. Lauber. Sorry. The two devices appear to travel in the same direction until they come to the same generalized location, utilizing those towers, and then return back to their respective starting points.
And that location that they're meeting up at, same as February 11th, 2022?
Yes, it's consistent with that, with the Draper area near that Maverick.
Thank you, Scott. Did you analyze, moving now, to March 2nd of 2022, did you analyze CDR data for Kouri Richins' device from March 2nd, 2022?
Yes.
Scott, if we could show Mr. Kotradimus 3-17, please. Do you recognize this?
I do.
Is this the call detail records for Kouri Richins that has March 2nd?
Yes.
I'll move to admit 3-17.
Okay. 317 is admitted.
And if we could show the call from 10:22 a.m., please, from March 2nd. And 10:27 a.m. Is that the same number that we see from the call at 10:22 and the call at 10:27?
It is the same number, yes.
Are those-
Ending in 1040.
Are those outgoing phone calls from Miss Kouri Richins?
Yes.
Who was she calling at 10:22 and 10:27?
That's the IRS.
What is the duration of the call made at 10:27?
The first call is 3 minutes, and the second call at 10:27 is 101 minutes.
Still talking about March 2nd of 2022, did you look at communications between Kouri Richins and Eric Richins on that date?
Yes.
If you could show the witness 2-37D. Do you recognize this?
I do.
And is this an exhibit that you created?
Yes.
Is this a text message thread between Eric Richins and Kouri Richins?
Yes.
We will talk about the content of this exhibit at a later time. I just wanted to lay out the information that you're aware of what it is and where it came from.
Okay.
I now want to turn your attention to March 9th of 2022. Same questions as February 11th and February 26th. Did you look at communications between Kouri Richins and Carmen Lauber for March 9th of 2022?
Yes.
We could show Mr. Kotradimus 3-35D. Do you recognize this?
I do.
Is this an exhibit that you helped create
It is.
using the CDR data that you just talked about?
Correct.
Does 3-35D accurately depict the raw data contained in that CDR information?
Yes.
We'll move to admit 3-35D
States 3-35D is admitted.
and publish to the jury, please. Okay, so we've seen these before.
We have.
We're looking at the same area of the Salt Lake Valley, and again, communications for March 9th, 2022 between Kouri Richins and Carmen Lauber, is that correct?
That's correct.
Scott, if we could move through this exhibit, please.
And this is just the same representation of those records. It shows essentially the same travel, and it depicts the conversations, text conversations or communications between Ms. Richins and Ms. Lauber's devices. We got 10 o'clock hour, 11 o'clock hour. Ms. Lauber's moving. She moves a little north in this. If you want to stop it right there, Scott, just for the 12-11, 12-13. She moves north out of the Heber Valley for this particular event.
Is it like Rockport Reservoir?
That tower at 12:11 p.m. is located very close to the Richins residence. Other than that, the travel is going to be depicted in a similar manner. Miss Lauber is going to travel same route through Provo Canyon into the south end of the Salt Lake County area, in an area consistent with being at or near the Draper, the Maverick and Draper. And Mr. Crozier is going to do the same thing. He's going to travel south, and his device is going to utilize towers in that direction as well. On the right-hand side, you're just seeing more communications between Miss Lauber and Miss Richins from that day. So Mr. Crozier and Miss Lauber's devices are coming together, utilizing the same tower in that area. Again, that's the tower across the freeway from the Maverick
Come together
and Draper.
right now.
Then the two will depart, or presumably depart, and their devices are utilizing different towers until they return to their respective starting points.
Did you look at communications between Carmen Lauber and Robert Crozier for March 9th, 2022?
Yes.
If we could show the witness 3-36D. Do you recognize this?
I do.
Is this an exhibit that you helped create?
It is?
Is it using the raw data from March 9th, CDR data from March 9th, 2022?
Yes.
Does 3-36D accurately depict the raw data you just described?
It does.
Move to admit 3-36D.
3-36D is admitted.
And again, we've seen this before.
Yes.
This is for March 9th of 2022. And this exhibit, who are the communications between in this exhibit?
This is communications between Mr. Crozier and Miss Lauber for that day, March 9th.
And Scott, if we could move through this exhibit, please.
And you've essentially seen the map before on the previous slide between Miss Crozier and Miss Lauber. The thing that's different on this is the the communications are just between Mr. Crozier and Miss Lauber, or Miss Rich, or excuse me, Mr. Crozier and Miss Lauber. Again, 11 o'clock hour, 12 o'clock hour, they're communicating. The devices essentially come together into the same general location, utilizing a tower there. Again, that depicts the tower and across the freeway from the Draper Maverick. The two parties continue to communicate until they return to the Heber Valley area and the Davis County area, respectively.
You keep saying Davis County, but that it's right on the border. I think that's actually in Weber County.
So far, we looked at communications and location data for February 11th, 2022, February 26th, 2022, and March 9th of 2022. Other than those 3 occasions, did Carmen Lauber ever visit that Maverick and Draper in all the data that you reviewed?
No, her device never was never in that general area.
Did she ever meet up with Robert Crozier? Did their devices come together at any other time other than those 3 occasions that we've talked about here?
No.
I want to turn your attention to March 3rd, 2022. Did you analyze data from Eric Richins' phone from the night he died?
Yes.
You looked at call records?
Yes.
And you looked at text messages and web searches?
Yes.
We could show the witness 3-39D. Do you recognize this?
I do.
Is this an exhibit that you helped create?
It is.
Does it accurately depict the raw data that you reviewed from Eric Richins' phone?
Yes.
Move to admit 3-39D.
3-39D is admitted.
You could publish this to the jury, please. So you might want to step down for this so we can just describe for the jury what we're looking at here.
It's very small, whatever it is. Oh, the text messages, text to
Sure.
Pedro.
So this is at the top. It's headed. The heading is Eric Richins' phone activity, March 3rd, 2022. This is from 8:30 p.m. that evening until midnight. It's basically just a moving timeline, so you can see what Eric's device was doing during that time period, in context to text messaging and web searches, that type of thing. So at 8:30, there's a text to a contact named Pedro Sonora, and then there's a text from like 9 seconds later. Those continue. There's a few of those, and then there are texts between Eric Richins' device and a contact named Scott Wagner in that device. Those continue into and through 8:30. There is a discussion going on between Mr. Richins and Scott Wagner, kind of back and forth during that time. And then at 8:50 p.m. on that day, Scott Wagner calls Eric Richins, and they talk for 8 minutes and 32 seconds. At 9:45 p.m., a Google search is made from Eric Richins' device. There's a misspell in it, but he's basically searching how far is it from Scottsdale to Nogales. And then at 10:18 p.m., there's an incoming text from a contact titled Raul C&E.
Thank you. For that last text message that's listed in the 10 o'clock or 10 p.m. hour, was there any indication that that message was opened by Eric Richins?
No.
During this time frame from 8:30 p.m. to 12 a.m. on March 3rd, how many phone calls were made on Eric Richins' device?
One.
That's the phone call that you talked about to Scott Wagner.
Correct.
No other phone calls made on that device that night.
No, between 8:30 and midnight, no.
Talking about same time frame, the night of March 3rd, 2022, did you look at Kouri Richins' phone for that same time frame?
Yes.
Did you analyze the data and device events for that phone?
Yes.
If we could show 3-18D1. Do you recognize this?
I do.
Is this an exhibit that you helped create
Yes.
using the raw data from Kouri Richins' phone?
Yes.
Does 3-18D1 accurately depict the raw data that you reviewed?
It does.
I'll move to admit 3-18D1.
No objection.
318D1 is admitted.
If we could publish this, please. Similar to Eric Richins' device, I guess not showing communications, but what are we looking at here for this device data?
So there's the activity sensor and device events for that device.
When you say device events, what do you mean?
So there are certain events that are captured in a device in the system files that detect various things. One of those things is locks and unlocks, meaning when you locked or unlocked your phone. The activity sensor is device movement. So there are accelerometers and gyroscopes and whatnot inside your device. And when it moves and it detects movements, it reports that to the system files and it retains that.
I now want to talk about March 4th of 2022. For Kouri Richins' phone, did you look at movement and device events for Kouri Richins' phone for March 4th of 2022?
Yes.
If we could show Exhibit 3-18D. Do you recognize this?
I do.
Did you help create it?
Yes.
Does it fairly and accurately depict the raw data that you reviewed from Kouri Richins' phone?
Yes.
Move to admit 3-18D.
Okay. 3-18D is admitted.
So walk us through, there's some different things here, and maybe you want to step down to the screen to show the jury what these different markers on this exhibit mean.
Sure. So we have a device event. The first thing we have for a device event on that day or in that morning is 3:06:50, the phone is unlocked. That unlock is for 28 seconds. At 3:07:04, there's a speaker activation. What that is there's an audio output route. There's audio routing in a device through the system files, and it detects when the speaker is activated. So anytime the phone is using the external speaker, you should get a system file report or an audio output report on that, and it'll tell you that the speaker's in use. Okay. At 3:08:10, the activity sensor picks up that a device travels 243 feet. So the 3:08:10 is the beginning of that trip. It's not the end of that trip. And at 3:10:37, the phone is unlocked for 1 minute 40 seconds. At 3:15:59, the phone is unlocked again for 37 seconds. At 3:19:07, the phone is unlocked once more for 28 seconds. And at 3:19:39 a.m., the phone is unlocked briefly for 3 seconds. We have a timestamp for a 911 call at 3:21:05. We have a receiver activation. We have a device, another activity movement, meaning the device is reporting that it had moved again. And then at 3:22, there is a receiver activation. And a receiver activation is when you hold the phone, a phone or a device up to your ear, say presumably your face, to make a phone call. There's a proximity sensor inside the device that activates the receiver. And so there's an activation there at 3:22:12.
Thank you. You talked about the receiver activation. Is it possible that a call can start before the receiver is being used?
Yes.
How does that work?
If you dial a number, for instance, the receiver activation only reports when you place the phone up to your. It has to detect the proximity sensor.
So it's a movement.
It's a movement, yes.
Did you also pull or look at data from Kouri Richins' phone from the morning of March 4th, 2022?
Yes.
We could show the witness exhibit 3-19. Do you recognize this?
I do.
What is it?
These are 3 thumbnails, PNG files recovered from Ms. Richins' device.
Does 319 accurately depict the raw data that you analyzed from Ms. Richins' phone?
Yes.
Move to admit 3-19.
Judge, may I voir dire the witness? Oh, maybe approach.
Defense asked of voir dire, then says approach. Judge might want to know why they're voir diring. Might allow this. This was teased earlier. The defense said we'd like to voir dire their witness when it gets to this point. Mr. Ramos lounging on the bar, on the bench, speaking to the judge, listing his reasonings for why he wants to voir dire the witness. Bretta, we've had an exciting day. We've had a little bit of spice here and there. It's been a good day all throughout. So we expect more to be coming. This expert witness is trying not to look very interested in whatever's happening right to his right about him. How long till I get the trust money? Thankfully, that search wasn't in there. Not sure why he needs the voir dire. I'd be interested to see the line of questioning. This is right before, I believe, we're going to see the three memes, right? We saw the 3 memes. So there's this Eric's sister there in the back row. The family sits alternating odds and even days. Today is a even day, which means Eric's family sits on the back row. On odd days, they sit on the second row.
Sure, please proceed.
Judge says no.
Looking at Exhibit 3-19, you testified these were located on or in the analysis of Kouri Richins' phone. Where specifically in that data were these images located?
They were in the image folder. They were in the image files.
What does describe what the image file is? Is that a camera roll or just more description about what an image file is?
So as it relates to these are PNG files. They were located in the image portion of, so if you open the extraction and you're analyzing it and you look under images, these are actually found in the timeline as well. Like you can just see them in there. But when you click into those, there's information that's presented to you, and it will tell you the file path of where these belong, or where they were last seen by the device. And so in the image file, there's a pathway, and so these images were last seen in a SMS, so a text like an iMessage. Photo search section is the pathway for those, meaning it was related to the messaging system inside the device.
I'll move to admit 3-19.
Mr. Ramos.
If we could just lay a little bit more foundation in terms of which people in the text message chain, he indicated that they were in the.
I'm not sure that's what he said, but.
Or if we could get clarification on that.
Sure.
Objects on foundation.
Yeah, sure, and I ask another question about the I heard the words photo search related to the SMS function.
Right, so let me be a little more precise with my questions.
Okay.
Were these part of a text message?
At some point, yes.
Do you know if that text message was incoming or outgoing from Ms. Richins' device?
No.
Why not?
Because the original images and the source of these images was deleted from the phone. It no longer exists on the phone. These 3 PNG files are what we call ghost or orphaned images. When an image is, like when a text is built and you add images to it, or when you receive images and you click those, it creates a print of it, like basically a thumbnail of it. Now, if you send that text or receive that text, and then you delete it from your system, and then the database overwrites it because of time has passed and there's no more room in that file, you'll never know the source of that text, whether it was incoming or outgoing, who sent it, that type of thing. All you're going to see is the remnant of that. And that's what these are, the small PNG files.
Again, move to admit 3-19.
Judge, we were in your objection. At this point, it seems like it's what Mr. Cortez found. It's a remnant of something.
I understand defendant's objection. It is respectfully overruled.
Wow.
You can explore these topics during cross-examination.
Look at Kouri's face.
State's Exhibit 3-19 is admitted.
We could publish, please.
And here they are.
So these are the images you were just describing.
Yes.
Wiping my tears with money.
And you
Idiots,
described that
idiots
they were
everywhere.
found in the image files as a remnant of possibly a text message.
Right. I wouldn't say a remnant, it's a thumbnail. I mean, it's
thumbnail.
a PNG file. I mean, it's a thumbnail, yes.
From the data that you analyzed, were you able to tell if these images were accessed by Ms. Richins' phone?
They were accessed by the system in her phone, yes.
How do you know that?
It gives an accessed indication in the file path, in the data and the extraction. It'll say when the device was accessed, and it will give a timestamp.
When we say accessed, what does that mean?
It just means when the file, or when that image was either selected or viewed, or, I mean, it's accessed. Yeah.
But it means it was selected or viewed by the person with that device.
Correct.
You mentioned there was a timestamp. When were these images accessed on Kouri Richins' phone?
8:29 a.m. on March 4th.
Was the phone also manipulated in some way during that same time?
There was activity on that device, yes.
What do you mean activity?
There was prior to that at 8:28 there was an unlock event that lasted the duration of this access point. There was the device event log shows that the device was actually turned into portrait view, and then turned into landscape view, turned back into portrait view, until ultimately it was locked again. I think the lock was at 8:34, but I'm not 100% sure on the time.
So those, the turning of the phone, the unlocking of the phone, those correlate with the time that these images were accessed?
Yeah, around the same time, yeah, during the same unlock event.
Right after the
So now I want to
paramedics
turn
left.
your attention to the post-April 13th, 2022 phones from Kouri Richins. We know from, Scott, if you could put up 3-37D, please. And you can publish that to the jury. It's been admitted. So I'm referencing this, the date on here when the silver phone and the blue iPhone were being used by Ms. Richins.
Right.
Did you look at, when you were analyzing the blue phone, did you find web searches during April, that time frame the phone was used, that were relevant to this case?
Yes.
Scott, if you could show the witness
Here we go.
3-26D.
You guys want to see this?
Do you recognize this?
I do.
Are these web searches that were located on that blue iPhone?
Yes.
If you could show Scott 3-29D. Do you recognize this?
Yes.
These also web searches that were located on the blue iPhone?
Yes.
And then Scott, also 3-30D.
Yeah, I think an objection.
Same question, is this a web search that was located on that blue iPhone?
Yeah, this is web history.
A web history?
Yes, which meaning the difference is one thing is a search, the other is a site visit, a website visit.
And do these three exhibits, 3-26D, 3-29D, and 3-30D, accurately depict the raw data that you analyzed for that blue iPhone?
Yes.
I'll move to admit those three.
Mr. Ramos?
Mr. Ramos, do you have issues?
I have an objection to the searches and we have an objection as to how they're going to be presented, meaning that redaction. My understanding is that Mr. Kouri did not make those redactions. So I'd like to approach and present a proposal on how to submit it.
Interesting. It's going to fight it a little bit, see if they can influence how these are coming in. Approaching the bench. This is a sidebar. So not really an objection here, but buckle up. This is going to be good. I may or may not be taking screenshots of various people just for my documentation so I can remember what happened when. And I might make a meme. I might. Did someone take his kombucha away? He has not had it that I can see since the first day. What were the pictures saying? Let me pull them up if I can. Just 1 second. Let's go full screen. The pictures are right here. One of them is wiping your tears with $100 bills. The next one is Kevin Spacey saying, idiots everywhere. And the last one is a political figure saying, I'm really rich.
So it was 26, 29, and 30, correct, Ms. Sherbanek?
Yes.
States 3-26D, 29D, and 30D are admitted. We're going to publish those. I have an instruction for the jury. Scott, could you go to 26 for me for a moment? Ladies and gentlemen, as you look at 26, 29, and 30D, you'll see these blue blobs that have no text behind them. Those are intentional redactions of information that has no relevance to this case. Please do not speculate about what was behind the blue bob. It's irrelevant. Just ignore it. Ms. Sherbanek, please continue.
So as we were talking about these three exhibits that we will go through in turn, you mentioned web searches versus site visits.
Yes.
What are we looking at here?
These are web searches.
What's the difference?
So when you type a search into your device and to presumably search for something on the internet, when you type it in and you hit send to search, it logs the search that you had typed into your device.
And so someone could search for any multitude of things. We're all aware of that, but maybe not if the results come up. If they actually click on a result, that would be a site.
Right. We normally see, analysts will normally see corresponding web histories related to those searches. So if you were looking for a type of vehicle, you would have a search for a type of vehicle, like a 2026 Toyota 4Runner. You're looking to buy one. And then right behind that, you'll see web history, meaning what happened was you typed in that search field, it popped up, and then there's some suggested websites for you to go to based on your search. And if you click through to those will show as a web history, meaning a site that you actually visited.
And so what are we looking at here?
Right here, we're just looking at the search function. These are just searches that were inputted into the device.
And this is in that blue iPhone, right?
In the blue iPhone, yes.
We need timestamps on this because they're
could,
juicy. Oh my goodness.
Do the same expanding for each page of 2-26D so the jury can see the different entries.
I'll see if I can read these for you. Women, Utah prison, Summit County District Attorney. Can cops uncover deleted messages on iPhone? How to lock my iCloud? What does lock lost iPhone actually do? How to completely wipe a phone clear remotely? How to erase a phone data permanently with EMI number? How to permanently delete information from an iPhone? How to permanently delete information from an iPhone remotely? Can cops force you to do a lie detector test? What happens if you're detained but never got read Miranda rights? Can probable cause be a testimony? Oh my goodness. She's searching everything. What are you allowed inside Utah jails? Phone Doc Park City. CUNA mutual policy on life insurance, cause of death. Will life insurance pay if death certificate says pending? Death certificate says pending. Will life insurance pay? Federal Correctional Institution, Dublin, California. Luxury prisons for the rich in America. If someone is poisoned, what does it go down on the death certificate as? What is presump positive for naloxone? Is naloxone similar to heroin? Where is my location on iPhone? What prescription just is to stop alcoholics? Like, the spellings are terrible. K. Richins Realty net worth. Kouri Richins Camus net worth. FBI analysis of electronics and investigation. What is FBI analysis of electronics? How to delete Facebook. Find my iPhone is off. Is location still correct? Can I find my iPhone work if off? Is find my iPhone ever wrong? Can FBI find deleted messages? FBI searching electronics. What does FBI do with electronics is for searches? FBI searching electronics. What is considered non-natural manner of death? Who determines cause of death on death certificate? Can the cause of death be changed on a death certificate? What is white-collar crime? Why would the FBI be involved? Is the medical examiner report and autopsy report different? When does the FBI get involved in a case? How long does life insurance companies take to pay? What is lethal dose of fentanyl? What is considered a lethal dose of fentanyl? Can a manner of death be changed on a death certificate? Change my passcode on iPhone. What happens if you give Narcan to someone who doesn't need it? Is circumstance unknown and an accident? How long does life insurance companies take to pay?
So we saw some web searches on 3-26D that related to remotely
Asking
wiping
for a
an
friend.
iPhone or remotely deleting text messages.
Yes.
Was the blue iPhone being used by Kouri Richins in the time after her original phone? That white iPhone was seized by police?
Yes.
Scott, if we could put up 3-29D.
Woodman, Utah Prison, Summit County, Utah District Attorney. Can cops uncover deleted messages? iPhone. How to lock my iCloud. What does lock lost iPhone actually do? Summit County District Court. How to find my iPhone off. On cameras. Utah State Prison, Timpanogos Women's Facility, Utah State inmate roster. Another search in here. Let me see that one. Oh, there's the deseretnews.com. Things you need to know about. Can't see it. 5 things you need to know about the new Utah State Prison and
this
when.
activity on the phone, does that indicate a website visit?
The old one will be torn down. Can you delete everything off an iCloud account? Can you delete everything off an old iPhone without actually having it? Can you deleted text messages be retrieved? Can you change the password remotely off a lost phone? Can deleted text messages be retrieved from an iPhone? Can you change the password remotely of a lost cell phone? Log into iCloud account. What do cops when they seize electronics? What information can be obtained from a cell phone? I'm correcting a lot of these spelling errors because there are so many. What happens to deleted messages?
Again, this indicates a website visit.
Yes.
Police can't read your messages, but here's what they can. iMessages, but here's what they can see. How long does life insurance companies take to pay? What is lethal dose of fentanyl? What is considered a lethal dose of fentanyl? Can a manner of death be changed on a death certificate? How long does life insurance companies take to pay? How quickly do you get your life insurance payout? Within 60 days of receiving a death claim filing. Delay in claim payment for death certificate with pending cause of death. What is considered a non-natural manner of death? Who determines cause of death on a death certificate? Can the cause of death be changed on a death certificate? What is white-collar crime? Why would the FBI be involved? Is the medical examiner report and autopsy report different? When does the FBI get involved in a case? Cause of death usually does not impact life insurance payout. What we investigate. This is from the FBI. How does the FBI work a case? How we investigate. Signs of being under federal investigation. Oh my goodness. Kouri or KN Richins Realty net worth. Kouri Richins Camus net worth. FBI analysis of electronics and investigation. What is FBI analysis of electronics? I've got a soundbite I just have to play. How to delete Facebook. Find my iPhone is off. Is the location still correct? Can I find my iPhone work it off? Is find my iPhone ever wrong? Can FBI find deleted messages? What does FBI do with electronics for searches? FBI searching electronics. FBI searching electronics. How to completely wipe an iPhone clear remotely. How to erase a phone data permanently with the EMI number. How to permanently delete information from an iPhone. How to permanently delete information from an iPhone remotely. Can cops force you to do a lie detector test? What happens if you're detained but never got read Miranda rights? Can probable cause be a testimony? So a lot of these are repeats for some reason. FBI conducted potentially millions of searches of Americans' data last year, report says. How do police and forensic analysts recover deleted data from phones? I think that's an ad for Celebrite. Couched in an article. A few more texts here. What happens if you give Narcan to someone who doesn't need it? Is circumstance unknown an accident? How long does life insurance companies take them to
We
pay?
can move to 3-30D.
Big sigh from Kouri there in the background. What happens to deleted messages? Police can't read your iMessages,
And
but
these are
here's
the
what they can
website
see.
visits.
Yes, correct.
5 things you need to know about the new Utah State Prison and when the old one will be torn down. Delay in claim payment for death certificate with pending cause of death from Bladen Online. Cause of death usually does not impact life insurance payment. That's from a life insurance law firm. Unless a suicide was involved. FBI conducted potentially millions of searches of America's data last year, report says. That's from the Wall Street Journal. How do police and forensic analysts recover deleted data from phones? Make use of. Is circumstance unknown an accident? How long does life insurance companies taken to pay? How we investigate. This is FBI stuff. How does the FBI work a case? Signs of being under a federal investigation. You'll know. You'll know.
Just a moment.
So was anyone's opinion changed
Sir,
in the
those are all
last
my
10
questions
minutes?
for you at the moment. I think the defense may have some as well.
Thank you.
Still some more? Need some more?
I need a little more. That'd be great. Thank you, sir.
Zach, can we get a refill for the witness, please?
Thank you, sir.
I got to play this soundbite.
Did the defendant find out how the FBI
Ramos.
finds people in this case?
Oh, she found out.
Did you want a break before beginning?
Thank you.
Yeah, if I take a break, I'll gather my thoughts and we'll get out of here on time.
Don't commit to anything. But let's just take a stretch the leg break. We'll come back at 3:45. Thank you. Please rise for the jury.
Mr. Ramos says, I'd like to take a break. Let me gather my thoughts and we'll get out of here on time. So it sounds like we don't have very much left here today, but obviously the more distance they can put between the time the jury saw those searches and the time they have to get up and face the jury, the better. But those are bad. What not to search? Kouri just taught a master
We'll be in
class.
recess until 3:45. Mr. Contreras, if you want to stretch your legs, use the restroom, that's fine. Just don't talk to anybody.
It's a 6-minute break.
Can you possibly have 10?
No.
Defense wants 10, judge says no. 6 minutes is all you get. So we're going to be back here very, very quickly. Wow, those hurt. Those are painful searches. Anyone who has watched any true crime show that had any electronics data in it is wincing, is like squirming with how uncomfortable they are with those searches. Sorry, I disappeared. I wanted to make sure everyone could see everything, so I wanted to jump off. I tried to give you guys, in case you wanted to get a screenshot or whatever. Wow, she found out. And once she's searching, then she, goes down the rabbit hole of, wait, hang on, they can get stuff off my device? How do they do that? She figures out how, and she's like, how do I erase it remotely? And she starts Googling that, and that's on there too. Oh, man. This was bad. This was so bad. Play the soundbite one more time.
Did the defendant find out how the FBI finds people in this case?
Oh, she found out.
Oh, my goodness. Let's see. What didn't she search? Well, I can tell you what she did. Luxury prisons for the rich? Like luxury women's prisons for the rich? What's a lethal fentanyl overdose amount? This is when? When are these searches done? Oh my goodness. Maybe defense can point out some timeline stuff because, believe it or not, I was surprised. These searches did not have the timestamp on them. Now, if some of this fentanyl searches especially, if that was done after the autopsy report came back, at least you have something to hide under, right? Saying, I was just trying to figure out what had happened to my husband. How much was that? I mean, what does this mean? There you've got some shelter. And hopefully for Kouri's sake, that's the case, because if this was done before the autopsy report came back, where are the verdict forms? We're ready, Judge. We're ready. She may have searched for, I murked my husband and now I've Googled a bunch of incriminating stuff. What should I do? Surprised I didn't object as to where was the proof Kouri actually had the phone. It's funny because over the weekend I was setting up computers that are going to be used in a location that is shared with a lot of people. And there are ways to configure a computer to basically destroy a lot of evidence automatically when you're done using it. And so limiting the ability for them to log into private accounts, and you can't log into Outlook and LinkedIn and whatever else, your Xbox account. We did all that. She really searched luxury prisons. Not true. She searched for it. I did not make up any of those searches. I did correct a lot of them because her spelling was atrocious, like terrible, terrible spelling. But you get the idea of what she was searching from the wording. So we don't know when she did the searches. Not yet, Betty. And I'm surprised. I mean, look, let me just put some up on the screen here. They're not the clearest, but let's go over here really quickly. See this one right here. Looking at the top. Can you delete everything on an iCloud account? Can you delete everything on an old iPhone without actually having it? Can deleted text messages be retrieved? Right here, this box just to the left of it, like we've got the blue box just to the left of the blue box, it says timestamp, and there's nothing there. There's nothing there. We need those timestamps for this really to make sense. They haven't been in there. I think if the defense gets to introduce these and say, actually, well, if you look at all the data, this was done at this time, and this is what was happening here, that would take a lot of the wind out of the sails on this for the prosecution, and it might make him look a little bit shady. But I don't think you can hide all of these under that. She's just, how to delete phones that cops have confiscated, basically, in your search history is not a good look. Can you blame all the searches on the dog or the small children? Nope. Can't wait to hear Selena call and tell us about the jury reacting to this. The gallery members can't see very well the evidence. They can't see it very well. So we didn't get a lot of reactions from the gallery, most likely because they can't read them. But the jury will have copies of this. They'll be able to read all of this when they're deliberating. I'm not convinced yet, says Gator Gal, but almost, but not yet. Timestamps will be what the defense hammers on. If they are bad, let me say this. Shame on the prosecution. Oh, Judge is back already. Shame on the prosecution for for setting that up for the defense to tee off on it. Shame on you. You should come out there and tell us those dates up ahead of so there's not an expectation and let back. Judge is saying, "Are you guys ready?" Timestamps missing screams shady. I'm not convinced. I think they were all after his death, and the defense did say the fentanyl-related ones were done after she received the autopsy report in the preliminary hearing. See, and that takes the wind out of the sails. Suddenly, it's not like what not to search. It's just like this is what everyone would have searched if they were in the same situation, and it becomes perfectly reasonable. She didn't search plea deals. She didn't. You're right. The timestamp column was there. There was just nothing visible in the populated there. And maybe they made it too small. If they expanded it, it would have shown up. But let us know up front. That word poison, though, says Bree Rouse, because who would think poison if they didn't poison someone? I would be looking up how I missed all the signs my husband was addicted to fentanyl. The memes are worse to me, says True Crime Addict. Judge is back. Mr. Ramos is up. He's promised to get us out on time. Let's listen to see what he has.
All rise.
Jury's back.
Go ahead and have a seat, folks. Thank you.
Mr. Ramos standing tall. See what he can save from this.
All right, please have a seat. Thank you. Mr. Ramos,
Thank you,
please
Judge.
proceed.
Mr. Kouri, how are you?
I'm doing great. Mr. Ramos, how are you?
Good seeing you again.
Good to see you.
You know what? Let's just dive right into the GIFs,
Oh,
the
okay.
PNG files.
Yeah, sure.
Right?
Sure.
Could we pull up those that exhibit?
We're putting the 3 memes back on the screen.
And just for the witness, Judge.
Yeah, don't show the jury again.
So I have this document here. It's been marked as State's Exhibit 340. Do you recognize that?
Yes, sir.
Now, when you were testifying earlier, you informed the jury that it was all the image files that you received, correct?
Well, just for this representation is just for that, for the 4th.
Correct.
Yeah.
Yes. So what we're looking at are
It's part of that, yes.
Images, data files for that day. Specifically, though, I think there was a range. It was for the March 4th, correct?
Correct.
Okay. Now, in that, there were 39 images, right?
Correct.
Now, of those images, obviously, we've seen 3 of them, okay?
Yes.
So I want to focus on those, okay?
These 3.
All right. So what I'm going to do is I'm going to pull up those 3 images that you've seen,
Okay.
okay? And I'm going to show you the MAC, right?
Okay.
Which is the modified access created.
Yep.
Okay?
Yep.
All right. We can pull that up for him. Now, could you see those on the left-hand side there?
I do, yes.
Okay. One second. That's what he can see, right? Okay. Sorry, I have a smaller screen here, so I just want to
Okay.
make sure we're on the same page.
All right, yeah.
Okay. On the left-hand side, can you tell me, or tell the jury, if all of these images were accessed on the same date and time?
Yes, they
Down
were.
to the second?
Yes.
Okay. Now, you mentioned that these are .png files, okay?
Yes.
Now, if we look to the right, there is what appears to not be a GIF, I guess, or it is a thumbnail, but it is of a, how would you describe it? What's the picture? What's that picture of?
I don't, which one are we looking at?
The one on the right-hand side, it looks like a house almost in the distance.
Oh, yeah, yeah, there's a photo of a piece of property, it looks like, yes.
Are you familiar with that property?
I can't tell what it is from the photo.
Fair enough.
No.
Now, can you just look at the time and date?
Yes.
Okay. Does that match the .pmg files that we saw?
It does.
Okay.
Yes.
To the second?
It does.
Okay.
Yes.
So, just practically speaking, okay, we can take that down.
4 images in the same second?
Do you find that odd?
Yes.
Not necessarily.
Okay. Let's walk through it.
Okay.
Okay. I'm gonna walk through an example for you.
Okay.
Okay.
All right.
And then I want you to explain it to me.
Okay.
Okay. Now, in fact, let's do this. Come on, Phil. So
Here comes a demonstration.
if I pull up my phone right now, I just unlocked it. Now I'm going to send a text message, okay, to my son.
All right.
Okay. Now I'm going to go ahead and add a thumbnail.
A photo, yeah.
Photo, okay. And I'll do a GIF, okay.
Okay.
And so I'm looking for one. I found one. So I just clicked on that.
Okay.
Okay. Now I just clicked on another one.
Okay.
And I just clicked on another one.
Yes.
Okay. Now I'm going to add also a picture, okay, just for my folder.
Okay.
Okay. Now I've selected those 4 items, okay, and I'm about to send it.
Yes.
Okay. So if you were to get my phone and put it in your system, extract it, and you analyze it, obviously it would be a text message.
It would, yes.
Correct?
Yes.
Now, the modified access created, would all of those be the same date, time, down to the second?
They could be.
Could be.
Yes.
There's a lot of reasons for that.
Yes.
Okay. For example, the type of iOS I have.
That could affect it, yes.
The type of extraction that's done.
I don't know if the extraction type would determine that or not.
Logical versus physical.
I still don't think in the way these images were in the database.
Okay.
I don't think that would be. I don't think that would be accurate.
So then let's look at the database.
Okay.
Where exactly were these images?
So they were in the database. There's a pathway in there.
Yeah, let's pull that up.
Yeah,
again,
so that's
please.
where they're at.
Okay.
Okay. So they are in an SMS photo database essentially. All right.
So is it up there now for you?
It is not. Not yet.
Okay. Now, the source file, is that what we're referring to?
Yes.
Okay.
Yep.
So I see here has a bunch of numbers, underscore files, full, .zip, right?
Yeah.
Private, var, mobile, library, cache.
Yes.
Right?
Yep.
Okay. Talk to me about cache.
All right. So, caches are folders. They're just places where the system stores data.
Okay.
Yeah.
And if I were to go to my phone right now, I could find those .png files, that image I just sent, right? If I go directly to my text message, correct?
You could, yes. Yep.
Right, because I just sent it.
Uh-huh.
Okay. Now, here in this file, this doesn't lead you straight to a text message.
Correct.
Okay. And so it is, and I think what you said in your direct, I think it was the system, I think is the word, you were very specific. The system in her phone, I logged it. Is that correct?
Yes.
Okay.
Those are databases.
Correct.
Yeah, yes.
Okay. So fair to say, and you indicated in your testimony early, so I think I'm right, that there are certain things in our phones that are there, but we can't necessarily access them.
Joe.
Correct.
We need a process to go kind of below the surface.
Right.
Okay.
If the
Now,
emoji don't fit, you
in
must have
this
quit.
case, these .pngs, you had 39 of them, correct?
Yes.
Okay. Now, you only selected 3.
Yes.
Okay. Did you select those? I shouldn't put.
I provided what I provided. Like,
and-
I provided the entire extraction report, and then I provided the part of the extraction report for that day.
Okay, so
Yes.
you provided the full 39.
Yes.
Okay, understood. Now, I want to go back to that other image, okay?
Okay.
Now, these have the exact same date, the exact same time, down to the second, okay? Are they tied together?
I don't know that.
You don't.
No.
In fact, it's impossible to know.
It really is.
Now, in what you do, there is, we heard the word a lot, analysis, right?
Yes.
You analyze.
Right.
Okay. Now, we know that you can, we get the information from Grade Key, it's extracted, then we put it in Celebrite. The analysis comes in reviewing the report, correct?
Correct.
Okay. Now, and you were also very careful in your direct testimony that it's not necessarily, I don't think you use these words, but it's not infallible, right? This Celebrite report.
Correct.
Okay. In fact, Celebrite itself recommends its operators, is that the word?
Yes.
To make sure that they validate their data.
Correct.
Right?
Yes.
And there's a lot of reasons for that.
Yes.
For example, you do have a hardware that you use, correct?
Yes.
You want to validate it's working.
Correct.
And then also the software that you use, you want to validate that that's working.
Yes.
Okay. Now, this might be an oversimplification, so
that's okay.
But I'm trying to process it. Okay. A lot of money went into making those phones.
Yes.
A lot of the data and how it works is all of it's proprietary. Correct?
Yes.
Now, in a way, Celebrite is trying to hack the phone to get the information.
Doesn't really hack it, but it parses the data in there.
It parses
But
the data.
Yeah.
Okay. And when it spits out, that's not a common term. When the report gives you this information, you can't take it as God's truth.
There's context to a lot of stuff. So, yeah, I mean, I can take it as God's truth, quote unquote.
Yeah.
That is how the system files within the are constructed.
You can take it that that's how Celebrite put the data or extracted the data.
Correct.
Now, you've heard, I suspect, of the epoch time.
Yes.
Okay. Now, if you could explain to the jury epoch time in terms of digital forensics.
This is getting really nerdy.
Cannot.
No.
Why not?
I don't have enough familiarization with it. I just don't.
Okay.
Not on the stand.
All right. Well, is it fair to say that, let's look at this created and modified and accessed, that date and time.
Okay.
Are you aware that that time isn't actually how it's stored on the phones?
It's in relation
I'm not
to the
sure I
epoch
understand the question.
Sure. So the epoch time, if you're not familiar with it, it's the number of seconds that has elapsed since
the creation
January
of
1st, 1970. Are you
He's
familiar with
testifying.
that?
I am.
Oh, sorry, Judge.
There was an
What was the
objection.
objection?
Counsel's testifying.
He said he couldn't testify about what epoch time is.
So
foundation.
foundation. I think you're laying foundation.
I am,
right?
Judge.
Let's see where this goes. Overruled.
So-
If you would, I interrupted you, gentlemen, if you would ask that question.
Absolutely, Judge. So the epoch time, and I'm just going to, I'll explain it how I know it, and if it refreshes your recollection, great. If not, we'll move on.
Okay.
Okay. So epoch time is the number of seconds that has elapsed since January 1st, 1970. Okay?
Yes.
Don't know why they did it this way,
It was
but
the
that is how
creation
the
of,
phones
like, Linux
have
or whatever.
registered the information. Or were you aware of that?
Yes, and I don't know the technical aspects of it, but it's a programming reason.
Correct. And because we're not going to do the math together.
No, we're not.
We rely, or in this case, you were relying on Celebrite to do that.
Correct.
Correct. Now, you also, a way to validate your data, because things even as, little as time, you also have the ability to cross-reference the data that you have in your phone, in the Celebrite report, the extraction, with other information, correct?
Correct.
So for example, the call logs, the text messages that you sent out, right, that's presented in the extraction.
Yes.
You could then compare it to the call detail records.
Correct.
Right? And you could say, oh yeah, you know what, this matches up.
Yes.
Okay. And you do that in a way to make sure that the information you're getting is correct.
Yes.
Okay. Now, when we look at this 4 images, the 3, I'm going to call them the what's been admitted as the 3 PNGs, okay, which we all saw, or let's call them GIFs, even though I know they're not right now.
Right. But just so everybody's aware. Okay. And then we have this photo that appears to be of a home, okay?
Right.
Now, you have records and you have call logs for March 4th, correct?
Yes.
Okay. And you can see who all communicated that day.
Correct.
Correct? And you could also get that through call detail records, correct?
Not always.
But the call detail records you indicated mark the time that a call was sent out and a text was sent out.
If it hits the carrier. So if it's a Wi-Fi call or if it's like iMessage, like iPhone to iPhone, iMessaging,
okay.
it can route around it and it won't hit the call detail record.
Perfect. So you had on March 4th at least some information in what you received from the extraction report that some calls were made, some text messages were sent from Miss Richins' phone.
Yes.
Okay. Now, with that information, you can, if you wanted to, you can attempt to see whether this image was sent or received by somebody, correct?
Yes.
Okay. You did not do that.
I did do that.
Okay, and who did it come back to?
I don't know. It was not available in the system file.
Okay.
Would you like, can I explain why?
Sure. Yeah, that'd be great.
Okay. Why I think, based on, yeah.
Yeah.
There is, from the time this event occurred on March 4th till the time the phone was seized on April 13th, I believe, 2022, there's an extended period of time that has passed in data terms, okay? So the reason why going back to the source on this is challenging is if the text source of this, incoming or outgoing, is missing, you can sometimes go into the data file, like from the timeline and from the extraction, you can go into the database information. You can go in there and you can look at that to see if that information is contained in the database still. The problem is that data is overwritten. Once it's deleted, the database then overwrites it. So then what happens is the source in there goes away. There's small amounts of data that are in there.
Like traces.
Well, like PNGs.
Yeah.
Okay, that are still there. But like I kind of explained with the data space, think of it as a...
Oh, 1 second. Is that like the garbage collection?
Yeah, we're talking about that, right? So so deletion. So think of that as, think of that deletion file as like the trash can in your house, like in your kitchen, okay? So you delete things, you throw things into that. Well, eventually it gets full and you got to take it out to the curb and the garbage man comes and gets it and it's gone,
right?
Okay? So the more you use it, the more you have to take it out,
So
okay?
Let me stop you there.
Yes.
Because what I'm asking about is, I understand that you tried.
I'm getting there, I promise.
Oh, no, real quick.
Okay.
Okay, go ahead.
Okay, yeah.
Go ahead.
All right. So those databases store that information for a while, okay? Then what happens is that text information, that the text threads, they're stored in a different place than these. What happens is every, I don't know, 30-ish days, don't hold me to that, but it's roughly, this iOS system performs a vacuum. And what it does is it takes deleted information that's in there that it no longer thinks it needs for the system files, and it vacuums it out, and it basically takes it out to the curb, and then it goes away. So to answer your question, I did attempt to look for the source for this, but there's none of that data remains in the device or in the databases at all. All I have is these, what I referred to previously as orphaned images.
Or ghost.
Ghosts.
Yeah.
Yes.
No, and I understand that.
Okay.
My question is, there are other things you can do outside of that. Obviously, that's your first one, right? You
Right.
try to go straight to the source. For whatever reason, it's not there.
Okay.
But there are other things you can do to see if you can locate whether they're tied together or where they could have gone, correct?
Correct.
So you indicated that at a minimum, this is on the mobile messaging system, right?
Yes.
It says mobile SMS, correct?
Yes.
So you know that at one point it was sent or received to somebody from Miss Richins' phone.
Yes.
Okay, so you have contacts in her phone, correct?
I do.
And if you had call detail records, for example, or just in her log, or any number of things, right?
Right.
You can go to those and see if the individual on the other end maybe did still have that message, correct?
Potentially.
Yeah, potentially. Now, you didn't do that in this case.
Are we talking physically contacting these individuals and?
Absolutely.
Okay, yeah. So I agree with that statement.
Okay. That you didn't do it.
That I didn't do it.
Okay.
But I would also add to that my role in this case is as an analyst, and I provide the information, and then any following it, any update or a follow-up investigation is
100%.
Yeah.
Yeah, I mean, I imagine that when you were asked to pull those images on that day, I imagine you explained all of this to the prosecution.
I did, yeah.
Right?
Yeah.
And you explained to them that, hey, you know what? These did pop up.
Yep.
39 of these.
And to your point and your question, I did go through call detail records. I did go through those types of things to see if there was a corresponding communication that would be contained in the call detail records that matches this.
Absolutely. And you did this because that is your job.
Correct.
Right? You're trying to say, hey, I have this orphan ghost.png. I'm going to try to find its home.
Yes.
Right?
Yes.
And hey, prosecution, I know you're going to use this, just so you know, I can't tell you who received it. Correct?
Correct.
I can't tell you who sent it.
Correct.
I can't tell you if it was viewed by Ms. Richins.
Correct.
Correct?
Correct.
But I can tell you that at that time and date, the system in her phone, as you said, registered it.
Correct.
Now, for example, if we were to find out that the image there, right, of the home, okay, if we were to find that other recipient, right,
okay,
and in that recipient's cell phone, it had the day prior, okay, so March 3rd,
okay,
say around 5 o'clock, okay,
okay,
and that individual sent the image, okay,
okay,
and then Ms. Richins opened her text message with that home there, okay, and maybe those GIFs or those .png, those thumbnails were attached. It could have been that the computer registered as it accessed it as it was opening up, correct?
Correct, because it would create a thumbnail.
Correct.
Yes.
Now, like you said, we don't know that, right?
Correct, we don't.
Okay. Now, I'd like to move on to the web searches.
Okay.
Okay?
Yes.
A lot of those web searches, as we saw, have no dates.
There it is.
Correct.
Right?
Yes.
And we do see some of them when they were searched, correct?
Yes.
Okay. Are you familiar with, I think it's called like lifestyle analysis?
No.
Okay. Did you perform any searches around the time on those that you can see on the web searches, that you can see the date that they were searched? Okay. Did you do any searches on Google or any validation to see what, if anything, was relevant to what was being pulled up?
No, like, did I perform the searches myself? And
Not the searches. So, for example, are you familiar with a certain Real Housewife in Salt Lake City?
Recently?
Okay, here we
in
go.
April 2022?
Oh,
Here we
no.
go.
Okay. Are you aware of somebody maybe being sentenced around that time?
No.
Okay. And now that would provide context to you, correct?
I could.
Yeah. Because right now, just as we see the searches, we don't know why that would be a search, correct?
I don't know content or can't speculate on anything.
You can't speculate.
No.
You shouldn't speculate.
No.
You also can't tell me, with the information that you have, who actually did the search.
Correct.
Right? It was done on the phone.
It was done on the device.
You could tell us the location of the phone, possibly, when those searches were done.
Correct.
You could tell us possibly the Wi-Fi that it was connected to, if it was connected to one.
Correct.
Okay. But you can't tell us who searched it.
Correct.
Now, You can't tell us if we were at, if this happened on the 4th, let's go back to the GIF images, okay? On that day, at that time, are you aware, were you told that there were other people in that home?
I'm aware of that.
You are aware of that?
Yes.
Okay, and so did you reach out to those, or I guess that's not your job. You could not tell us who opened that phone at that time, correct?
Correct.
Okay. Now, I do want to talk to you about something you just brought up.
Could have been the kids. Oh, my goodness.
You said, oh, the Wi-Fi.
Yeah.
You said not necessarily because it could be an iMessage, right?
Correct.
Was one option, and then the other one was that it was connected or sent through Wi-Fi.
Yeah, the file path on here indicates that it is a mobile SMS, which went through iMessage, and iMessage, iPhone to iPhone, typically will not hit a carrier, so it won't be in a call detail record.
Right. But that also is helpful to you, right? Because you're able to see, of all the people that she could have possibly contacted that day, you could then narrow it to like who has an iPhone.
Correct.
Okay.
Good. Half the
And
population
so
of the
because
world.
of the communication, and correct me if I'm wrong, I'm guessing here, between iPhone and iPhone, it's a different connection, correct? It makes it easier to communicate?
It's a typical Wi-Fi connection, so it's not a different connection.
Okay.
It's just a different system, or it's the same, they're on the same system. It goes through Apple servers versus the carrier.
So for example, can we pull up the Mr. Richins mobile activity on the night of March 3rd? Do you recall that state's exhibit where you laid out a graph of all the text messages that were sent from Mr. Richins to a Pedro Sonora?
Yes.
Right?
Yes.
I think it's up on your screen now.
Yes.
Okay. When we were talking about this, one of the last questions was about the text from Raul
They're
at 10:18.
talking about this one right here.
Okay.
And I believe Ms. Shervanak asked if it had been read, or if you could tell if it had been read, and you answered it very curiously, which is, I'm left to wonder, I just want clarification, whether or not you could actually tell if it was read, or whether there just wasn't enough data to determine whether it had been read.
I didn't see any, I don't remember.
Okay.
I'm sorry, I just don't remember the data
No,
line
and that's why I'm
specifically.
following up.
Yep.
That's why I'm following
Yep.
up.
There's no response. The indication was that it was not read.
Okay.
Yeah.
Now, here, we see all these text messages, correct?
Yes.
And we just talked about the iMessage that you just discussed. That
Yes.
sometimes that won't register on call detail records, for example, right?
Correct.
Now, that's different than this, right?
That is different than this.
Okay. You would expect an iMessage to show up here?
Yes, because this is from the phone's timeline itself.
Correct.
These are system file.
Correct. Just want to make sure. Could we take that one down, please? Thank you. Okay, so the movement of the iPhone. Let's start with Eric's.
Okay.
You had indicated that you had done how did you phrase it? You had actually compared it. It said you had done some sort of analysis with his overall use in terms of his activity on his watch, right?
Yes.
And that those 87 minutes, that gap, was off, I guess.
I don't think I said it was off.
What were your
I
words?
said it was atypical.
Atypical?
Yes.
Okay. Now, can you please walk us through what exactly you did to get to that conclusion?
Oh, so those are spot checks. Those are looking at random locations within his activity. I did not take the totality of his activity and compare it day to day to one another. Those were spot checks and looking at the device patterns in his phone to see if there was large types of movement. Now, there are sometimes large spaces of inactivity, but not in this context.
So what spot checks did you do?
Just periodically throughout the throughout the timeline, through that activity timeline, just to look at and see if his activity indicates that his device stays in motion, and to what extent day to day.
Over how many days?
Oh, God, I probably looked at maybe 20 days or so, just random days.
And how did you log that?
I didn't report it, I just made a mental note of it.
Just a mental note?
Yes, yes, sir.
Okay. So what was the largest deviation?
I don't know that, sir.
What was the smallest deviation?
I don't know.
How did you come up to the fact that it was atypical?
Well, it's, like I said, in context, right? So there's communications about, with presumably Ms. Richins on the device, and
Wait,
there is...
Mr. Richins.
I'm sorry, Mr. Richins on the device with Ms. Richins, right? And so there was a...
So right now, just so you're clear, we're talking about the physical activity.
Oh, yeah, okay, yeah,
Yeah.
I'm sorry. Yeah, physical activity.
Yeah.
Yeah, but in conjunction with that, there are text messages, there are other things going on around this time, indicating in the other exhibits, I don't know if we published them, but there's some discussion about what Mr. Richins was doing that day around
Sure, so like this
11
one,
a.m.
so this one specifically, on February 14th, 2022.
Yes.
It was, you indicate that it was, that the gap was atypical.
Yes, and maybe I didn't put that in good context.
Sure, put it in context.
But in
now.
context with what was going on at the time, it is not typical, based on what I looked at, for Mr. Richins to like lay down and take a nap, for instance, in the middle of the day.
So you could tell that he took a nap from this?
I cannot, but he indicated he was going to in the text. That's what I'm talking about in context.
Okay, so there's a bit of confirmation bias there, you would agree?
I would agree with that, and there's probably a little speculation there on that. The thing with device activity is you only know if the device is moving or not.
Right, there is a bit of speculation, like you said, and we shouldn't do that.
Probably not.
Let's talk about...
Did he just crack his knuckles?
Let's talk about the activity sensor data, okay? Not in context of what was registered.
Okay.
But in the context of you as an analyst, okay?
Okay.
Now, we talked about how what you do is digital forensics.
Yes.
And that's considered a forensic science.
Okay.
Yes. Do you disagree with that?
Yes, it is.
It is?
Yes.
Okay. And part of that field, right, is what we, I guess, grew up knowing as the scientific method, right?
Yes.
And so, for example, here we identify a phone, an electronic device, okay? And then we go from identifying that to preserving it.
Yes.
Right?
Yes.
And we either put in a Faraday bag or we plug it in and we make sure that the hash values and the hex code and everything matches.
Correct.
And we do that so that when you get the information, you know that it's the cleanest version possible, correct?
Correct.
Okay. And then once we preserve it, we then collect the information, which would be the extraction.
Yes.
Right? And then we examine it. Okay.
Yes.
And then we get into the analysis.
Yes.
Okay. So we examined it, and I'm going to go off of the activity sensors. Okay. Activity monitors.
Yeah.
So we identified it, we collected it, we examined it. Now let's talk about the analysis of it.
Okay.
Okay. Tell us what you did to validate the information about the activity sensor data. And we'll start specifically with the distance traveled. And this could be for either Mr. Richins or Miss Richins' phone, okay?
In general?
Yeah, what did you do in this case for either Mr. Richins or Miss Richins, okay, to validate the information that was presented to you in Celebrite regarding traveled distance, or distance traveled?
So
the distance traveled is just reported by the device based on the sensors that are contained within the device.
Correct.
Yeah.
So then what did you do to validate that that information was correct?
I'm not sure I understand the question.
Okay.
I did nothing to validate that information, like outside of that.
Okay, so for example, that information that was there, it indicates, let's pull up Miss Richins if we wouldn't mind. The state's exhibit where it shows, yeah, this one right here.
Okay.
Okay. So, can we publish this one, Judge? It's been admitted. So let's look at that 3:08:10 a.m.
You need to find something that's completely
Now, the
invalid.
74.14 meters, that comes straight from the extraction report, correct?
Correct.
Okay. And the 243 feet, I imagine that's something that you converted?
Yes.
Okay. And using what?
Calculator.
A Google conversion.
Google conversion.
Yeah.
Okay. And in this device travels, we know that it was 74.14 meters that was registered on the device.
Correct.
Okay. Now, what kind of iPhone was this?
I believe it was an iPhone 12.
Okay. And do you recall what iOS system it had?
I do not.
Okay. Now, did you, for example, going back to, so I can explain myself, did you grab your phone, a phone, and measure the distance from point X to point Y, put the phone in your pocket, walk over there, knowing the distance, walk back, plug in the phone, and see whether the Celebrite data that you received for what you just did in that controlled environment matched what was being produced?
No.
Okay. Did you purchase or have access to the iPhone make and model of Ms. Richins?
No.
On either of her phones that she had?
No.
Did you have access to Mr. Richins' iPhone make or model?
No.
Okay. And you did not do any tests, correct?
Correct.
So these numbers right here that we're seeing, you are speculating that is correct.
I'm not speculating. I'm relying on the data being correct inside the device.
But you have no way of knowing that.
Well, I mean, the examples you're giving are not 100%, wouldn't 100% verify this anyway, I don't think. I think you would have to use the exact device under the exact conditions.
Yeah.
In any way, for one.
Yeah, so let's go with that. So
and two, and which I didn't do. Which I didn't do.
Real quick, go on. So let's be clear. We understand you didn't do it. You did have access or could gain access to the environment, correct?
I could.
Okay,
Yes.
so then let's go from there. There are body cams in this case. Were you aware of that?
Yes.
Okay. Have you been to the Richins home?
No.
Okay. Have you seen those body cams?
I've seen some images of the body cams. Yeah.
Okay. Have you seen videos of the body cams?
Very few.
Okay. Do you recall a video where one of Miss Richins' phones is handed from one of the EMS to an officer, and then the officer walks over all the way to where Miss Richins is to provide her the phone?
No.
Okay. Had you been aware of that, or had that, rather, I'll be fair to you, had that been told to you by the prosecutors or law enforcement? Having that controlled environment, having this data, having access to the same phone, downloading the same iOS, could you have run a test to see if it was similar? And specifically referring to the 41 meters that's indicated there.
I could.
Okay.
But I mean, your statement just actually opened up why there's a device movement later on.
My questions sometimes tend to do that. Okay, so now let's talk about even the phone unlock lock. Okay. That seems pretty intuitive.
Yeah, the locking.
The locking and unlocking.
Yes. Yes.
So for example, when we look at the 319, I'm sorry, could we go back to the other one? I don't know if it was me. Thank you. At 3:19:39 at the bottom, phone unlocked 3 seconds?
Mm-hmm.
So it was unlocked 3 seconds. Does that mean it was locked at 3 seconds?
Yes.
Okay. And then, to be honest, this is just out of curiosity. Why don't we show an unlock before the 3:21?
Oh, no, because that 3-night, I don't know.
Sometimes just things happen, right?
I don't know.
Yeah. Okay, we could take that one down.
Someone was asking what the elevation of the courthouse is. It's just under 6,000 feet, about 5,800 feet. Summit County.
Going back to the web searches, okay, just briefly. This was all after, to your knowledge, I imagine you're aware that this was all after, all these searches were done after Miss Richins knew she was under investigation, correct?
Yes.
Okay. And I imagine but at that point, and if not, you probably have been made aware of it now, and we've all seen, during that January to March timeframe that you mentioned that there was a massive deletions between in her phone, correct? Do you remember that?
Yes.
As well as Miss Lauber's phone?
Yes.
You know that they were purchasing oxys, correct?
Objection, Your Honor. Lack of foundation.
Are you aware of what Miss Richins was doing during that time, either then or now?
Yes.
Okay. Now, you're a former law enforcement officer?
Yes.
Okay. Do you ever deal in narcotics?
No.
Okay. You're aware of them?
I am.
Okay. You're aware of purchases?
I am.
You're aware of the criminal mind, perhaps?
I am.
And you're aware that most individuals dealing in drugs might want to delete their information?
Yes.
And like you said, context matters, right?
Context does matter.
Bear with me.
He did ask him if this former officer, has ever dealt drugs. Bold move, Mr. Defense. Do you ever deal in narcotics?
Are you familiar with Bayesian inferences?
No.
Okay. Or probability statements?
No.
Mr. Ramos is trying to prove that we have a Timu expert on the stand.
I promise. Just want to make sure. Oh, can we pull up the call record for Miss Richins? I think it was the 101, 110-minute one, please.
That was to Miss Lauber, if I remember correctly. There was a short one for 3 minutes, then a long one for 110.
I do, yes, sir.
Okay. To be honest, I don't know why you were asked the questions. But this was in March. Could you zoom that in?
Sorry,
Yeah.
those.
No, I know,
yeah,
I know.
Those things are.
Zoom it in when you find it. Please.
Can you show us as well?
Oh, don't worry about it. It's fine. You remember what we're discussing, right?
I think I do, yes.
Yeah. If you can find the date, that'd be great. I believe it was March 4th or 8th.
And, Your Honor, this exhibit on the screen is not March.
Oh, it's February. This says February 11th. It's 3-6, whatever.
Oh, okay, perfect. Thank you.
We're on March 1st.
Is it March 2nd?
So let's be clear for the record. The jury can't see what you and the witness.
No, we understand. I'm just, I want to make sure that Katie finds it first.
Okay.
And then we'll.
Let me know when you're ready.
Is that it? Okay.
Yeah.
Yeah, that's it. Yes, if we could publish it, and we could see the 101 minutes.
Mm-hmm.
Now, the date is March 2nd, correct?
Correct.
And you indicated that you reached out and you found out that that was the IRS?
Yeah, I had Google search.
She was on hold the whole time.
I know the number.
Yeah. I was gonna.
It ends in 1040. I mean, it's.
Well, and it's a month before tax season.
It's the code for your tax.
So context-wise,
okay,
not unusual, right?
Yeah. Not unusual.
Yeah. We could take that down.
It ends in 1040. 1040 EZ.
I do want to make sure you...
Dr. Bullbutter, 28 months, OG.
2020. When were you brought on?
Retained. I was retained in May of 2023.
May of 2023.
Yes, sir.
Now, you indicated that Verizon holds locations only for 12 months.
Correct.
Now, Ms. Richins' phone was seized on April 12th, correct?
I
I'm sorry,
think
April 2022.
Yeah. Yeah, April 13th, I think. Yeah,
Okay.
of 2022.
Of 2022.
Correct.
Now, so by the time you had come on, that information was no longer available.
The records were still available, but records with location data were not.
Correct.
Tower data.
Correct.
Yes.
Okay. And to your knowledge, that's never been obtained, correct?
Correct.
Okay. We went through a lot of those PowerPoints indicating where Ms. Lauber
Yes.
was, and the communication she had, I think, with Kouri on the right-hand side, and
Yes.
then kind of following.
Yes.
I think you made it clear. Those aren't their actual GPS locations, correct?
Correct.
Okay, those are cell towers.
Those are the tower locations, yes.
Right. So every time that the jury sees that little image going with Mr. Crozier,
Right.
those are all cell towers.
Right. You're seeing the tower that that device is communicating with.
Correct.
At that time.
And so there was a time during your direct that you indicated that I think it was Miss Lauber was near the Richins' home.
Yes.
Do you remember that?
Yes.
To be clear, it's not that she was there.
Her device was.
Her device was connected to a cell tower.
Yes.
Okay. Now, with all this information that you have, the call details records, the cell tower information, the Carmen's phone, right? All of that, were you ever able to see, or were you asked, whether she went to 75 East, 100 North in Midway?
I believe I was asked to look at that.
Okay, and did you find anything?
It's the data is not that specific.
Okay.
It's not GPS location, it's tower location.
Right,
So,
right. Okay, we talked about those. Okay, I think I'm almost done. I think I am done.
I think I am done.
Two things. Biometric data.
Okay.
Let's go back to the activity sensor data. Did you go into anywhere in the extraction to locate the height Miss Richins put in her phone?
I don't recall seeing that.
The, whether her weight?
I don't recall seeing that either.
Did she lie to her phone?
I don't recall seeing that.
Did you do that or recall seeing that in Mr. Richins?
No.
Okay.
I don't think I've ever told my phone that.
These SMS previews that we had been discussing,
Yes.
are you aware of the different settings that one can do on their phone to either show a preview or not show a preview?
No.
You're not familiar with those?
I don't think so.
Okay. Do you have an iPhone?
I don't.
Okay. We disagree on a lot of things then. Fair. So you wouldn't have done anything there to check, or did you do anything to check her settings?
I did not.
Okay. So you don't know if on her settings in her iPhone there was an automatic play previews?
No.
Okay.
Imagine you could probably find that setting somewhere in the extraction if you needed
One second. May I have the white noise, Judge?
He asks for the white noise as they huddle. Are we done? It is about time. It's 4:35 in Summit County, Utah right now, which is which is an acceptable ending time for this judge. Let's see if they're going to finish with a little. I'm not sure what the state would need in redirect. Might ask a couple more questions. Didn't do anything to take the sting out of the searches? No. And he left so much on the table. He was going to talk about the scientific method, and then he never went there. He just sort of skipped ahead. Sort of just bounced around. This expert looks like he did very little under this line of questioning to validate the data. He just sort of put together PowerPoints of the sensational bits. But honestly, that's probably what he was hired to do. He wasn't hired to check and see if iOS is actually accurately tracking steps and things like that. They're just saying this is what it recorded.
Okay. For clarification purposes, okay? Because as I was talking about the web searches, I did not specify, and I want to make sure we get it clear. Those came from the blue phone.
Correct.
Okay. So those were after the April 13th, April 12th, when the white phone was seized, correct?
Correct.
After Ms. Richins obviously had been under investigation.
Correct.
Correct. After her, I'm not sure if you're aware, after her home was searched.
I don't know anything about that.
Don't know about that. Okay, but it was on the blue phone.
Yes.
None of these web searches were on the other phones, correct?
Correct.
That's all I have. Thanks so much. Appreciate you.
Yeah.
That's all he needed to get up and say. That would have helped a
Ms.
ton.
Sherbanek, within the scope of cross.
Sorry. A lot of sticky notes.
A few things I want to follow up with you on. We talked a little bit about CDR data and Wi-Fi, maybe why things wouldn't show up on Wi-Fi.
Sure.
What type of messaging can happen over Wi-Fi?
Most app messaging happens over Wi-Fi. So third-party apps like WhatsApp, Kik, Signal, those types of apps. But also, again, iMessage.
And so
Snapchat.
when talking about those 3 image files located on Ms. Richins' phone from March 4th, 2022 at 8:29 a.m., we don't know all of the information about those because it was deleted.
Correct.
If it hadn't been deleted, we'd know more.
We might.
Talking about the web searches on the blue phone, when you looked through and analyzed that blue phone, nothing indicated to you that that blue phone was being used by someone else.
Correct.
I want to talk about Exhibit 3-14D. And this is the device, Scott, if we could put that one up.
One moment, please. The witness has it. Do you want to publish it?
Please.
Okay. Go ahead.
Now, you made this exhibit in conjunction with the context of what was happening during this time frame. Is that correct?
Correct.
Meaning that you looked at messages between Kouri Richins and Eric Richins during this time frame.
Yes.
And in those messages, Kouri Richins was telling Eric Richins to go take a nap.
Yes.
And based on what you've created with this exhibit, does this movement in context indicate to you that during this time frame, Mr. Richins could have been laying down or
Yes.
not moving?
Yes.
I want to talk about this activity sensor data. That data is proprietary to Apple.
Yes.
And tell me if I'm wrong, but Apple probably puts a lot of money into making that data.
I'm sure they do.
They want it to be correct for
Yes.
their users,
Yes,
and they would want it to be accurate for their users,
yes,
because their users want that activity data to reflect what they're actually doing.
yes.
Have you looked at activity data in other phone downloads that you've analyzed?
Yes.
And looking at phone activity data for other hundreds, maybe thousands of phones that you've analyzed, have you been able to tell if that data can be checked in other cases? Meaning that if somebody said, hey, I went for a 1 mile walk today, giving you a hypothetical, and then you could look at their phone and say that they went for a 1 mile walk. Have you been able to look at that type of data in other phones and verify that it reports in the way you would expect?
Are you asking about corroborating witness statements based on their activity in their devices?
Right.
Yes.
That activity data in other cases when you've analyzed it has been accurate and corroborated by other information?
In my experience, yes.
Just a moment.
I think Mr. Ramos is going to get up
That's
and
all
ask
I've got
one
for
more
you, sir.
question.
Thank you.
Thank you.
Mr. Ramos, within the scope of redirect?
Yes, of course. Thank
Everyone
you.
wants the last bite at the apple. It's now 6:42.
You indicated
Eastern,
that.
4:42 Mountain.
Oh, you indicated that the Ms. Sherbanek was talking about the information that was deleted.
Yes.
Regarding those thumbnails, GIFs, correct?
Yes.
Certainly, it would have been better for all of us.
It would have.
Does that file path and the information tell you who deleted it?
No.
And as you explained with the garbage collection, it could have been that way, correct?
It would have to be, it would have, if it wasn't deleted from the device, it would not have ended up there. There would be a remnant of it.
Right.
Yeah, it would be a data line.
Okay. Now,
so Kouri,
you were also asked about that you did not investigate or you don't have any reason to believe that anybody else had the blue iPhone. Do you recall that question?
Yes.
And you said that no.
Yes.
How do you come to that conclusion?
The big thing for me is there is a text in that phone from that device to Mr. Grossman in which the defendant indicates that.
So, to be clear.
Yes.
I'm not saying that the phone wasn't Miss Richins.
Right.
Right.
Yeah.
My question is.
Okay. Well, I'm trying to answer it.
Yeah. So I'll clarify my question to make sure I'm asking it right.
All right.
Is your testimony that there was nobody else who had access to that phone at all?
I don't know that.
Okay. That's my question.
He doesn't want that. Don't let the witness just bring up some random text.
You were asked about Apple software and proprietary software, and did you attempt to get information from anywhere else, whether it's Apple, whether it's another peer, whether it's another case, where you can get the information that you have in these extractions to validate it?
I kind of don't understand that question.
Sure, I'll rephrase.
Okay, yeah.
Yeah. So I understand that you don't work for Apple.
No, I don't.
That you don't know how it works. That you don't know how the activity sensor data is logged, correct?
I don't know what their programming looks like.
Correct.
Yeah.
Okay. Do you make any efforts in this case with this information to try to validate that the information you had was up to Apple standards?
No.
You indicated that you've been able to rely on other cases before. How many cases?
At least 100.
And so in those cases with activity sensor data, in those you did test?
Okay. So analyze data in phones, at least 100 phones. There have probably been, there have probably been a dozen or so cases where I've had to corroborate
like witness statements and suspect statements, that type of thing, against their phones. And I have not found any inaccuracies.
I misunderstood. You, in those cases, corroborated the data that you received, but you did not run tests to make sure that the data you had was accurate.
Not physical tests, no, sir.
Correct. Okay.
Yeah.
That's all I have, Judge. Thank you. Thank you.
Thank you.
I have one question. You started to describe how you knew that no one else was using Kouri Richins' blue phone.
Yes.
There was a text message that indicated to you how you know that.
Yes.
How did that message indicate it to you?
Not word for word or verbatim.
Summarize the message.
The message summary was a text from the new number, the 9592 number, which is the blue phone number, to Josh Grossman's phone. And Ms. Richins indicated to Mr. Grossman in that text that she had activated one of, I believe it was her mom's phones, and she would be using that now, so, to that effect.
So she told him, this is the phone I'm using to contact you now.
Yes.
That's all my question.
May we release this witness, counsel?
Yes.
Subject to rebuttal if we need him.
Understood.
If we cannot release him from the subpoena.
You are still subject to subpoena, so that means you can't, well, he's an expert, so the exclusionary rule does not apply to him, correct, Mr. Ramos? Okay. Maybe we'll see you in the future. You're free to go today.
All right, thank you,
for
sir.
your time.
Thank you, I appreciate it.
You just have to stick around.
Now it's a good time to recess for the day, Ms. Shervnek, yes?
Yes, sure.
Mr. Ramos? Very well. Ladies and gentlemen, we are going to recess until 8:30 tomorrow morning. As always, please affirmatively avoid talking about or listening to anything about this case. Avoid any person that's trying to talk to you about the case. Please do not read, watch, or listen to any report about the case at all. No online or other research about the case. Please travel safely. Enjoy your evening. Please rise for the jury.
That was a pretty fun day. That was pretty cool. Don't think we have any pending issues to sort out, so I think we're done for the day and be able to start again at 8:30 tomorrow.
Counsel, have a seat, please.
See what's up.
Ms. Shervnek, Mr. Bloodworth, anything else on the record today?
No, Your Honor.
Ms. Lewis, Ms. Nestor, Mr. Ramos?
Do we want to address the juror issue?
What I'd propose, and let me just say it out loud, and then you can tell me whether you have any objection to this, is to let all of you consider whether you want to have the court voir dire that witness regarding his prior interactions with
the juror or the witness?
Crosswhite.
So the juror, he meant juror.
Tomorrow morning, and if so, we can do that. Or if you'd prefer not to do that. But give that some thought overnight. We can pick it up first thing in the morning. Any objection?
No, sir.
Mr. Bloodworth?
No objection.
Okay. We'll be in recess until tomorrow morning. Please travel safe.
There we go. So tomorrow morning we'll have the juror issue. Once again, we start the day trying to solve a problem. The juror issue was he sat down to listen to witnesses and somebody walked in. He's like, hey, I know that person by a different name. I've done business with that lady. She apparently got married or changed her name at some point. And so he sent a note to the judge. Judge, I know this person. We've done business a time or two. And that's where it's at right now. The judge leaving it in the defense and the prosecutor's court. I would say in defense in this case because the prosecutor doesn't have an issue. Hey, Nicole's trying to call me to teach me about hearsay.
It's Nicole.
Hang on 1 second. Nicole, hearsay class is in session. I'm taking notes.
Yes, I got to do this.
Straighten
I
me
got to
out.
do this really quick because
Yeah.
my son has a symphony tonight that he's in. Okay.
Awesome.
Yeah, he's a clarinet player. So hearsay is an out-of-court statement being offered for the truth of the matter asserted. So if an out-of-court statement is not being offered for the truth of the matter asserted, it is non-hearsay, not an exception.
Okay, so
That's
it has
what
to
I
be for
needed
the
to
truth of
correct
the
them.
matter asserted. I just like to think it's
Correct.
just any out-of-court statement.
Nope, it's an out-of-court statement being offered for the truth. If it's an out-of-court statement being offered for a different reason, then it is not hearsay. If you want to get hearsay in for its truth, then it has to fall within one of the exceptions. Does that make sense?
Yeah. And the exceptions, there are many exceptions.
There's a lot of
excited
exceptions.
utterance and,
Yeah, I did a real short video, and I had like 30 minutes, but yeah, there's a ton of exceptions, and but that's it in a nutshell. So if it's not offered for the truth, it is non-hearsay, not an exception. And if you want to offer it for the truth, you need an exception.
Awesome. Nicole Goodman from Goodman
There you
Law Firm, my standby lawyer, called you when I needed
Hearsay
a little
in 2
advice.
seconds.
Okay. Thank you very much. I'll have to check your channel out, watch the video again, take better notes, and then do better next time. Thank you, Nicole. It's always great talking to you.
Have a good one.
Appreciate you. We'll see
Bye.
you. Bye. All right. I just missed a call from Selena. Hang on just 1 second. Let me see if we can call. She can call me back. Hold, please. Let's check in with Selena. There she is.
Call from
Selena.
Hey, Selena. Sorry about that. How are you doing?
Well, it's snowing.
Finally.
Yeah, we need it, but I don't want to drive home in it.
I know you've got to head down that canyon. That's terrible.
Yeah.
Please be careful.
It's okay. I'll be fine. Hey, and I also took one for the team today too because I couldn't read any of the text or Google searches. None.
I tried to read as many of them as I could. They went pretty fast and they were blurry as well.
Yeah, I know. So it was hard for you too.
Yeah,
okay.
But we got most of them. Basically, there's a lot about how do I delete my phone? Can I delete my phone when I don't have it? Can I reset my password when I don't have the phone? Why is the FBI involved? And how do I know if you're under investigation by the FBI? Things like that.
Oh, wow.
They were bad. They were really bad. Luxury prisons for the rich. We had some bad searches, but in our defense, we didn't have many timestamps, and all of them were on the blue phone.
Mr. Ramos put some reasonable doubt back in to all of that. And sitting there, I was like, okay, and I have to bring up one thing real quick because I'm not going to talk very long because I got to get home. But there is one juror that I'm going to keep my eye on. I don't know if it's the one that's going to be maybe dismissed tomorrow, but during those text message and Google search, blah, 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 they were all reading them, but one juror was looking away, looking out in the gallery, not paying attention. And then when Mr. Ramos come back up, he started writing notes.
Interesting.
So that is very interesting, right?
Huh.
I'm going to zero in on that.
Obviously, you can't, and we wouldn't want you to describe the
No,
the
I'm not going to divulge it. I can't do that, but I'm
you
just
would
telling
know,
you.
You would know tomorrow, possibly, if this is the juror that it gets questioned about.
Oh, I will.
About the relationship or the business relationship with one of the witnesses.
I will.
The defense has said this is a problem. But if you observe that from the gallery, the defense probably also observed it. They have people that watch the jury. And if that's the case and they think this is one of our jurors, we think he's on our side, then they won't want to dismiss him, right? Because they only need one.
Exactly.
So even if it is a problem, they want to keep him.
I can only wait until morning to see if it happens to be that juror or not.
That'll be interesting. It'll be interesting. I do think that if the defense at this point did press and say we need him dismissed because we did get hostile with that witness.
Right.
And he has an outside relationship. His relationship with her might be friendly or positive, and seeing us attack him might have made us be the bad guy in his mind. I think it would be right if they asked for him to be dismissed.
Well, and here's a great argument that somebody made that we don't know what kind, we need to do a voir dire to see what kind of relationship they had with her. Was it a good one? Was it a bad one?
Yeah.
Was in the real estate, did it go well? Did he not like, did they not like her? Because
How much
So
money?
that's
How much
kinda what-
money changed hands? I mean, was this like
Right,
did you
that's-
become rich off this 2
exactly.
deals? You know, then
So that's what
we
they're
can
going
go
to
full
ask
scope.
that's what I think they're going to do in the morning is ask those type of questions.
Yeah, it'll be interesting. So
And then make a decision.
and that means we get to start another day with some spiciness. And
Yeah, you called the afternoon too. Even though I couldn't read those, I could feel them. I could feel the vibes.
Yeah. Selena, thank you. I know how dangerous that canyon is driving
It
down.
is.
Please,
It's very
please be careful.
dangerous.
Please be careful.
I will. I am going to go super slow. I got my truck, so it's 4-wheel drive. So
I hope you don't have to use that though. I mean, the 4-wheel drive.
I hope I don't either. But I'm just saying, I can drive. I'm going to drive like an old granny, like I am, and I'll be good.
The
so.
right lane. The trucks go barreling down there sometimes. So be
Oh,
careful.
they do. They do. So what another day. This trial has not disappointed.
I know. It's incredible for the players. I think the lawyering is just next level. I think they're great.
The lawyering is off the charts. I'm loving it.
Even Miss Nestor just fighting for every tooth and nail when she's losing, and then reserving the right to come in hard and on the bias issue. Yeah.
Either lover or hater. If you needed an attorney,
she'd fight.
She'd be it.
She'd fight.
Oh,
for sure.
My goodness. We were talking about that. We're like, okay, now I really need to go to see Tyler Robinson's trial. Because she's his attorney, so. Yep. Anyway.
Selena, thank you very much.
Until
Wednesday,
I'm going to see what the weather looks like tomorrow. And I might come, I may not, but I will let you know.
All right. Thank you. You're amazing. Appreciate
All right.
you. Bye-bye.
Okay, bye. Bye.
All right, wonderful. We're gonna play some music. Selena will let us know tomorrow. If there's a lot of snow, I hope she doesn't go. It's super. I cannot begin to tell you this canyon, the way it's formed. The canyon between Salt Lake and Park City is extremely steep for a long grade, and then very curvy. And because of if it gets any snow, it just ices. It's like an ice sheet. And so you're just gathering speed for 1.5 miles before there's a sharp S turn with a reservoir off one side and, the cliff or a big ditch in the other. There are accidents almost every single snowstorm there. It's just super, super dangerous. So please, Selena, drive safely. All right, we're going to wrap things up. We've had a spicy day in court. Thank you for watching either here or on the Top Mark Media channel. I appreciate you very much. Do join us back tomorrow. We've got a lot of new friends here. Welcome. I'm glad you stuck around throughout this one. I saw you on the chart. It looked amazing. Please join us tomorrow because this trial has almost 5 more weeks left on the books, and it's just getting better and better. Tonight when you go home, please hug the people you love, smile at someone, make their day just a little bit better, and please stay safe till we go live again tomorrow morning, 8:30 Mountain Time, 10:30 Eastern. You can do the math on the rest of them. I think we'll actually start 10:15. They're going to start at 10:30. That gives us 15 minutes to do this. I've got to try to fix the soundbite so you can get 110 back because everyone's wanting that soundbite. I've got some work to do on my end, but you guys have a good one. Appreciate y'all. It wouldn't be possible without you. This is the best place on the internet to watch true crime. It's because of you all. You guys have a good night. We'll see you.